looking at an aerial shot of the area around the United States Supreme Court, where in just about an hour, the court will entertain arguments in the case of George W. Bush versus the Palm Beach County Board of Canvassers. There's kind of a circus atmosphere here in a sense. It's like the Macy's Day Parade of American jurisprudence. You have protesters, you have lawyers, you have members of Congress, you have celebrities. And here to give us a little bit of a flavor of what's going on right in front of the court is our own Rita Cosby. Rita?
Hi, Tony. Well, it is certainly a dramatic time here at the U.S. Supreme Court as we get ready for oral arguments, which are set to get underway in less than an hour. As you can see behind me already, a sea of protesters has arrived here at the U.S. Supreme Court. Many of them started lining up as early as 4 o'clock this morning, so about 5 hours ago they started showing up. And indeed, there are protesters of all sorts, some who are against the death penalty, some who are pro-life advocates, and of course, many who are Gore and Bush supporters. In fact, on one side, they're basically separated in two parts. On one side, on the side right behind me, is just a slew of Gore supporters saying, what do we want? Every vote counts. That's what they're shouting. Then next to them and separated by 2 rows of police officers, we have a number of Bush supporters who say, who do we want? We want Bush. Gore is a sore loser. Get out of Cheney's house. And they're literally shouting at each other back and forth, again separated by 2 rows of police officers. In fact, a number of other officers are arriving here on the scene trying to make sure that the protests stay calm. They're expecting several thousand of them to arrive, possibly as many as 5,000 or 6,000 of them to arrive when oral arguments get underway. Now, in addition to this, inside the courthouse, inside the chambers, there are 400 seats. 129 of them are reserved for members of the press of all sorts from all over the world, many of them, of course, American members of the press. Now, in addition to this, there are also 75 seats for lawyers who are not participating in this case, but are admitted to practice before the High Court. They, of course, are observing these historic proceedings. And then the remaining 200 seats are for members of Congress, some VIPs, also guests of the court, and in addition to this, members of the public. Now, a lot of people from all over the country have been coming here to watch this historic proceeding. Indeed, I talked to a number of people, one of them an 85-year-old grandmother who flew down from New York City. She lined up as early as 5 a.m. yesterday to get a seat. We're told that 50 members of the public will get full-time seats. In other words, they'll be able to watch all 90 minutes of oral arguments. Then in addition to that, they will allow members of the public and others who've stood in line to come in and watch on a rotating basis. They'll get 3 minutes inside the chambers to watch the historic proceedings. And we will, of course, talk to many of them when they come out. Tony, back to you.
Now, Rita, there have been a number of celebrities, political and otherwise, making their way around here. Who have you seen?
Well, we saw Ted Olson came in. He, of course, will be arguing for the Bush camp. He is the lead attorney who has argued before this court more than a dozen times. We did see him come in. We saw a number of other political celebrities. John Ashcroft, who was, of course, the senator from Missouri who will be leaving, who lost to the deceased Governor Mel Carnahan. Also, we saw a number of other members of Congress coming in, and also a number of sort of celebrity types sort of walking around. Many people are intrigued by this. Also, a number of law professors and a number of law students. For them, this is a civics lesson, the best they could ever get.
All right, Rita, thank you so much. One law professor who's particularly interested in today's proceedings is Lawrence Tribe of Harvard Law School. He's going to be making the arguments. He's going to be doing the chief arguing on behalf of Al Gore. Now here to help us talk about exactly what we can expect when the court does begin its hearing at 10 a.m. Eastern Time is Steve Centani. Steve, let's first begin with kind of the order of battle. Who speaks for how long?
Well, we're going to get 35 minutes for each side to make their main argument. Ted Olson goes first. He's the attorney for George W. Bush. And as Rita just mentioned, he's argued before this court 13 times before, so he's back again. He'll get 35 minutes. Then there'll be 10 minutes each for the attorneys for the Secretary of State of Florida and for the Attorney General of Florida. We'll have Joseph Clark for Catherine Harris, the Secretary of State, and we'll also have Paul Hancock arguing for Bob Butterworth, the Attorney General. That'll be for the Gore side. Then we have the main argument for Al Gore. That'll be 35 minutes taken up by Lawrence Tribe. He's a very well-known constitutional scholar who's argued before this court 29 different times, so he too no stranger to the High Court. Now here's the way it'll start off. Chief Justice Rehnquist will announce which case it is. It's 00036, Bush versus the Palm Beach Canvassing Board, and then he'll begin to hear arguments. He'll call on the first attorney, and that is Ted Olson. Now, as soon as Ted Olson stands up and starts to make his argument, it's very likely that he'll be questioned by one of the justices very, very quickly. He really won't get a chance to make much of an argument. Most of his 35 minutes, if things go according to the way they usually go, will be taken up by questions and answers from the different justices. That'll be the same, of course, for Lawrence Tribe when he argues for Al Gore. Now, you can't read too much into the questions being asked by the justices, but they could give some clues as to what they're thinking about this case. The ones who are most likely to raise questions are Antonin Scalia. He's very vocal during arguments. The most silent, of course, is Clarence Thomas, who hardly ever asks any questions. Then the next we're going to hear from the court after Justice Rehnquist says that the case has been submitted is we'll hear their ruling, and we don't know exactly, Tony, when that's going to come. Usually the court takes weeks and months to come down with a decision. In this case, we think it'll be somewhat more rapid, possibly within a matter of days, possibly this weekend, but we expect it to be sometime next week.
Now, Steve, let's again march through the procedures. One of the things that will happen is Ted Olson doesn't have to use up his entire 35 minutes. He can, if he wants, save a little bit of time at the end to do a rebuttal for Lawrence Tribe.
That's
correct?
right. He can reserve some of his time for a rebuttal, and usually the court grants such a request. Yeah.
Now, when we saw the Florida Supreme Court entertaining arguments, they were kind of loosey-goosey with the time. I gather Chief Justice William Rehnquist is not that way.
Not that way at all. He runs a tight ship, and he sticks to the rules, and the rules are 90 minutes, and he wants to divide it equally, make sure each side gets exactly 45 minutes. He usually sticks by the clock. If it goes a minute or two over, that has happened, but not very often, and not much more than that.
And there have been some fabled instances where he's actually cut people off in mid-sentence saying time's up.
Yeah, like I said, he runs a tight ship. He'll say your time. He'll cut him off right in mid-sentence.
Procedurally, after the court hears the arguments, then the justices retire and they meet in conference. Right. Is it likely at that point they're already going to have a decision?
Well, there's no way to predict this case or any case, really. They could have made up their minds before they come in for oral arguments. Having read the briefs is sometimes considered the most important aspect of the case for the justices, and oral arguments is just gravy or just a way to reconfirm what the justices have already decided. But they will retire behind closed doors, make up their own minds, and that could take any amount of time whatsoever. They could even announce a ruling right after hearing the arguments. I don't think that's ever happened in this court before, but it does happen in many courts all the time. They'll announce an opinion, and they'll announce a ruling, and then say opinions to follow, written opinions to follow. That's very unlikely in this case.
Well, most people are speculating at least sometime early next week,
That's
given
right.
something of this magnitude. Now, as you mentioned, the justice has been looking through the briefs, and by the way, here's a stack of the briefs,
right.
And these are just the main briefs. These are not the friend of the court briefs or any of the others. They've been doing a lot of research, and they've been doing independent research of their own as well.
That's right. They like to be as apprised of the situation of any case that comes before them as possible. They do a lot of research. Their law clerks do most of the research. And in this case, it's hard not to know the facts of the case because they've been broadcast daily all across the country, every minute detail of every ballot being counted in Florida. So it's hard for them not to know all the facts of this case going into it.
All right, Steve Centani. Well, thanks for joining us. We are going to take a break. We will be back with more as we anticipate the Supreme Court's hearing in the case of George W. Bush versus Palm Beach County.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts.
Much more different, that is acting like a legislature, changing the law, literally changing the law of Florida in such a way that it actually creates a problem under federal law.
Both sides will cite statute and law and constitutions to argue the point as to whether the Florida Supreme Court was changing the law or interpreting the law when they extended the deadline for certification and allowed those recounts.
That's right. They are going to be citing all the things that lawyers, of course, rely on, which is statutes and opinions, although there are not a lot of relevant materials here. This is an area that actually is pretty new for the court. The court rarely, if ever, steps into a situation where it's going to second-guess really what went on in a state in terms of the state's interpretation of its own laws.
Clear outcomes or muddled outcomes as possibles?
Well, I think, of course, either is possible. I think the real problem here is that if the court doesn't issue a unanimous opinion, then I think the court's decision will be much more vulnerable to political attack. It'll look much more partisan. And even if the court comes up with a unanimous opinion, I don't think it's likely to bring closure to this. I think the problem is one side will lose, that side will attack the court's opinion as inconsistent with the rule of law.
Professor Gerhardt, Darren Kagan down here in Atlanta, I have a question for you today about logistics. 90 minutes for arguments today, a 50% increase in what the court usually allows for their arguments. How did they come to that decision, and is it because it is such a historic, important case?
Well, obviously, the court has the control over how much time it will allow people in terms of whether or not it will increase the usual amount of time. But I don't think it's that unusual for the court to increase the amount of time. It does happen, well, with some regularity. But I do think it is one signal, probably one relatively credible signal, that the court recognizes that this is not just the run-of-the-mill case. The implications of this case, the issues raised in it, are novel and they are serious.
And 50% increase seems like a lot relatively, and yet 90 minutes to decide something that is so important. When you look at other legal cases, it seems relatively short.
Well, that's true. And in fact, the great scheme of things, 90 minutes, although it should be good enough for a lawyer to put his case together concisely, is not that much time in terms of the history of the court. In fact, it used to be that lawyers would argue for days over a matter. In Buckley versus Vallejo, for instance, a great case about election law, that took more than a day. So the court, in fact, in the past has given a lot of time to litigants, lawyers who argue great issues, but today 90 minutes is, relatively speaking, for today's time, a good bit of time.
Michael, let me jump back in here. For those at home who may be taking out their scorecards and preparing to follow this thing, they may be hearing a fair bit about Title III, Section 5. Now, this regards laws enacted prior to the election. Right. In terms of determining who the electors will be. Both sides are gravitating to Title III, Section 5. Why?
Well, that's the relevant federal statute here. It's a 19th century statute that was passed in the aftermath of the very controversial 1876 election. The whole idea behind Section 5 is to try and set up a process for insulating a state's choice of its electors from scrutiny later in Congress. It's trying to protect the state's choice of electors from being second-guessed or overturned in Congress. The way in which to do that, the statute says, is that the law that governs the selection of the electors must be the same after Election Day as it was before Election Day.
On a scale of 1 to 10 on the holy cow meter, what's today?
I actually don't think it's as huge as a lot of people think. I would say probably it's a 3 or 4.
Oh, my goodness. We'll have to argue that one in the future, Darren. There you go. Take it away.
Well, the professor has certainly seen some incredible things if he only calls this a 3 or 4. To us here at CNN, we find it probably a 10 for us, and we encourage you to stay with us. Tune into CNN for special coverage of these oral arguments. The actual proceedings are set to begin, as we said, at the top of the next hour. After that, we will bring you audio of the arguments as soon as the court releases the tape. You can also watch or check out the historic proceedings by punching up CNN.com on the web, CNN.com.
We now break away from CNN USA's coverage of the disputed presidential vote. We'll return to it at the bottom of the hour, but for now, we bring you Asia Tonight. Coming up, violence subsides in the Middle East as Muslims...
Shots of the members of the Supreme Court. And if people may not have noticed, but the way it works is that the people sitting on the outer fringes are the newest appointees to the court, and as your seniority increases, you get to sit closer to the middle. And the guy in the very center, of course, is Chief Justice William Rehnquist. Right. Andrew, let's talk about the issues here. Again, the Bush team is making two arguments. They are saying that the Florida Supreme Court violated federal law in changing the deadline for counting ballots. It said that the state had to accept certified ballots up to December 5th, which was, of course, last Sunday. In addition, it says that it also violated Article 2 of the United States Constitution in that it changed the method of appointing electors. Let's first get your assessment of those arguments.
Okay, well, the problem with what the Florida Supreme Court did is it did more than interpret the Florida law. It actually changed deadlines, and that is the heart of the Bush argument, because federal law is clear. And the federal law was written by the Congress primarily to prevent certain southern states that were trying to disenfranchise African Americans from changing election laws after the election was over. that law is still on the books and applies to Florida just as it does to every state in the union. And that's what really has rankled the Gore people, that the Florida Supreme Court did more than interpret a statute. It changed a deadline. And by changing that deadline, it changed the manner in which the election is conducted. And that is prohibited by federal law. So if the Supreme Court decides that that is a violation of federal law, they'll invalidate what the Florida law did.
Okay.
Now, the other side... Go ahead, Tony.
Yeah, no, let me just paraphrase the other side. Now, the Gore team is saying, no, the Florida laws are ambiguous, and then, in fact, it's the responsibility of the Florida Supreme Court to interpret and get rid of these ambiguities. In addition, it says, even if the Florida Supreme Court went in and rewrote state law, that's not a matter of proper federal jurisdiction. It is a state matter, and the Supreme Court ought to butt out.
Well, that's correct. You have the irony of liberal Democrats saying to a fairly conservative court, states' rights principles, which the court calls federalism, is mandating that the federal court not get involved. And the other Gore argument that's being made is one that we're taught all the time in law school, and that is, it is the job of judges to interpret the law. And that act of interpreting is not called making the law, it's called reconciling different language between two different statutes. So it'll be very interesting to see how the Supreme Court looks at this. I am loath to try and predict it. I may have some feeling after we see how the questions go, but I can't predict it now, Tony.
Let me talk about a scenario that some people have been discussing, which is the court will simply wave this thing off and say, this is something that has to be resolved in Florida through political means, thereby throwing it to the Florida legislature. Is that a likely outcome in your opinion?
Yes, I think it is a likely outcome, and I'll tell you why. Because the Supreme Court has a history of not hearing cases that become moot by the time they hear them. Now, at the time Governor Bush filed this appeal, it looked as though the Supreme Court of Florida was just going to let those 3 counties in South Florida continue to count and count and count. Well, the counting finally ended, and Governor Bush was declared the winner. So actually, technically, the issue on which he based his appeal is no longer a valid live issue. It is moot. And the Supreme Court may very well say, this is not in our ballpark anymore. We're not going to rule on it. In which case, I think you'll see the Florida legislature move very quickly as the day the Supreme Court decision comes down.
Okay, Judge, I want to give people a sense of just how convoluted and complex this is by throwing you another curveball. Now, the response in the Bush team briefs are that this is still being contested in a number of places within Florida, and that by taking away some 600 votes from George W. Bush, that could ultimately affect the outcome, and therefore that's one of the reasons why the court should act now.
That is a very strong argument as to why it is not moot. Because if the Al Gore people only have 537 votes to overcome, as opposed to 930 votes to overcome, that will profoundly affect what goes on in Judge Saul's courtroom. So that's an argument why this Supreme Court should rule and should address the validity, the constitutional validity, under the federal Constitution, not under the Florida Constitution, of those counts which occurred during that week extension that they gave the canvassing boards to count.
Very quickly, the Gore team has also indicated that if the Florida legislature goes ahead and appoints electors, even though a slate has already been sent here to Washington, it will appeal that decision to the United States Supreme Court. The question is, will they cite federalism in that case as well?
Well, I don't think they'll get very far in doing that, because I think the U.S. Supreme Court will again want to wait and see what happens. This morning I spoke with a Florida state senator who informed, a Republican leader who informed me on the air on Fox, that the legislature will name the very same 25 electors that were named by Secretary Harris the other day. So there may not really be anything to dispute there.
Okay, Andrew Napolitano, thank you for joining us. We're going to take a break. On the other side, we're going to have John Gibson with an update on all the day's proceedings and a lot more right here on Fox News Channel.
For the first time on DVD, experience the entire first season of The X-Files.
They're here, aren't they?
With exclusive features, deleted scenes, and an all-new documentary. Own the ultimate DVD collector's edition of The X-Files.
him? He was such a jerk.
A complete jerk, but so cute.
So wrong.
Yeah, but
everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
Power. 24 hours, 7 days. The most powerful name in news brings you the world. Fox News Channel. The power to bring you the people and places. From mega markets to emerging nations. Reports that make a difference. Power to cover the events that shape the planet. The global forces changing your life. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news, Fox News Channel. We report, you decide.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced. Powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
見たかったものがここにある。エンターテインメントチャンネルといえばフォックスしかない。華麗なトリックの裏側を仮面のマジシャンがついに全て公開。破られたマジシャンの掟、謎に包まれたストーリー、真実を知るのは今。 X ファイル特別版モアシークレットファイル。あまりにも無力な人間、追跡、生死を分けた大暴風。生き残りをかけてかつてないバトルが繰り広げられるワールドレスリングフェデレーションスペシャルサバイバーシリーズ。救いを求める人を放ってはおけない危機一髪世界の救出劇。ニュース番組の裏側を描いたブロードキャストニュース。ドラマを超えた衝撃ツインピークス劇場版。マイケル・キートン主演のマシンガン・ジョニー。12月も話題作続々。フォックスムービー。感動と興奮がここにある。本物のエンターテイメントはいつもフォックスから。
I'm John Gibson in New York. Before we go back to Tony Snow, here's a quick look at the bigger picture, what's happening in the different venues where the presidential election may be decided. While we're all focused on the Supreme Court right now, there is action elsewhere. There's legal maneuvering in Florida state courts. Another ballot caravan is headed for state court in Tallahassee, and both candidates are making plans for possible administrations. The spotlight today is definitely on the U.S. Supreme Court, as we've been reporting. Oral arguments begin at 10 a.m. Eastern Time. No cameras in the courtroom, but stay with Fox News to hear the audio tapes of the hearing, which will be released immediately after the hearing. Back in Florida itself, the ballot battle is growing. Bush lawyers asked Circuit Court Judge N. Sanders Sauls to send another 1.25 million ballots from 3 counties. The judge has yet to consider the request. Al Gore's lawyers asked the Florida Supreme Court to order hand recounts started immediately. In a countermove, Bush's legal team filed a motion in the Circuit Court urging the judge to throw out Gore's contest of the election. They argue the real election dispute isn't between Bush and Gore, but between separate groups of state electors. And there are reports the Bush team plans to call 95 witnesses if the case goes to trial. Meantime, about 600,000 ballots from Miami-Dade County are being trucked to Saul's court in Tallahassee. Yesterday, about 500,000 ballots arrived from Palm Beach County. The Circuit Court will hold a hearing tomorrow on whether to order recounts. The Gore camp says it's tossing around names for possible cabinet posts should Al Gore eventually win the White House. Running mate Joe Lieberman wouldn't name any names, but he says a Gore administration would include Republicans and independents. Gore and Lieberman met with advisors yesterday, including their transition director, Roy Neal.
Sources say the group wants to create a grassroots panel of community leaders to advise Gore on building his administration. The Bush camp still holding down the fort in Texas. The governor is spending another day at his ranch near Crawford working on the transition. He was joined there yesterday by retired General Colin Powell and running mate Dick Cheney. Powell is expected to be offered the position of Secretary of State. Tomorrow, Bush plans to meet with House Speaker Denny Hastert and Senate Majority Leader Trent Lott. Another update later in the hour. Now more from the United States Supreme Court and Tony Snow.
Thank you, John. As John just mentioned, we have another one of these caravans making its way slowly from South Florida up to Tallahassee. Today we have slow white vehicles making their way up Interstate 95. And to give us a flavor of what's going on down there, Orlando Salinas now joins us. Orlando, will you set the scene for us?
I sure can, Tony. Good morning to you. You know those two rental trucks that you're speaking about? They've been rolling along towards Tallahassee for about 3 hours and 20 minutes now, give or take a couple of minutes. They left the Miami-Dade County government building right around 6 o'clock this morning. And I believe we have some pictures to show you as they were actually taking off. You got a couple of rental trucks, Tony, as you were speaking, about 12 to 15 feet long. You see the caravan right there. They left, they're rolling through I-95, then the Florida Turnpike, then I-10. Eventually, those two trucks will make their way to the Leon County Courthouse. From there, Tony, state employees will unload about 654,000 Miami-Dade ballots. They'll be unloading them into a guarded storage vault at the county courthouse. Now, those two trucks, by the time they reach Tallahassee, will have covered about 525 miles, give or take, of course, a couple of miles for pit stops that they're going to have to take. This morning, about a dozen people began moving 3 carts, packed them 4 stacks high, 82 boxes in all, we're told. And those boxes weighed about 55 pounds each. They really had a small army, Tony, of people picking these things up, dropping them inside the truck. It's one of those things that just has to happen. Again, the bottom line, Tony, they're shooting for about 5 o'clock today. That is what Judge Sanders Sauls wanted. And from the timetable that we see right now, they left early this morning. They should be able to make their deadline. Back to you, Tony.
All right, Orlando, thank you. Now, there is still a bit of a festive atmosphere, if you want to call it that, here in Washington at the Supreme Court, which is directly over my shoulder across the street. Rita Cosby is standing by with some protesters. Rita?
Hi, Tony. Well, as you can see, just a slew of protesters are behind me. Basically, several hundred have arrived, and many of them came as early as 4 and 5 o'clock this morning to get a good position. They can only stay here on the sidewalk. They're not allowed to go on the steps of the Supreme Court. And one of them here is Dave McIntosh. You're a Bush supporter, and you came all the way from New Jersey. How did you get here, first of all?
Came down on a bus. We left at 5 in the morning.
And what time did you arrive?
A couple minutes ago.
Now, why did you come here? Why did you think it was important to protest and put out your views here in front of the U.S. Supreme Court?
Well, I feel that basically, for the most part, the media is very much pro-Gore, and we needed to show our support for George Bush and for the election that was fairly and legally held throughout the country. We had a count in Florida. Bush was ahead. We had a recount in Florida, mandated by law, which is fine. That Bush also won. And to take certain counties that are Democrat strongholds, supposedly, and hand recount them, I don't think is fair. Plus, these ballots are supposed to be machine counted. They're not designed to be hand counted. That just opens up the door for all kinds of mischief and illegality and stuff behind the scenes that we don't need.
Now, what do you hope happens here today inside the chambers? You will not see inside, obviously. You'll hear the audio recordings later. But what do you hope happens inside the U.S. Supreme Court today?
Well, I hope that they rule that the Florida Supreme Court overstepped its bounds and, in effect, wrote new law by extending the date for the counts. Catherine Harrison was just going by the law in Florida, which she has the duty to do as the Secretary of State there. And I feel that the Florida Supreme Court overstepped its bounds and basically wrote new law. I hope that they rule that way. Excuse me.
Now, what are you hoping? What are you going to do if they vote in favor of Gore? If they rule in favor of Gore, a decision that is favorable to him, saying that the hand count should remain and that certification deadline should remain, the extension, what are you going to do? Go home and cry, or what happens next?
Bush still wins.
How do you figure that? What happens if it changes the whole rules and possibly the contest goes in his favor in Florida?
Well, first of all, the hand recounts of those counties has already been done, and Bush won.
Tell me what also you're shouting out here real quickly.
I'm not. I have a sore throat, so I'm not shouting anything.
Okay, great. Thank you.
You know what? I don't believe in the shouting. I believe in being very peaceful, and, we just pray that the Lord's will be done here, and that, you know, that our guy gets in.
Great. Thank you, Dave McIntosh. He does have a sign, by the way, even though he's not shouting, that says Gore Loserman. So obviously we know how he feels. Back to you, Tony.
All right, Rita, thank you so much. We're going to take a break. On the other side, we're going to give you a sense of who the players are in today's drama. And we'll also talk about the legal issues involved with our own Brian Wilson. Stay right here.
Stay there.
To see if the stock market, especially those tech stocks and the NASDAQ, can turn things around. We, of course, are following events in Washington, but keeping our eyes on the markets as well. And the opportunity to try a case before the 9 Supreme Court justices is arguably the high point of any attorney's legal career. We have a great opportunity here this morning, a chance to talk with 3 attorneys who have had that incredible experience. Attorney Sarah Weddington successfully argued the landmark abortion rights case Roe versus Wade before the High Court in 1976. Herbert Miller, an assistant attorney general during the Kennedy and Johnson years, as well as former counsel to President Nixon, was able to argue before the court on the Nixon Papers case. And former U.S. Congresswoman Elizabeth Holtzman, who served on the House Judiciary Committee. Ladies and gentlemen, good morning to all of you, and thanks for joining us.
Good morning.
Good morning. Mr. Miller, we're going to start with you, since you did argue the Nixon Papers case, and that was a case that the High Court had to look at how strong and what were the boundaries of a certain branch of government, in this case, congressional powers, and if they were allowed, how far Congress was allowed to go. Do you think that the High Court, as they will have to today, has particular sensitivity when it has to look at how strong and how far a particular branch of government can go?
I don't think there's any question that that will be one of the issues before the court. There's always a question first of jurisdiction, which I assume has already been taken care of, but then the impact of the decision and its reaching effect will have to be considered by the court. They did that in the Nixon Papers case. They did that in the Nixon immunity case, and they held that President Nixon, as all other presidents, had absolute immunity for any civil actions brought while he was president of the United States.
And then on a personal note, when you're before the High Court arguing something of that great importance, what was that like for you?
Well, the first time I argue, I can't tell you how many years ago, but it was 20, 30, 40 years. But it was terrifying. The other cases that I've had, including Eastland, representing the Senate Judiciary Committee, and Senator Eastland, all 3 were cases of very, very important constitutional principles. And any lawyer is honored to have the opportunity to address the court on issues of major substance, major constitutional substance. It is a wonderful experience, and anybody that can do it, I strongly recommend it.
Sarah Weddington, now to you. It was remarkable to me to find out you were only 26 years old in 1976 when you argued before the Supreme Court on Roe versus Wade. How does a 26-year-old young woman end up in such an important position?
Well, you volunteer to file a very important case and then take it all the way to the court. But right now, my heart is racing, just remembering what it was like. Right now, the lawyers, the champions for the 2 sides who will not wear suits of armor, but are sharpening their words and legal concepts. They are in the lawyer's lounge at this moment, just getting ready to go in, but they're thinking at a more personal level. They've had 4 seats each to give to family or friends or special attorneys. People are beginning to be processed into the courtroom, 125 members of the press. You have the family and friends of the justices in a section, the public section. While they're arguing, every 3 minutes a group will come out, a group will go out. There are heavy velvet curtains to hold down the noise. They will each be given a handmade goose quill pen. It will be at their place when they go into the courtroom, and it is a souvenir to take for having argued in the U.S. Supreme Court. There will be a huge light, a huge clock just above the Chief Justice, a few feet away, so they can watch the minutes of their oral argument ticking by. The spectators are now being told they cannot chew gum, they cannot have any written materials, they cannot whisper, they cannot put their arm on the back of the seats. They will be in very strict rules by the U.S. Supreme Court. But for those who are the legal champions today, they are really the ones who are trying to sharpen those words and concepts right now. They know once they address the court, it's going to be questions. They're not going to get to just give a speech. It's going to be questions. And then once the argument is over, their words will be on the internet. They will leave the court to face members of the press and give interviews. But if you had a Geiger counter that could pick up history, it would be clicking madly at this point.
It certainly would. Let's bring in Elizabeth Holtzman at this point. Ms. Holtzman, do you remember who the 4 people were who you invited to witness your historic moment before the High Court?
Well, they were actually members of my staff of the House when I was district attorney.
All the help you can get, huh?
All the help we can get, and some former staff from Congress. But I remember being a little bit terrified, but preparing like crazy.
Well, give me a little bit of insight. Give me a little bit of insight on that preparation. How do you get ready for something like this?
Well, you hit the books. You read every case, and you've read it over and over, and you read the statutes. And then what I did, and many lawyers do, is have what's known as a moot court. You kind of go through a dress rehearsal. You have friends and as brilliant people as you can find who just stand there, pretend they're the Supreme Court justices, and throw questions at you, and you got to try to answer them. And you go through several sessions like that, so you're really prepared so that you know you can anticipate every question that they're going to ask you and have an appropriate answer. Part of that's your responsibility as a lawyer, because you're there not just as an advocate for your side, but to educate the court and respond to what their concerns are and help educate them about how your concerns intersect with the Constitution and why you should win the case. It's a very, very draining and important process, but I think the most important thing about arguing before the court, and something that made me feel so proud as an American, you have the highest court in the land, and yet when you stand up to argue, they're really at eye level with you. It's like a conversation. It's very informal.
You weren't intimidated?
I wasn't. When I stood, I was intimidated before. Here I am. You know, my parents are immigrants to this country, and I'm walking up the steps of the Supreme Court and getting to argue a case about the Fourth Amendment and the Constitution and involve states' rights as well. And yet, when I stood up, I was just another human being whom they respected, and I respected them. And it was an extraordinarily informal dialogue. And of course, they hit you with questions, but it's still just such respect for you as a lawyer, because your responsibility is to help shape the Constitution and the future of this country, and it's a fantastic experience.
An incredible perspective. We're going to continue our conversation with our 3 guests after this break, giving us more of an idea of what it is like to go before the High Court, including what kind of facilities are available. Interesting trivia right ahead.
You start every morning with eyes that are new. Open up, your heart knows what's true. Open your eyes, open your mind, open your thoughts. See what you find. Nescafe. Open up, you can do anything. Nescafe.
日本から素晴らしいレポートが届きました。キシリトールがパワーアップします。
2つの新成分を配合、キシリトールガムプラス2新発売。虫歯のない社会へ、キシリトールはロッテ。
いけね、これからデートだった。
大丈夫、私なんかお見合いよ。大丈夫よ、私なんてこれから結婚式よ。食べたらフラボの大丈夫。お口すぎりロッテフラボの。
You must be excited to begin a new life in Tokyo. If you have any housing needs, please let us know. With the longest history of serving the foreign community's real estate needs, and thousands of premises on our exclusive list, as well as access to all those on the market, we can find the best home for you and your family. We can also provide you with all the hot information you need to live comfortably in Tokyo, including spots that are around your residence. We'll work hard so that you'll be happy in your new home.
You're looking at a live picture of the U.S. Supreme Court, where just about 21 minutes from now, the High Court will take on the question, did the Florida Supreme Court overstep its authority when it ruled that manual recounts should be included in the state's final presidential election totals? Quite a bit happening in the nation's capital. You have the hearing about to begin, and you have a number of protesters outside the U.S. Supreme Court trying to have their voices heard as well. You can only imagine the butterflies in the stomach of the attorneys that are about to appear before the Supreme Court. And to get an idea of what they're going through, we have 3 attorneys with us who have all argued before the High Court, and not just any cases, very important cases, we should stress. Herb Miller, want to pick up where Elizabeth Holtzman left off, the idea of preparation. Is the idea here, or the key, to try to pre-guess the 9 justices and try to anticipate every question that they might throw at you during your time before them?
Well, obviously, the first thing you have to know is the facts and the law as applied to the particular case involved. Then you generally can understand where the various justices will be coming from in terms of their question. What we do at Miller Cassidy Law Firm, we have several former Supreme Court law clerks, and we have moot courts, which was mentioned earlier, where these lawyers who have served on the Supreme Court do the actual interrogation in this moot court. And it is very, very helpful because they have a sense of what the Supreme Court practice is all about and are able to be perceptive, shall we say, as to what questions might well be asked. That, in addition to totally knowing the case, is a major part of any appearance before the Supreme Court.
Elizabeth Holtzman, back to you. I think people might be taken with the fact that this whole thing's going to last 90 minutes, and yet that's twice as long as most cases are before the High Court. How fast does it go, or is it like a slow motion camera?
No, it goes very fast because you know all the weaknesses in your case and you know the strengths of your case, and you're playing it all in your mind while you're really you're trying to make an argument, but you don't get very far because they're peppering you with questions, and it just goes so fast you can't believe it's over. And you have a dialogue with them on what the significance of the facts are of your case, the law, and how it fits into the constitutional statutory framework of the country.
And our time here
goes like fast.
Our time here is going very quickly. In the little bit of time we have left, Sarah Weddington, I have to get you in one more time. Give us a historical perspective. I understand in 1976, which was not that long ago, there weren't even facilities for women who might argue before the court. Is that right?
This time in 1971 and 1972, I was in the lawyer's lounge getting ready to go argue and suddenly discovered there was no ladies' restroom in the lawyer's lounge. Only men had argued for so long. I had to run to the basement. And today, it's only men arguing. But there are a lot of women arguing other cases. I think there is a zone that the lawyers are going into right now where they've studied the cases, they've studied the justices. They know they could be asked a question they don't know. I was asked one by Justice Rehnquist. And so now is the time they are getting quiet, they are going inward, and they are
What was that question? What was the question that Justice Rehnquist?
For me, of course, it was the abortion case, and Rehnquist's question was, when was Texas readmitted to the Union? I just didn't think about that as something I needed to know.
And why was it important?
So I had to say, well, I don't think it was. I think I was a young lawyer and he wanted me to lose, and he was just seeing if he could throw me and make me ineffective. So I said, I'm sorry, Your Honor, I don't know. I'll go home and look it up, send it in on a supplemental brief. And my students now ask me if they can file supplementals after finals. But it is this moment when you're going into an inner place. Because once you're up, I agree with Elizabeth Holtzman, you don't look at your notes, you're not aware of anything in the courtroom, not the 13 columns of marble, not the high ceiling, not the formality of the court. You're just looking at those 9 judges and trying to guess what they're thinking. And when it was over, I actually had to say to people, what did I say? Because you are so intense, and they are getting to that point now.
Well, the beauty of today's proceedings, the lawyers will just have to tune on CNN and they'll be able to hear the audio of what takes place today, and we'll have it for our viewers. Go ahead.
My argument was taped. They've taped arguments for years. But what's so different is that it will immediately be available.
It will be a fascinating moment. It's been a very interesting conversation with all 3 of you. Our many thanks to Herbert Miller, Elizabeth Holtzman, and Sarah Weddington. Thanks for joining us here this morning. Great to have you here. And we will actually go up to Frank in Washington, D.C. Frank, you take it from here.
All right, well, quill pens, ladies' restrooms, Title III, Section 5, protesters, all these among the historic events in the nation's capital today. And Supreme Court justices being asked to rule on a very serious matter on whether Florida State Supreme Court unlawfully authorized that hand recount to be included in the vote tally, which determines the President of the United States. CNN's David Mattingly now on how this day will play out in the High Court's hallowed halls.
Among the bedrock principles of American election law is that you can't come up with new and different rules after Election Day for the purpose of counting ballots.
We are asking the High Court to step aside. We do not think there has been any violation of federal law or the federal Constitution to remedy.
Two sides, two polarized viewpoints. And in the center of this presidential impasse, the highest court in the land, the U.S. Supreme Court.
There's going to be an enormous crowd taking numbers so they can get those very few seats that are available in the courtroom to see this historic argument.
And it will be tight. Additional seating will more than triple the usual array of press, 119 in all. 75 seats reserved for attorneys admitted to practice before the Supreme Court. Additional seats brought in, available to accommodate up to 250 members of Congress, guests of legal teams, and finally, the general public. The lucky few who do get in will watch counsel teams stationed down front argue to seated Justices Ginsburg, Souter, Scalia, Stevens, Chief Justice Rehnquist, Justices O'Connor, Kennedy, Thomas, and Breyer.
What do we want? When do we want it?
At issue, did the Florida Supreme Court violate federal and constitutional law when it ruled on behalf of the Gore campaign to include manual recounts in the state's final and certified presidential election totals? One sign of the extraordinary nature of this case, each side will be given 45 minutes to argue, 15 minutes more than usual.
Chief Justice Rehnquist is sometimes very stern with the lawyers, may correct their grammar. Justice Stevens always has the question that the lawyers never anticipated. Justice Scalia likes to toy with the lawyers. He will ask these crazy hypotheticals sometimes and will just give the lawyers a very hard time.
The proceedings will not be seen on television as they have been in Florida courts. The Supreme Court's never allowed that. But in another sign of extraordinary circumstances, the High Court, for the first time, will release audio recordings after the oral arguments. We will hear every statement from the attorneys and every question from the justices.
And the justices will retire into their secret conference. No one will be present at that conference except for the justices themselves.
Then, behind closed doors, Chief Justice William Rehnquist will speak first, followed by each justice in order of seniority.
I, Stephen Breyer.
With Justice Stephen Breyer, appointed in 1994, speaking last.
And they will take a tentative vote, and the senior member of the majority group will decide who writes the majority opinion. And then they're off to the races.
In private, the justice writing the opinion can confer with other justices before circulating a draft to the entire court. If there is a dissenting opinion, more time may be needed. How long, how many days is anyone's guess.
They'll troop back into the courtroom, and then the justice drafting, who is the author of the opinion, will read a usually short summary of the court's holding and analysis.
A short summary with potentially historic implications for future elections. But what impact will the High Court have in this presidential impasse? And can the court help the nation avoid a constitutional crisis? David Mattingly, CNN, Atlanta.
Answers to those questions begin to take shape just 10 minutes or so from now with these words, oyez, oyez, oyez. The court is now in session as the marshal calls the court to order and the justices take their seats. We're going to go to Bob Franken outside the court after this very brief break.
No getting out, no going home. I got the same mission.
X ファイルのクリエイターが挑む衝撃のサイバーアクション
ッシュレグ12月8日ビデオレンタル開始。
I'm John Gibson in New York. Back to Tony Snow at the Supreme Court in a moment. Once the election mess is over, the Sunshine State may have to change its nickname to the Battleground State. Here's what's happening in the battle for Florida's 25 presidential electors. While we're all focused on the Supreme Court right now, there is action elsewhere. There's legal maneuvering in the Florida state courts. Another ballot caravan is heading for a state court in Tallahassee, and both candidates are making plans for possible administrations. The spotlight today is definitely on the U.S. Supreme Court. As we've been reporting, oral arguments are due to start any minute. No cameras in the courtroom, but stay with Fox News Channel to hear the audio tapes of the hearing, which will be released immediately after the hearing. Back in Florida itself, the ballot battle is growing. Bush lawyers asked Circuit Court Judge N. Sanders Sauls to send for another 1.25 million ballots from 3 counties. The judge has yet to consider the request. Al Gore's lawyers asked the Florida Supreme Court to order hand recounts started immediately. In a countermove, Bush's legal team filed a motion in the Circuit Court urging the judge to throw out Gore's contest of the election. They argue the real election dispute isn't between Bush and Gore, but between separate groups of state electors. And there are reports the Bush team plans to call 95 witnesses if the case goes to trial. Meantime, another 600,000 ballots from Miami-Dade are being trucked to Saul's court in Tallahassee. Yesterday, about 500,000 arrived from Palm Beach County. The Circuit Court will hold a hearing tomorrow on whether to order recounts. The Gore camp says it's discussing possible candidates for cabinet posts should Al Gore eventually win the White House. Running mate Joe Lieberman wouldn't name names, but he says a Gore administration would include Republicans and independents. The Gores and the Liebermans met with advisors yesterday, including their transition director, Roy Neal. Sources say the group wants to create a grassroots panel of community leaders to advise Gore on building his administration. The Bush camp still holding down the fort in Texas. The governor is spending another day at his ranch near Crawford working on the transition. He was joined there yesterday by retired General Colin Powell and running mate Dick Cheney. Powell is expected to be offered the position of Secretary of State. Tomorrow, Bush plans to meet with House Speaker Dennis Hastert and Senate Majority Leader Trent Lott. Another update later in the hour. More now from the U.S. Supreme Court with Tony Snow.
Thanks, John. Well, the sun is coming out. Things are calming down here a little bit, and the sound of protesters is giving way to the sound of leaf blowers. As you can see, the line outside the Supreme Court chambers is getting much smaller as people are piling in and trying to cram themselves into the court room because the hearings are going to begin promptly at 10 a.m. Eastern Time. Now, as John just mentioned, there's a lot of activity going on today in Florida as well. And to give us a little more context on that, we're joined from Tallahassee, Florida, by our own Rick Leventhal. Rick?
Hey, Tony, no sound of leaf blowers here, but we are expecting the sound of helicopters as they follow that caravan of ballots heading up here from South Florida. As John mentioned, 654,000 of them in the back of a white rental truck in 82 cardboard boxes sealed with tape marked as evidence. If you're tracking at home, they're taking I-95 to the Florida Turnpike to I-75 to I-10. And once they arrive, they will be loaded into a vault inside the Leon County Courthouse next to those other ballots from Palm Beach County, and they might stay there for a while because Judge Sanders Sauls hasn't yet decided if they'll be recounted, which is what the Gore team wants. That'll happen Saturday. He holds a hearing Saturday on the contest. The Gore team asking that 14,000 ballots be examined, believing there might be enough votes there to swing the election his way, reversing the certified results. Now the Bush team says that if you're going to count those, you also need to count 1.2 million more ballots from 3 other counties, Broward, Pinellas, and Volusia, where they believe Al Gore gained illegal votes. In the meantime, the state Supreme Court, considering that Gore appeal to have those ballots recounted immediately, the Supreme Court also considering a couple of other appeals on the butterfly ballots down in Palm Beach County, some voters asking for a revote down there. And of course, the state legislature may also get more involved here. A special committee has now passed a resolution recommending a special session to decide if the state House and Senate should be ready to choose the state's electors themselves as this court battle drags on. Tony, we may hear from the state Supreme Court spokesman within the next couple of hours. Not sure yet. They're dealing with some other business as well. There are a couple of death penalty cases they have to work on, so that may be taking up the bulk of their time right now, Tony.
Rick, do we even know if they're going to agree to take up the Gore petition? They're looking at it, and if so, what happens? Do they invite both sides in for arguments?
Well, that could happen. In fact, both sides may be required to present oral arguments. All we know right now is that they're considering briefs, but they have not decided whether or not they'll actually hear this appeal.
Okay, so that's if we're going to hear something from the court spokesman, that's likely going to be the case. He will tell us first whether or not they're going to take up the case at all.
Right. Well, more than likely, that's what we'll hear. It's possible that the court will have ruled on the arguments that were filed by the lawyers, but it's also possible, as you mentioned, that they could hold another hearing. So really, we need to wait for Craig Waters to come out and lay it all out for us. And as yet, no time set for that announcement just yet.
Rick, also yesterday, a joint committee in the Florida legislature that is taking a look into the manner of appointing electors announced that, it had accepted, it was moving forward a bit of legislation to have a special session. Do we have any more information today on when that special session, should it take place, would take place?
Well, what we may hear is from someone with the state legislature. In fact, they may have a special signing ceremony at some point to talk about calling this special session into order. It could happen today, that signing ceremony, or it could happen early next week. There's been a lot of speculation that sometime, possibly early to the middle of next week, they would call this special session, and we may find out more on that today as well, Tony.
All right, Rick Leventhal in Tallahassee. Thanks for keeping us apprised. Sure. Folks, we're going to take another break in just a couple of minutes. The arguments begin before the United States Supreme Court. We'll be right here.
The tape recorders will be rolling. When the arguments are over, the tape will be brought outside, will be played back for us and for you. Back to Atlanta.
Frank, thank you very much. Once again, we are covering events in Washington, the protesters there, the arguments that are about to begin at the top of the hour. Also, we have Bill Hemmer, of course, stationed in Tallahassee, Florida. The story today in Florida as those hundreds of thousands of ballots make it from Miami-Dade County up to the state capitol, covering that part of the story as well. More of our special coverage and morning news continues at the top of the hour.
Hi there, everybody. I'm Lauren Sidney in New York.
X ファイル毎週月曜夜10時 Only on Fox。
You're seeing a live aerial shot of the United States Supreme Court, and any second now, the justices are going to be hearing arguments in the case of George W. Bush versus the Palm Beach County Board of Canvassers. In the balance may hinge the election of the year 2000. The justices are actually going to be releasing audio tapes of the arguments just about as soon as they're completed. That's going to be 90 minutes from now. We will bring you those audio tapes. We'll have pictures to cover them, and we'll also have commentary. Now, we've talked today about the kind of people who've been outside. We've seen political protesters of all stripes, but there are people who come here for academic reasons as well, and Rita Cosby has a law professor who's come to see what's going on today. Rita?
That's right, Tony. In fact, you can probably hear the crowds behind me. The enormous crowd of protesters is gradually increasing. In fact, we've probably got more than 1,000 of them out here. And in between all that, we've got a number of people who are here to physically watch history firsthand, including John Oldfield, your University of Oklahoma law professor. You've been standing in line to get into that 3-minute rotation setup. Tell us how that works and tell us what time you got here to the courthouse.
Well, that's correct. We had hoped to get in for the entire argument, but we didn't make the top 50 on that, but we're hoping to get in to the 3 to 5 minute rotation. We got here about 6 o'clock this morning, been waiting in line, and it's been real exciting watching all of this happen.
Now, what's your sense? Are you going to be able to get in? I saw that line. It's going longer than a block.
Yes, they've told us that where we are, we will probably get in and get a chance to view at least some of the arguments that will be made today.
Now, you've been inside the Supreme Court before, but why is this so important? Is this sort of the zenith of it all?
Well, I think so. I think any lawyer that gets to even just watch the Supreme Court, much less argue before it, I mean, it's the height of being a lawyer, and it's the top judicial position here in the United States. This is just an exciting time for lawyers to be here, to be a part of it, to see it, to interact with it, and watch the people interact with it, and educate the people a little bit about the role of the Supreme Court.
All right, John Oldfield, thank you very much. University of Oklahoma law professor. Tony, back to you. An exciting time, a civics lesson I think you're going to share with your students. Back to you.
All right, thanks, Rita. Well, speaking of civics lessons, we have every reason to believe that the arguments have begun, or more precisely, the grilling of attorneys by members of the United States Supreme Court. To talk a little bit about that, I'm joined here in Washington by our correspondent Brian Wilson, and in New York by Judge Andrew Napolitano, host of Power of Attorney. Gentlemen, let's first take a look at each of the justices, and I'm going to run in backward order of seniority. We're going to talk about what people may or may not expect to hear from these justices as today's events transpire. Number one is Ruth Bader Ginsburg, who is actually, I guess, well, Ruth Bader Ginsburg is one of the 2 Clinton appointees on the court. Judge Napolitano, what can we expect to hear from her?
Well, Ruth Bader Ginsburg is from my native state of New Jersey. She taught at Rutgers Law School in Newark, New Jersey, and at Columbia Law School. She was a very staunch civil libertarian and a champion of women's rights when she was a litigator and a law professor. She is a card-carrying Democrat, an unabashed liberal, a respecter not necessarily of the literal words of the Constitution, but of what she thinks the founders meant by those words. So I think you're going to see her aggressively grilling Ted Olson about why these votes should not be counted.
Okay, Brian Wilson, everybody says she's one of the people who is most eager to question people, along with Antonin Scalia, of whom we will speak in a couple of minutes.
I have sat in on other Supreme Court arguments, and you do see her take an active role in the court and ask a lot of very pointed questions. I think you should have to also make the point, though, that you can't always tell by the direction of the questions which way they're going to go, as we've seen oftentimes with Antonin Scalia, but we'll get to him, I'm sure, in just a moment.
That's right. Okay, now, the other Clinton appointee on the court, David Breyer, somebody who came in with a reputation of maybe not being as much of a judicial activist, but that seems to have changed a little bit on the court. Andrew Napolitano, talk a bit about Justice Breyer.
Not as aggressive a questioner. His background is when the Democrats controlled the Senate and Senator Kennedy of Massachusetts was chairman of the Education and Labor Committee. Stephen Breyer was general counsel to that committee. He then was appointed to the United States Court of Appeals for the First Circuit, which sits in Boston and pretty much governs the district courts in New England. And from there, he went to the United States Supreme Court. He's a little bit more Sphinx-like, I think, than Justice Ginsburg, though he comes from the same ideological and political camp. He's not as willing to reveal his thoughts by the nature of the questions, and is not as aggressive in his questioning as Justice Scalia or Justice Ginsburg.
And thank you for correcting me. I called him David Breyer. It's Stephen Breyer. Subtly done, too, Judd.
Yeah, Stephen Breyer, of course, is 62 years old, nominated by Clinton, and he was sworn in. And I think it's right. It's very often very difficult to get a sense of which way he might be leaning in a case. He is, of course, one of the two Clinton appointees on the court, and therefore more likely to go that way, but not, I would say, one of the extreme liberal members of this court.
Now, one of the sort of chestnuts about Supreme Court justices is you can never tell how they're going to turn out. President George Bush appointed David Souter. He was a man who didn't have a paper trail, but everybody said that he was a strict constitutionalist. Turns out he's been one of the more active members of the court. Judge Napolitano?
Oh, this has been a real surprise for President Bush and a real pain in the neck for conservatives who were promised that Justice Souter would be one of them. This is a quiet, serious thinker who works about 18 hours a day. He is not married, doesn't have children, is a workaholic. He is a serious scholar. He has disappointed the conservatives. He's voted with the liberals on abortion, and I have no way of even suggesting which way he's going to come out on this. He was once on the New Hampshire Supreme Court, where his decisions could be characterized as constructive, that is, not a constructionist, that is, not an activist, but he's done some very activist things since he's been on the U.S. Supreme Court.
And you mentioned something very interesting, Judge Napolitano. He's somebody who works very hard, and although not much loved by conservatives, is held in considerable esteem and affection by his own colleagues on the bench. Brian?
Yes, he is.
I covered his confirmation hearings, and one of the things that was remarkable about that when he was going before the U.S. Senate for confirmation is that he was such a huge question mark. There was so much about this guy we did not know, nothing remarkable about him, which apparently was what the Bush administration was looking for at the time, and the judge is absolutely correct. Many conservatives are very disappointed that he didn't turn out to be a little more conservative.
As somebody who's
Go ahead. Brian, I remember watching those confirmation hearings. They were broadcast on another network late at night, and his answers to questions put to him by the Senate Judiciary Committee sounded like a treatise on constitutional law. Now, I teach constitutional law, and I have for 13 years. I was bowled over by this man's knowledge of the nuances of constitutional law, and have rarely been as impressed by an intellect as I was by him. I'm not going to tell you my opinion of his votes, but no one can dispute Justice Souter's intellect.
A bright man, no doubt.
What's interesting, I was in the Bush White House at the time, and as you gentlemen may recall, there was a lot of concern about somebody being ripped to shreds over things he might have written. Everybody still remembered the 1987 debacle involving Judge Robert Bork, who was rejected by the United States Senate. So they cast about to find somebody who would not be terribly controversial. They looked for somebody with, quote, no paper trail other than renderings from the bench, and that's how we got David Souter. Let's turn now to the other George Bush appointee, Clarence Thomas, somebody who tends to be quite silent when it comes to oral arguments, but at the same time is somebody who is increasingly assertive in terms of the opinion he's handing down from the bench.
Well, Justice Thomas, of course, entered the court under a cloud, which thankfully is receding into history, Tony. And he is not an aggressive questioner. In fact, in some very, very tumultuous experiences in the court, that is, where there's a lot of questioning going on at once, Justice Thomas remained absolutely silent. But his opinions have not lost the attention of legal scholars who have praised them for their reasoning and for their exceptional research. Even when he writes a dissent, it's a long, well-researched, well-reasoned dissent, and many people who were harshly critical of him when he was nominated to the court have said he's a real legal scholar. He's in the conservative camp, and unabashedly so, but you'll never know from the questioning how he thinks because he rarely asks any questions.
Now, Judge, one of the other things is when you take a look at the opinions people write, other than Antonin Scalia, he writes in the most, how shall I say this, comprehensible English. These are pretty straightforward opinions as well.
Yes, he is, and as a result, those of us who teach these things in law schools are not reluctant to point to Justice Thomas as the type of legal reasoning that lawyers should be attracted to because they can understand what he's talking about.
Let me ask you one more question, then I want to get to Brian Wilson on Clarence Thomas, which is Justice Thomas originally was characterized as a, quote, Scalia clone, somebody who often held the same opinions as Antonin Scalia, but they've begun to diverge a bit as well, have they not?
They have on some issues. Now, for the most part, they come from a common spring, a view that law means what it says. They are close to being literalists. They don't want to read a lot into the law. But yes, they have disagreed. I mean, one of the things they were criticizing Justice Thomas for was it gives Justice Scalia 2 votes. But that is not the case. He is an independent thinker. They have disagreed. And when they've disagreed, Justice Thomas has written eloquently as to why they disagreed.
Okay, folks, you hear a lot of racket behind us. It's Capitol Police on their motorcycles disembarking to go someplace or other. Brian Wilson, let's talk more about Clarence Thomas.
I, of course, again, covered the confirmation hearings of Clarence Thomas, which every person in America probably remembers. That was one of the most interesting times that I remember in Washington. The result of that, I think, has been that Clarence Thomas has basically pulled in his horns and has tried to be as low-key on a personal level as he can. You don't hear much about him around this town, except of his comings and goings to the court. And I think that one of the reasons he is so quiet in the courtroom is that it was a decided strategy on his part. Look, I know I'm controversial. I know that a lot of people don't like me. I think I'll just lay low and let my legal writings speak for me, and that has seemed to be his strategy since he took the court.
As a matter of fact, when he first came to the court, he was telling friends and colleagues that he didn't really plan to do any serious writing of opinions for the first 5 years. He wanted to get a sense of the institution, but he started weighing in on voting rights cases as early as his 3rd year on the bench. We're going to take another break, and we'll talk about the other 5 members of the Supreme Court and also the arguments today in just a couple of minutes.
In an era of fierce competition for spots on cable systems.
Life is an end.
Gone are the days when baseball fans can feast their eyes on the dazzling doings of Joe DiMaggio, one of the game's all-time greats, who always went all out in playing his way to the pinnacle of his profession. By Yankee owners Topping and Webb and manager Stengel, the Yankee Clipper makes an historic announcement.
I said last spring, I thought this would be my last year. I wish I could have had a better year. But even if I had hit 350, this would have been my last year for me anyhow. You all know I've had my share of injuries and setbacks during my career. In recent years, these have been too frequent to laugh off. When baseball is no longer fun, it's no longer a game. And so, I've played my last game of ball.
Sorry to see you go, Joe, but happy to welcome you to our Yankee microphone.
Camera highlights in the world of sports. This, ladies and gentlemen, is the Rose Bowl game, minus the Rose Bowl weather, minus the Rose Bowl. Well, here we are at Durham, North Carolina, the transplanted setting of the postseason classic, where the Beavers of Oregon State and the Blue Devils of Duke make 56,000 rain-soaked spectators forget the weather in a slashing ball game that finds the Dukes trailing 7-0 here in the second period and driving to the Oregon State 9-yard line to set up the scoring play. Blanche takes the ball on a reverse, carries through a hole in the right side of the line, goes over standing up. And what these lovelies behold here in the third period is a deadlocked ball game at 14-all. But the Beavers change all that when Deathman drops back, heaves a pass to Gray, who takes the ball on the Duke 35 and carves himself a chunk of Rose Bowl glory as the underrated Beavers triumph 20-16.
Okay, we're looking again at the outside of the United States Supreme Court. Inside, we know that the arguments have begun in the case of Bush versus Palm Beach County. Ted Olson, who is the chief attorney, the attorney of record for George W. Bush, presumably is making arguments right now. He will be followed in time by other attorneys for the Bush team and, of course, for the Gore team as well. Now, we are marching through one by one the members of the United States Supreme Court to give you a sense of what the atmosphere inside might be and how they might behave. Next up in our roster is Anthony Kennedy, who got the seat that was denied to Robert Bork. He's widely seen as kind of a moderate so-called swing vote on this court. Let's go back to Andrew Napolitano. Judge Napolitano, talk a little bit about Anthony Kennedy.
Justice Kennedy was a professor at Stanford Law School before he went on the Ninth Circuit Court of Appeals, which is the Circuit Court of Appeals that covers California and most of the West Coast. When he was on the Ninth Circuit, pardon me, he had a reputation for being the type of strict constructionist, code word for conservative, if you will, that Presidents Reagan and Bush would enjoy. He has pretty much become a centrist on this Supreme Court. That is, he and Justice Sandra Day O'Connor pretty much control which way the court's going to go, depending upon whether they vote with the liberal bloc or with the conservative bloc. Now, here's a little bit of undercurrent that you and Brian probably know about, sort of the scuttlebutt in Washington, D.C. Justice Kennedy really wants to succeed Chief Justice Rehnquist, who, if George Bush becomes president, will probably resign. And it's well known that he is sort of the rally around the flag centrist type who usually becomes the Chief Justice.
And one of the other sort of interesting byplays is the fact, as we mentioned earlier also, that he's pretty close friends with Lawrence Tribe, who's offering the Gore team's arguments today. Brian?
He is close friends with Lawrence Tribe. He's also close friends with Ted Olson, who ran the office in the Justice Department that picked then Judge Kennedy to have him nominated to the Supreme Court.
Key swing vote. There's no doubt about it. This man is in the middle. Now, in the state of Texas, where I'm from, there's a saying about there's nothing in the middle but yellow stripes and dead armadillos. But in the Supreme Court, many people say that the middle is where the real power is. It's not to the left. It's not to the right. It's the people in the middle who have the power. And clearly, Judge Anthony Kennedy is a man who is there in the middle and often is the determining factor in which way a case will go.
Okay, we're going to pick up the pace a little bit and speed through the rest of our justices. Antonin Scalia, the most outspoken conservative on the bench. Andrew, we expect to hear a lot from him today.
Yes, we will. He's the most aggressive questioner. He is the most aggressive writer. He is the most controversial justice on the Supreme Court. And he's the one that Governor George W. Bush has said is one of his two favorites, and he is likely to appoint justices who think like Justice Scalia. The other favorite is Justice Thomas.
A man with a tremendous sense of humor. He is considered kind of the cut-up of the court. He always brings laughter to the court, which are not always very solemn affairs. Somebody who was once urged by a Washington Redskin to be more of a cut-up, Sandra Day O'Connor. Andrew, talk about...
Sure, Tony. She occupies the same position that Brian so nicely described for Justice Kennedy. She is right in the middle, and in fact, the two of them vote together as frequently as do Justices Scalia and Thomas, except in the case of Justice O'Connor voting with Justice Kennedy, they can frequently determine the outcome by depending which camp, the liberal or the conservative, that they swing to.
And someone who has changed over time. She was a lot more conservative in the early days and seems to become more of a moderate as time goes on.
And one of the ironies is that she and William Rehnquist were in the same class at Stanford Law School. He was #1 in the class. She was #3. John Paul Stevens, another Republican appointee, no longer part of the conservative bloc. Andrew?
This is the arch liberal amongst the Republicans. This is an old-style liberal Republican, sort of from the old Nelson Rockefeller school, who can be counted upon safely to vote with Justice Ginsburg and Justice Breyer almost always.
Interesting to note that he has voted against broadening police powers and in favor of abortion rights. So, yes, one of the more liberal members of the court.
Okay, finally, William Rehnquist. We've seen in the impeachment hearings he runs a tight ship. We expect more of the same today, correct, Andrew?
Yes, we do. Justice Rehnquist runs a very tight ship. He has been known to stop lawyers not only mid-sentence but mid-syllable if their time is up. An arch-conservative of the Antonin Scalia school whose real legacy, he says, will be federalism, returning powers to the states. We can't even think which way he may go on this one.
Probably the best-known member of the court, of course, because of the Lewinsky hearings and the building that is in front of us now, the U.S. Senate. So definitely well-known, very conservative, a man who I think would like to get off the bench if a Republican president were elected.
Okay, Brian Wilson, Andrew Napolitano, stay with us. We're going to take a break. When we return, we're going to get a full update of the goings-on in Florida from our own John Gibson. And, of course, we'll keep you up to date with all the developments here in Washington as well.
Kentucky's great day, when the focal point of the sporting world converges on historic Churchill Downs, when fanfare and mellow Stephen Foster strains proclaim the running of another Kentucky Derby. Attending notables today include Kentucky's Governor Keene Johnson with Mrs. Johnson and his sister, Mr. and Mrs. Warren Wright, his Calumet Farm entry Whirlaway is Kentucky's heartthrob, and the bluegrass betting owner of Man o' War and Mr. Herbert Hazeltine, 20th Century Fox star Don Amici. A record throng of 90,000 spectators on the scene when 11 jockeys thread a path to the paddock. The crowd cramming every vantage point when the post-parade passes in impressive review. Moments later, the prelude is over. All in order within the starting gate. Starter Ruby poised. The dramatic pause before Bedlam. And they're away. Pounding down the straightaway past the stands. The crafty maneuvering of jockeys raiding high-strung thoroughbreds in the run to the turn. Disposed leading the pack out in front by a length and a half. Porter's Cap, Blue Pair, R. Boots, and Robert Morris closely bunched behind the flying leader. Whirlaway, betting favorite, eased smartly by jockey Eddie Arcaro in the tight going at the turn. Disposed having a run for himself in the early stages here, seems well within his commanding pace, but it's a mile and a quarter that these three-year-olds travel with the hardest going yet to come. And here, through movie-tone slow-motion camera, the record-shattering stretch run of Whirlaway, his blazing final quarter in 24 seconds flat. A rare study of the little chestnut colt with a long tail, cracking the 10-year-old Derby time of 20 grand by 2/5 of a second. Here, then, is life's biggest moment in the enthralling story of Whirlaway, a 3-year-old son of the Aga Khan stallion and England's Epsom Derby winner Blenheim II. Like father, like son, a thoroughbred born to the purple and the laurel of a champion.
In the Santa Monica Civic Auditorium, the highlights of the presentation of Academy Awards. For their roles in the Best Picture West Side Story, George Chakiris gets an award from Shirley Jones as Best Supporting Actor. And as Best Supporting Actress, we have Rita Moreno receiving one from Rock Hudson, exciting Rita no end. While acting for Sophia Loren, Greer Garson accepts the Best Actress Award from Burt Lancaster, and there's joy in Italy as the star whose performance in Two Women was a winner, and with director De Sica shares her triumph with Mother and Husband.
I'm John Gibson in New York. We'll be back to Tony Snow in D.C. in a moment. All eyes are on the Supreme Court, but there's also maneuvering elsewhere in the battle for Florida's 25 presidential electors. There are legal proceedings in the Florida state courts. Another ballot caravan is heading for a circuit court in Tallahassee, and both candidates are making plans for possible administrations. The spotlight definitely on the U.S. Supreme Court today. As we've been reporting, the justices are hearing oral arguments. No cameras in the courtroom, but stay with Fox News Channel to hear the audio tapes of the hearing. They will be released immediately after the hearing. Back in Florida itself, the ballot battle is growing. Bush lawyers asked Circuit Court Judge N. Sanders Sauls to send for another 1.25 million ballots from 3 counties. The judge has yet to consider the request. Al Gore's lawyers asked the Florida Supreme Court to order hand recounts starting immediately. In a countermove, Bush's legal team filed a motion in the Circuit Court urging the judge to throw out Gore's contest of the election. They argue the real election dispute is not between Bush and Gore, but between separate groups of state electors. And there are reports the Bush team plans to call 95 witnesses if the case goes to trial. Meantime, about 600,000 ballots from Miami-Dade County are being trucked to Saul's court in Tallahassee. Yesterday, about 500,000 arrived from Palm Beach County. The Circuit Court will hold a hearing tomorrow on whether to order recounts. The Gore camp says it's discussing possible candidates for cabinet posts should Al Gore eventually win the White House. Running mate Joe Lieberman wouldn't name names, but he says a Gore administration would include Republicans and independents. The Gores and the Liebermans met with advisors yesterday, including their transition director, Roy Neal. Sources say the group wants to create a grassroots panel of community leaders to advise Gore on building his administration. The Bush camp still holding down the fort in Texas. The governor is spending another day at his ranch near Crawford working on the transition. He was joined there yesterday by retired General Colin Powell and running mate Dick Cheney. Powell is, of course, expected to be offered the position of Secretary of State. Tomorrow, Bush plans to meet with House Speaker Dennis Hastert and Senate Majority Leader Trent Lott. We will have updates throughout the day. Now, for more from the United States Supreme Court, Tony Snow.
Well, the Supreme Court has been hearing arguments for close to half an hour, and in just about an hour and 10 minutes or so, we'll actually be getting audio tapes of today's oral arguments. It's the first time that's ever happened, and we'll give you a play-by-play with Judge Andrew Napolitano, Brian Wilson on our cast of stars here. Meanwhile, though, let's touch base on political developments. First, we're going to start with what's going on with Team Bush. Carol McKinley is standing by in Austin, Texas with the very latest. Carol?
Hi there, Tony. You know, cabinet announcements could come as early as Monday or Tuesday, but it's not like it's been any secret. Governor Bush has been teasing us with glimpses of what's to come lately. For instance, here's a good example. Retired General Colin Powell was in Crawford at Bush's ranch on Thursday. He and Dick Cheney and Governor Bush were talking about all kinds of things, including transition, and a topic Powell knows a little something about.
Powell, 21.
I've been reading that in the newspaper, but I have had no such conversation with the governor or with Secretary Cheney or anyone else. I'm not sure where that came from. It has always been my understanding in my earlier conversations with the governor that he would not move in that direction and begin appointing members of a cabinet until all of this matter is behind us and resolved.
Now, Powell's been mentioned as the Secretary of State. He's the only person in America who isn't so sure of that possibility. Now, it was the first time Bush had taken questions from reporters in quite a while. He's been laying low, although his advisors assure us he's been in on all the decision-making. He talked here in Crawford about what he and Bush, what he and Cheney and Powell were discussing.
Roll 19.
We're going to spend the afternoon talking about our transition and in particular, we're talking about national security matters and foreign policy matters. No better person to talk about that with than Colin Powell. Got a great deal of experience. Dick and I trust his judgment.
Bush and Cheney will make it back to Austin, Texas today. There is a Christmas party scheduled, and tomorrow they'll be meeting with 2 VIPs. House Speaker Dennis Hastert and Senate Majority Leader Trent Lott will be in town to talk about what happens when the legislature convenes in January. Of course, they'll be talking about transition. Meanwhile, today, Bush is going to be keeping his eye on what's happening in Washington, D.C. with you, Tony, because he's very interested in that decision, hoping that it furthers his position to be the next president of the United States. We're live in Austin. Tony, back to you.
Thank you, Carol. Now standing by in our Washington studios with more on what's going on with Team Gore is David Schuster. David?
Hey, Tony. The vice president at this hour is at his official residence in Northwest Washington, the Naval Observatory. Gore is expected to watch some of the Supreme Court coverage, and he has no events on his schedule. One Democrat said this morning the situation for Gore, who had transition meetings yesterday, is like the first round of the NCAA basketball tournament. It's like March Madness, said the Hill staffer. If you win, you play on. If you lose, you go home. If Gore wins at the Supreme Court and in the Florida courts, the next battle would likely involve the Republican-dominated Florida legislature. The legislature is planning to go into special session next week to name a slate of 25 electors for George W. Bush. Democrats are calling it an outrageous attempt to bypass the true will of Florida voters and guarantee Bush an election victory.
We know there's a lot of emotion swirling around the election and the results in Florida, but we're talking here about the integrity of the selection of a president of the United States. We're talking about history and the precedent that everything we do this year will set for those who follow us in years ahead. I just think it would be a terrible mistake for our country if the Florida legislature and Governor Bush went ahead and did what they said they're going to do.
Republicans say the legislature is just trying to make sure that Florida's voice is heard in the Electoral College. Democrats say the legislature only wants Republican voices heard. But the fact that the legislature plans to act at all is being described by Electoral College experts as strange and redundant. They note that Republican elector certificates have already been forwarded to Congress. If the courts give a victory to Al Gore, a Democratic slate will be delivered, and it will be up to Congress to decide which group of electors to accept. Finally, some historians have suggested that it would be inappropriate for an outgoing president to get involved in any of this, but during a recent conversation with foreign journalists, President Clinton apparently couldn't resist. According to the Ottawa Citizen, Mr. Clinton told a few reporters, quote, "America will be embarrassed in front of the world if the votes in Florida are not counted." The president said if the courts don't examine those undervote ballots, historians, in a very public fashion, will. Tony?
All right, David, thanks so much. Just to reset where we are, folks, the arguments have been taking place for about a half hour now before the United States Supreme Court. And a little more than an hour from now, we'll have audio tapes of those oral arguments, along with commentary from our experts here. Speaking of which, we're going to take a quick break, and when we return, we're going to talk about the issues that are before the court today.
Because millions are golden, also because silence is golden. They're seen but not heard. Count and Countess von Haugwitz-Reventlow. Married at Reno, they're on their honeymoon, speechless. But let's try to get them to say a few words, 5 words or maybe 10. Count, what do you think of married life? Not a word, but maybe the Countess will let slip a secret or two. How's the weather, Countess? Nothing for publication. The words she would not speak were countless, but she is not countless. Away she goes to greet some of her friends, and so ends the interview that was only a view.
A bride of 19. She marries Vaughn Paul. He was assistant director in the making of her first motion picture when she was a child singer. Now he's an associate producer. Deanna Durbin's wedding is quiet and traditional. The traditional wedding cake and the bride cutting a slice. How is it? Nothing like finding out. You try it first. Weddings are wonderful. The cake is so good. The wedding of a Vanderbilt heiress is a social occasion, and she's Gloria Vanderbilt. The old Santa Barbara Mission in California and a bridal veil on a windy day would seem to make it a breezy romance. The groom is Pat DiCicco, an actor's agent. The best man is movie star Bruce Cabot, bridesmaid Shirley Cohen. He's 32, she 17.
Back outside the United States Supreme Court. I'm Tony Snow in Washington, joined here by Brian Wilson in New York. We've got Judge Andrew Napolitano. Let's give you a sense of what's going on. First, we're going to give you a graphic look at what the United States Supreme Court chamber looks like. You will see there that at the very front, you have a kind of a semicircle at which the 9 justices are seated. In front of them, you have the various benches where attorneys on both sides are seated as well. And then, of course, all those little gray squares and lines indicate where the audience is. And it's really kind of a packed audience within the chamber. Now, the way it works is Ted Olson, the attorney for the Bush camp, started off. He should be done by now. At this point now, Kenneth Clark, who is an attorney representing Florida Secretary of State Katherine Harris, is going to be making arguments, and then we'll be hearing then there will be arguments from the Gore camp. Now, there are 3 separate questions that are being presented to the court today, and these were framed by the brief put together by the Bush team. Now, question number 1 in the case of George W. Bush versus the Palm Beach County Canvassing Board is whether the Florida State Supreme Court, in resetting the deadlines for counting ballots to December 5th of this year, as opposed to 7 days after the election, violated either the Due Process Clause of the United States Constitution or the Title III of the United States Code, Section 5 of Title III. Brian Wilson, let's talk about that very first issue. 3 U.S.C. Section 5.
It is basically a piece of law that says that when you have an election and you count the votes, you have to count the votes under the rules that were in effect at the time of the election. And as we mentioned earlier in this broadcast, it is a result of the Hayes-Tilden election way back, where there was all this rampant accusations of fraud and wrongdoing. And the United States Congress came forward and wrote this piece of law to say, look, you can't change the rules after an election has taken place. You have to count those votes under the rules that were in effect at the time the election took place.
Okay, that election, for those of you keeping track, was in 1876. Now, Andrew Napolitano, let's talk about also one of the other parts, which is the Bush team is not only saying that this violates that federal law, but also the Due Process Clause. Talk about that for us, will you?
Well, the Due Process Clause has 2 components. One is procedural, that you have to follow proper procedures. The other is substantive, which basically means fairness. The Bush team is arguing under the substantive part of the Due Process Clause, which basically argues that it is unfair to change the rules after the election because no one could have known what those rules were going to be, and the election was held and contested under rules that are no longer in existence. And the Supreme Court of the United States doesn't like to invoke the Due Process Clause to say something was unfair, but it has done so. And in fact, it has done so recently when a state court has stopped a state executive official from enforcing a law. The Supreme Court has found that is unfair, violates substantive due process, and they're going to interfere with it.
Now, let me ask you, Andrew, could it not also be argued that the failure to count every vote, which is what the Gore team is arguing for, also could constitute a violation of due process?
Oh, absolutely, and that argument was made by Professor Tribe in the brief that he submitted in behalf of the Vice President. So that's one of the reasons that the Supreme Court does not like to go with the argument of substantive due process, read fairness, because there's 2 sides to every coin, unfairness. They don't like to get into that kind of a squabble.
Substantive due process is also legal jargon for the court going in, seizing the Due Process Clause and using that as an excuse for judicial activism. The substantive due process first flared up under the courts appointed by Franklin Roosevelt and later became a concern under Chief Justice Earl Warren and subsequent courts.
Tony, I'm smiling because you get an A+ in my constitutional law class. That is an absolutely perfect rendition of American Supreme Court history.
Okay. Now, the question here, question number 2, did the Florida Supreme Court violate the United States Constitution, in particular Article 2, Section 1, Clause 2, which provides that electors shall be appointed by each state, quote, in such manner as the legislature thereof may direct? Brian Wilson.
Well, this is, of course, the U.S. Constitution, and it seems on its surface to be very clear-cut. I mean, you read that line, each state shall appoint electors in manner as the legislature thereof may decide. You would say, that's it. Okay, well, nothing hard to decide here. But what is at the real core of this argument and this debate today before the Supreme Court is the law written by the Florida legislature. The Florida legislature wrote a law that the Bush camp says is very clear, but the Gore people say, let me read this from their brief. The Gore lawyers argue that the Florida Supreme Court was, quote, applying familiar principles of statutory construction to resolve the textual ambiguities and gaps in the Florida election code. That has been their core argument, that basically you look at the law written by the state legislature and it's vague. That's their argument. And so the Florida Supreme Court had no option but to go in and try to resolve the vagaries of that that election code.
Okay, now Andrew Napolitano, let's try to sort through this. I need your help. The Gore team is arguing that there were, quote, ambiguities in the Florida election statutes. The ambiguity, though, arises, does it not from Florida statute, but from federal statutes. Florida statute says you got to turn in your ballots, you got to certify them 7 days after the election. Federal law, actually a consent decree entered into with the state of Florida, says no, you got to wait 10 days to count military ballots, or you at least have to accept those till 10 days after the election. Number one, is there ambiguity in Florida law?
There is some ambiguity in Florida law, Tony, because one of the statutes says votes submitted after the deadline shall be rejected by the Secretary of State. Another statute says votes submitted after the deadline may be rejected by the Secretary of State. Now, ordinarily, one would think that that would give the Secretary of State discretion as to whether or not to reject them. And as we know, she did reject the Palm Beach County votes because they weren't able to get in under the deadline. The Gore team is arguing that all the Supreme Court of Florida did was reconcile the conflict between those two statutes, and it only did what judges do, which is interpret the law. The Bush team is arguing that, yes, they did interpret the law, but they made such a drastic change, extending the date by which votes are due to the Secretary of State, that it constitutes writing the law. And the Constitution of the United States says only the state legislature may write the law. So that's the thorny issue that the U.S. Supreme Court is going to have to resolve today.
Okay, Judge, number three, we're going to hit this very quickly. The court asked, when it accepted this case, for the respondents, the Bush team, to give a proposed remedy and also tell what that might mean. The proposed remedy is to reverse the Florida State Supreme Court. What would be the implications of that move?
If the Florida Supreme Court decision is reversed, legally there would be no implication because the hand counts have already been submitted and George Bush has been certified the winner. Politically, there may be an implication because it'll cut a lot of ground out from the vice president and he'll lose a lot of support. Flip side of that, if the Florida Supreme Court is upheld, legally there will be no implication except that the vice president will have some political momentum because they'll be able to spin this decision as, see, the Florida Supreme Court was right all along.
Okay, gentlemen, we're going to take a break and stay with us because one of the things we're going to do in our pregame show is to talk about the lawyers. We'll do that right after this break.
Presentation of the awards of the Academy of Motion Picture Arts and Sciences is always a distinguished occasion in Hollywood. Producer Darryl Zanuck and Mrs. Zanuck and Wendell Wilkie discuss movie affairs. Linda Darnell and Cesar Romero are among the film stars in attendance, as are Betty Grable and George Raft. Donald Crisp and Mary Astor are acclaimed for the year's best performances as supporting players. For the best acting by stars, Joan Fontaine and Gary Cooper get what Hollywood calls the Oscars. Top honors for producer go to Darryl Zanuck, award presented by Walter Wanger.
Colonel Zanuck, it's indeed a pleasure to be able to present you with this award for the most distinguished picture of the year, How Green Is My Valley, a picture which has brought great credit to the industry and to Commander Ford, who made it, and you, who produced it.
Thank you very much, Mr. Wanger. It's a great pleasure to accept this award for the entire 20th Century Fox studio.
USS Tuscaloosa with President Roosevelt aboard. Lower the boat with the president in it. A Canadian visit putting ashore at Campobello Island in New Brunswick. A favorite vacation stop for the president on summer cruises in northern waters. Congressional wrangles are over for a while, so away from the Washington heat. But there's always a press conference. The newspaper correspondents ask their questions, even though it's presidential vacation time. A serious answer.
They're Mr. and Mrs. Franklin D. Roosevelt Jr. as the interview draws a jovial answer.
You see the United States Supreme Court, and right now there's really an interesting atmosphere here. You've got a lot of protesters milling around. We've been told that the Reverend Jesse Jackson may be holding a press conference. You may have seen in the past people walking behind us waving placards, and a couple of minutes ago some guy whistling Rudolph the Red-Nosed Reindeer so loud that we could barely think. In any event, there's all sorts of pageantry taking place, free speech being exercised exuberantly here outside the Supreme Court. Meanwhile, inside, if we are looking, if the Supreme Court is adhering to the schedule it laid out, the Bush team has completed its oral arguments, or at least its preliminary oral arguments. Ted Olson, who is the lead attorney, started off today's deliberations, followed by Joseph Clark, who is arguing on behalf of Florida Secretary of State Katherine Harris. Let's first go and talk a little bit about the attorneys, the cases they're going to make, and so on. I'm going to begin talking with Brian Wilson here. Let's talk about Ted Olson.
Ted Olson, a very interesting guy. He's a local figure here in Washington, a man who knows a great deal about constitutional law, has argued many constitutional cases. He's with the firm of, Gibson, Dunn, and Crutcher here, and has been since 1965. Interestingly enough, we found a little interesting tidbit about Ted Olson yesterday doing our research. He was actually hired at one point by ABC News to help advise ABC News as they were trying to secure that interview with Monica Lewinsky. Mainly, he was apparently some kind of expert in immunity law, and as you know, Monica Lewinsky had been given a grant of immunity, and so he was involved in those negotiations. Just an interesting side note, a man who is definitely well known in this town and admired for his legaling skills.
And Ted Olson, also Andrew Napolitano, is himself part of a famous Supreme Court opinion as well regarding independent counsels.
Yes, he is. The case is called Morrison against Olson, in which when Ted held the job in the Reagan administration that Justice Scalia once held, which is loosely translated the chief advisor to the Attorney General, he was prosecuted by an independent counsel, and he challenged the constitutionality of the Independent Counsel Act, and he lost. He was ultimately never indicted, so he was never truly prosecuted, but the case stands for the proposition that that independent counsel statute, Morrison v. Olson is the case, is constitutional.
Okay,
Justice Scalia dissented, by the way.
In addition, we're going to hear from Joseph Clark. A lot of folks have seen him before. He's a sort of a white-haired fellow who argues on behalf of Florida Secretary of State Katherine Harris. Any comments, Andrew?
I'll tell you, I watched Joe Clark when he was before the Supreme Court of Florida and when he was before Judge Sanders Saul. This is a fellow who really knows Florida law. He may not have the spit and polish of Larry Tribe or Ted Olson, but the Supreme Court likes people like Joe Clark because they really do not know the intricacies of Florida law, and they probably, when he's up there, will ask him to help them understand how the laws came about.
Okay, Andrew, I don't know if you guys can see it, but just over my shoulder, Reverend Jesse Jackson is leading a little procession down First Street here in Washington, right in front of the Supreme Court. As we told you, it's a day of great pageantry, and so now you see an organized protest that's making its way all the way past the Supreme Court, across the vast lawn of the United States Capitol here. And Jesse Jackson will, in fact, be holding a press availability in just a couple of minutes.
A very large crowd coming down the street, kind of a surprise maneuver. Most of the protesters have been in place since early this morning, holding up positions in front of the Supreme Court. Jesse Jackson making, as he often does, a dramatic entrance here during these.
Well, as I said, folks, this is a bit like the jurisprudential equivalent of the Macy's parade, and so now
I'm expecting the big balloons at any moment.
We don't have any big floods, but we got lots of signs. And the chief allegation on both sides is that the other person wants to steal the election. And so the Supreme Court is going to have to try to straighten this out. Maybe it will, maybe it won't. We're going to take a quick break. When we return, we'll talk about the lawyers who are representing Al Gore.
camera highlights in the world of sports. Kentucky's great day when America's sporting spotlight is trained on Churchill Downs and 65,000 spectators forget for a moment the martial mood of wartime as bluegrass tradition and mellow Stephen Foster strains proclaim the running of the 68th Kentucky Derby. Attending notables include Mr. Samuel D. Riddle, Kentucky's Senator Happy Chandler. There's Jim Farley escorting his daughter Kitty. 3 governors, and they're not talking politics, you may be sure. Cooper of Tennessee, Johnson of Kentucky, and Dixon of Alabama. Mr. and Mrs. Warren Wright, whose Whirlaway won the Derby last year. 20th Century Fox star and Mrs. Don Amici. And Colonel Matt Wynn proudly presenting to Mr. Charles Allen a $50,000 check, the gift of Churchill Downs to the American Red Cross. But now they're at the post, and they're off. 15 of the year's crack 3-year-olds in the mile-and-a-quarter classic test. The purse more than $86,000, the richest in Derby history. Here in the rush past the stands, With Regards leads the field. Then Valdina, Orphan, and Dog Patch running head-and-head. Shutout coupled with Devil Diver in the Green Tree Stable entry running 4th and 5th. And so they go in their thundering stampede toward the turn. The throng even now unaware of a standout. In the run down the far side, Alsab comes to life. With jockey James aboard, the Bay Colt moves from 8th to 6th to 5th to 4th. In the stretch turn, With Regards is weakened, shut out in front. Valdina Orphan second. Alsab on the outside, overtaking With Regards, and there you have the big 4. The others all but lost in this fighting stretch duel. Less than a 16th to go in this heart-throbbing run for the Roses. Shut out a good length and a half out in front. Valdina Orphan and Alsab in a battle for second. With Regards on the rail, now running 4th. Shut out the winner. Alsab second by a stride. The Orphan third. As Shutout garners the lion's share of more than $64,000. And that rose-scented laurel, the greatest glory that can come to a 3-year-old.
Before the turn of the century, Connie Mack turned to managing the Philadelphia Athletics and found it a steady assignment, this year completing his 50th season in that capacity. An all-time great among big league pilots, Mr. Mack won 9 pennants and 5 world championships. Yes, he could show anyone how to play the game. A typical pose was his dugout scorecard wagging to move his players defensively. The patriarch of baseball, in an exclusive interview, hangs up the spikes and turns the Philadelphia A's mantle over to Jimmy Dykes.
I'm not retiring from baseball. As manager, at 88, I feel that a younger man should have the position.
I'm Tony Snow sitting outside the United States Supreme Court. There you see a shot of a street demonstration that has been proceeding past the Supreme Court in recent minutes. It's sort of quieted down. There were a lot of people screaming every vote counts a couple of minutes ago, but now folks are just kind of milling around, either waiting to figure out what they're going to say next or maybe waiting for the Reverend Jesse Jackson to hold forth in a press conference. In any event, we wondered some time back why there was a squadron of motorcycles. Now we know there was a police escort helping the protesters onto First Street behind us, and now they're just kind of waiting for people to move on. But it gives you a sense, again, of the weird pageantry. Folks, we haven't had a case like this of this kind of magnitude before the United States Supreme Court, certainly since the Nixon era, and never one that had so much impact on a presidential election. Now, before the break, we were talking about the legal guns who are in the courtroom representing Team Bush. Now we'll talk about Team Gore's representation. And let us start first with Paul Hancock. He is the attorney who's representing Bob Butterworth, who is the Attorney General of Florida, who has issued opinions contrary to those of Secretary of State Katherine Harris of Florida. Andrew Napolitano, what do you know about Paul Hancock?
Well, this is a very interesting situation here involving Paul Hancock. It is rare that the Attorney General of a state, when given the opportunity to argue before the Supreme Court of the United States, will assign it to one of his deputies, but that's what happened here. I don't know if there's some political interplay because Bob Butterworth is one of Jeb Bush's closest friends, even though Bob is a Democrat and Bob was the co-chairman of the Gore campaign. But Hancock is the opposite number to Joe Clark. That is, he is the local Florida lawyer who is the expert in Florida law that will be able to answer questions from the justices of the Supreme Court when they want the Democrat understanding of how these laws came about. So, again, the court likes to have people like Hancock there to help them out.
He was in the Justice Department at one point, and one of the things that I found in looking into his background is that he was a civil rights lawyer there, and he has a great deal of federal experience as well, so I'm certain that's why he probably has been brought onto this team.
Well, his time is, again, if we're watching the clock, and we're told that Chief Justice William Rehnquist does that with particular care, his time's just about up, and right about now, Lawrence Tribe of Harvard Law School, who has stood before this court 29 times, is making his arguments. Tell us, Andrew, a little bit about Lawrence Tribe and his courtroom style.
Lawrence Tribe is, without question, the foremost scholar and foremost authority on the United States Constitution in the United States today. The treatise that he has written is probably on the bookshelf of every federal judge and certainly on the bookshelf of all the 9 justices. He tends to be a little pedantic and a little condescending in his oral argument. In fact, it has been said that if Al Gore became president, Tribe would certainly be on the short list. And if he actually got on the Supreme Court, the battles between he and Justice Scalia, who are intellectual opposites, would be fantastic for students of the court to study for many years.
Lawrence Tribe is probably one of the brightest people on the planet. You have to give him that. I look through his background and I find that not only has he got like law degrees out the yin-yang, he's also, his first degree was not in the law at all. He graduated summa cum laude in mathematics from Harvard. So he started as a scientist and then moved into the law later. A very interesting fellow. You are exactly right, Judge Napolitano. Often talked about as a possible member of the Supreme Court under a Democratic administration.
Okay, now we have been trying to figure out, of course, what's been going on inside. Rita Cosby can shed a little insight. She's standing by with a student who had a little bit of time inside the courtroom. Rita?
Yes, hi, Tony. I'm here with David Bolad, who's a student at Georgetown University, International Politics. You were one of the luckiest people in America today. You just came back from out. You were inside how long?
I was in there for about 20 minutes.
What was it like inside? Tell us what's going on.
I would describe the whole process as dignified. I mean, I think everything we've seen so far, at least from the justices, you can see that the democratic process is working. And as a student of foreign relations and of international politics, that's very rewarding to see that our democracy is working.
Tell us, were the justices asking a lot of questions? Did you see the Chief Justice William Rehnquist intervene, ask any questions?
The Chief Justice didn't really take the lead. Mr. Souter actually took the lead on most of the questions in questioning the Bush team, and he was asking some very pointed questions to the Bush team.
What type of questions did you hear him ask?
He was really asking about whether or not the Secretary of State really had the right to go over basically the Florida Supreme Court, whether she had the jurisdiction to call the election. And I mean, basically the question that's on all of our minds.
And what type of answers did you hear from Ted Olson, who's obviously the lead attorney there for the Bush camp?
I think they're still trying to coordinate their attack, because every time he would try to point to one section of the Constitution, they would say, no, actually that has nothing to do with this. Tell me exactly how it has to do with a federal court intervening with a state process. And so I think they were really looking at it from a states' rights perspective, as this court has done in the last 10 years.
And now, when you were in there, did we get a chance at all to hear from the Gore attorney, Lawrence Tribe? I know he should be up at this moment. Was he up when you were there?
No, he was not. Actually, it was just the Bush team at the time. So I don't know if it's accurate to say that it was just the Bush team that was getting pointed questions, because I imagine that the justices will be asking critical questions on both sides.
I'm sure they will. Also, give us a sense of the scenery in there, the mood in there. Is there a sense of gravity? Because this is obviously one of the most important cases, if not possibly the most important case before this court.
I mean, I think that you could cut the tension in the air with a knife, but I mean, there was a moment of laughter at one point, kind of legal humor, if you will. And but like I said, I think the atmosphere is dignified, and like I said, that's very satisfying.
All right, David Bolad, thank you very much, and congratulations for getting one of those lucky seats inside there. And David Bolad, you told me you were waiting in line for 23 hours just to get a chance to get a first-hand look at history. Back to you, Tony.
All right, Rita, thanks. We're going to take a break, folks, but word is starting to trickle out about the kind of questioning that's taking place inside the Supreme Court. We'll have some updates for you in just a couple of minutes.
10:30 Sunday morning, I noticed a car parked on that hill, a man and woman in it. I never paid very much attention to it. They were fooling around the car like picnickers on an outing or hunters or something. And I went to haul rocks on that hill up there, and I was right at that orchard about 30 feet from the car. And I could see the clothing. The woman was dressed in a brown suit, and the man had on a blue shirt, khaki riding breeches.
And here's the notorious couple Farmer Schieffer says he saw. Bandit Barrow and his girl companion, Bonnie Parker. These photographs of the outlaws are being circulated by the police through the Southwest to aid in their identification. The girl always carries at least 2 guns. With Barrow, she's accused of another killing after that of the motorcycle cops that Schieffer describes.
One was standing on either side of the car. They reached down and got the gun and came up when they was about 10 feet away and says, boom, 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 boom. With automatic shotguns. The man on the steering wheel side shot the man in front. The one on the other side shot over the radiator and shot the man in the rear. The man in front fell flat on his back. The other man sort of spun around and fell with his face down the other way.
To Hollywood after their surprise elopement to Las Vegas, Nevada, these newlyweds aren't a bit camera shy, which isn't surprising when you consider who the lady is. Filmland's own Joan Crawford, a screen favorite of many starring roles. And Joan has evidently broken hubby to the camera. He's Al Steele, an executive for a soft drink distributor. But he displays a nonchalance before the cameras worthy of a film veteran. Congratulations and best wishes from Movietone.
About 2/3 of the way through the United States Supreme Court's hearing of the arguments in the case of George W. Bush versus the Palm Beach County Canvassing Board. Early reports indicate, as Rita Cosby just told us, that the justices were closely grilling Theodore Olson, the attorney of record for the Bush team, about why this should be a federal case at all, asking why this should not properly fall under the jurisdiction of the Florida State Supreme Court. Judge Andrew Napolitano, we don't have names yet. We know that Justice David Souter was one of the people doing the questioning. If it follows this line, can we interpret anything from it?
Well, Justice Souter is at times part of that middle that consists of, in addition to himself, Justice Kennedy and Justice O'Connor. That may very well indicate a view on the part of the middle that this is not a matter to be heard by the United States Supreme Court, either because it is moot, because George Bush has been certified by the Secretary of State as the winner of Florida, or because this is truly a state matter. But again, I caution everyone not to try and read the tea leaves. Sometimes justices will grill more aggressively the lawyers in whose favor they're going to vote just to test the adequacy of the opinions they're about to write. So we don't know.
Yeah, that's exactly right. I mean, the Supreme Court, when they ask questions, it is almost impossible to tell which direction they may be leaning. I have been in the Supreme Court hearing arguments in cases, have seen some very detailed and very sharp questioning of the lawyers in the case, and you walk out of there thinking, oh, it's all over for those guys. They haven't got a chance. And as it turns out, the ruling ends up going the other way. And that's because they want to get as much information as they can. That's the purpose of this questioning. Particularly, Antonin Scalia asked very sharp questions, very pointed questions, but you cannot draw from the nature of those questions the way he is going to ultimately rule. They all take this information, they go into a room, and they hash it out. And that's where the interplay of the Supreme Court and the group dynamics come into play, and things can change dramatically based on what one justice says to another during these meetings.
But Andrew Napolitano, one of the first things that happens is they go in, they basically take a tally, and the Chief Justice starts assigning opinions, correct?
Yes, they take a tally starting with the junior most justice, the Chief Justice speaking last. And then they'll know if they're unanimous, then the Chief Justice will assign one person to write the opinion. If they're in two camps, then whatever camp the Chief Justice is in, if it's the majority, he'll assign. If he's in the minority, then the senior person in the majority camp will assign who in that majority camp will write the opinion. And they'll make that decision probably by mid-afternoon today. But what you should understand, and I agree entirely with what Brian said, oral argument is not a game, and it's not a contest as to how much the lawyers know. It is an opportunity for the justices genuinely to get questions answered, questions that they have in their minds as a result of the briefs that they have read.
Okay, Andrew, I'm going to break in here for a second because we have breaking news, which you can see there on your screen. Colombian police, that is police in the nation of Colombia, evidently have thwarted an attempt to assassinate U.S. Senator Paul Wellstone and U.S. Ambassador Ann Patterson. As you may or may not know, one of the things that's been going on here in Congress in recent years is an attempt to try to thwart the drug trade in Colombia. As a matter of fact, President Clinton last year signed a bill that allows U.S. military to go down and try to train Colombian troops in the drug wars there. This may or may not be related. Obviously, as we learn more about that story, we'll bring it to you right away as well. Now, we were talking just a second ago, Brian, about, again, the kinds of stuff that goes inside the Supreme Court. I want you to pick up from where Andrew left off.
Well, inside the Supreme Court, it's really hard to know what goes on. I mean, this is still such a mysterious organization. We know a lot about how other courts operate. We saw, for example, very publicly how the Florida Supreme Court operates, but they don't do things the same way here. It is a very closed society. People are sworn to secrecy when they work here. We don't know a great deal about what happens once they go into that room, they close the door, and they start to hash it out. It's a very mysterious process. Clearly, the group dynamic comes into play. There is great reverence given to the Chief Justice of the United States, William Rehnquist, as the man who is ultimately leading the group. But really what happens there is something of a mystery to many, many people.
Okay, as a matter of fact, people are pretty much sworn to silence. A few years ago, somebody wrote a book called The Brethren about the inside machinations of the court, and that created quite a stir. In any event, Rita Cosby is standing by with more people who have been inside the courtroom. They can shed a little more light on what's been going on. Rita?
Hi, Tony. Well, of course, the situation inside is progressing. We're now finding out now that obviously Al Gore's side is now presenting its case inside the U.S. Supreme Court. And here to tell me a little bit about that is Don Serrata. You're a fundraiser from the University of Maryland.
That's right.
You were one of the lucky ones inside for just a few moments. Tell me what you saw when you were inside.
I saw the Attorney General of the state of Florida delivering his argument, and
That is Paul Hancock, the attorney?
That's right. And the justices were asking him a number of questions, redirecting, and so on.
Tell us what type of questions were being asked of him.
Well, I remember the questions were really more statements than they were questions. Justice O'Connor said to him that the legislature made a very dramatic change in the change of the date from the original certification date. And I also remember that Justice Scalia was discussing with him the voters' intent and the fact that what the problems were really made by voter error.
What type of responses were you hearing from the attorney?
I must say that I felt the Attorney General's responses were very timid. He basically agreed with the justices, even though I thought the justices' arguments did not affirm the Supreme Court's stance.
Were you there during Ted Olson, who's the attorney for Bush? You were not in there for that.
I was not.
Were you able to see Lawrence Tribe, who's the attorney for Gore?
No, I only saw the Attorney General for the state of Florida.
Tell us about the mood in the courtroom. Somber, grave, very intense. Obviously, this is really a moment in history.
Right. Well, it's very somber. People are respecting the court, and in fact, the marshals are in the courtroom, so no one really has much choice but to just sit quietly and pay attention to the proceedings.
Now, you were one of the lucky ones to get inside. Tell us your strategy for doing that.
Well, I just tried to get here as early as possible. I understood that yesterday, I live in town. I live only a few blocks away from the Supreme Court, and I understood that yesterday there were only about 25 people in line at 2:30.
So what time did you get in line?
4:30. Okay. And by 4:30, there were about 100.
Okay, so you waited in line over 24 hours?
That's correct.
All right. Well, Don Serrata, was it worth the wait?
most definitely. It was wonderful.
All right, Don Serrata, thank you very much. Obviously an indication that right now Lawrence Tribe is up presenting the case for Gore. Back to you, Tony.
Okay, thanks, Rita. We probably need to remind folks that a lot of those people who come in get exactly 3 minutes inside the courtroom, then they get shepherded back out. In any event, we are going to be back with more on the arguments inside the Supreme Court and also updates on an attempted assassination today of the U.S. Ambassador to Colombia, Ann Patterson, and U.S. Senator Paul Wellstone. Stay right here.
At the Massachusetts General Hospital in Boston, a revolutionary advance in making X-ray pictures is successfully tested. Using the recently evolved Polaroid film, which can be developed without liquids and the conventional darkroom, the hospital experimenters achieve a miracle in speed, cutting the time of making and developing a print from 45 minutes to 60 seconds. It will be a boon on the battlefields. Doctors can carry the little developing boxes anywhere to quickly determine the seriousness of wounds from graphic, clear 10x10 prints like this.
Baseball history is made at Seal Stadium in San Francisco, the first big league baseball on the West Coast. Managers Bill Rigney of the Giants and Walt Olson of the Dodgers pose in pregame ceremonies. Starting pitchers Ruben Gomez and Don Drysdale. Here, too, are Mrs. John McGraw, wife of the legendary Giant manager and Commissioner Ford Frick and League President Warren Giles. Historic. And so, too, is the eloquent silence of Ebbets Field in Brooklyn with its colorful past. But now, empty stands. The Polo Grounds, a home of great champions and Giant baseball achievements. But now the old sod is going to seed. In the Giants' new home, San Francisco, new Giant fans crowd the stadium and surrounding trees. Inside, Mayors Paulson and Christopher of Los Angeles and San Francisco indulge some hijinks to the amusement of the spectators in pregame activities. There's a mayor running the wrong way. And when the game gets going, the Giants make this dawn of a new era in their long history an auspicious beginning as they trounce their longtime rivals, erstwhile of Brooklyn. The Giant-Dodger rivalry, one of the keenest in all baseball, transferred in toto to the West Coast. Final score, San Francisco 8, Los Angeles nothing.
Well, it's quite a scene outside the United States Supreme Court here in Washington. There you see the court building, but also protesters aplenty milling around in sidewalks and on the streets. We saw a young woman with a guitar trying to serenade crews from another network a moment ago. They didn't seem all that interested in singing along. In any event, let me give you a quick update on a breaking bit of news, and then we're going to go to Rita Cosby, who's good enough to be roping in observers so we can get a sense of what's going on. Let me also remind you that in just about 25 to 30 minutes, we'll actually be getting the audio tapes of the arguments before the court today, and we'll be supplying commentary as well. Now, as we reported not too long ago, earlier today, Colombian police thwarted an attempt to assassinate U.S. Senator Paul Wellstone of Minnesota and U.S. Ambassador to Colombia, Ann Patterson. Senator Wellstone and Ambassador Patterson were evidently in a motorcade in Colombia. Now, there were landmines evidently placed along the side of the road. Each of the landmines were said to carry a 6.6-pound explosive charge. In other words, 2 kilograms or 3 kilograms. They're attached to cables and a detonator ready to be sent off. It was, in any event, that is basically, there were shrapnel-wrapped landmines. And as we said, Colombian police managed to head that off. Senator Wellstone's office, we contacted them. They didn't know any more about it than we do. They're reading the same news on the wires. And we'll keep covering that story as the day continues. Now, Rita Cosby, as I said, has been grabbing people as they come out of the courtroom with updates on the action inside. Rita, let's go to you.
All right, well, Reverend Greg Appelian, he is from Rio Rancho, New Mexico, and he actually just left. You were inside the courtroom for, what, about 15 to 20 minutes?
About 15 to 20 minutes. It was unbelievably invigorating to walk up the steps and to see democracy in action, this crowd out here. Everybody's concerned to make sure our votes are heard in this election. I think that's really what's at stake, is to make sure the people are the ones to decide who the next president is.
Tell us what you saw inside. Who was asking questions? What kind of answers you were hearing?
Well, basically, we heard some interchange between some of the conservatively appointed judges, and it was heartening to hear that they were leaning on the Constitution. They were leaning on the Constitution of Florida, and basically, it seemed to me, from what I heard, that it was going to be deferred in that way, to let the Florida system handle it. I could be wrong, but that's the sound I was hearing in the courtroom.
What type of questions were you hearing specifically from specific justices?
Well, I think even more interesting than the questions was the fact that what you don't get to see from not having cameras in there is the posture, the human side of this. You had Justice Scalia, who was so far slumped back in his seat that all we could see was his eyes over the bench.
But asking lots of questions, as always.
Oh, yes, he was very active in the questioning. And again, it was pursuant mainly to the constitutionality of it under Florida law and whether or not this case was subject to their interpretation or not. So it really seems to me that they were grilling both sides on the question of whether or not the issue was for them or for Florida to decide.
Now, you were lucky you were in there, you said about 17 minutes, so you did get to hear questions asked of both sides.
Right.
Did you see a difference in the way that the justices were handling Ted Olson, the Bush attorney, and then Lawrence Tribe? And actually, you were there for the Attorney General,
right.
Paul Hancock, the attorney representing the Florida Attorney General. Did you see a difference in the way they were being handled by the justices?
I wouldn't say there was a marked difference. I would say that they were both being treated equally, being pressed on the issue of why are we hearing this? Let us know, why are we the ones to be hearing this now? And I had a chance to actually file a pro se brief of my own in this case that was co-signed. And in it is the constitutional issues. I just cite the Constitution. So it was heartening to see the justices sticking to the constitutional issues, because if they do that, like it says on this building, equal under the law, that's the big issue here, that the voters' voices be heard and not just pushed aside.
All right, Reverend Greg Appelian, one of the lucky ones inside. Thank you very much. And just to point one thing out, you did fly all the way yesterday. You told me, right? You flew in from Rancho.
No, I drove. I drove across country, as a matter of fact.
He drove across country from Rancho Rio, New Mexico, to come here for this moment. Came in yesterday, waited in line for many, many hours, but one of the lucky ones who got to be inside and was inside for 17 minutes. Back to you, Tony.
All right, Rita, thanks so much. Now, we're going to try to read the tea leaves a little bit. As we've been telling you, as soon as the oral arguments are concluded, and that's in a little more than 15 minutes at most, then we expect to be getting audio tape, and we'll be doing commentaries on that. But Andrew Napolitano, observers seem to be saying that the issue on which the justices are most interested is whether this is an issue for them to consider at all. And we talked about this at the beginning of the broadcast. You sort of thought that's the way this might be headed.
Well, I did, and I do so for two reasons. One, because this court has a tradition of deferring to state courts, and two, because the Supreme Court, this court and its many predecessors, have had a tradition of not hearing matters that are moot. And remember, the ballots that George Bush wanted to stop counting, wanted this court to order stop being counted, have already been counted, and he's prevailed, so they may very well decide that this is moot. They may want to inject a little federalism in this. On the other hand, there's a doctrine called preemption. That's what the court has to look at when there's a direct conflict between a federal statute and something a state has done. And in the area of preemption, this court has not deferred to the states. This court has consistently upheld the priority of federal law. Finally, we can't go by the questioning, because these justices just are expert at not revealing what they're thinking.
Judge, do you think it's basically coming down to a debate over states' rights on one side versus judicial activism on the other side? These are two issues the court has often been very concerned with.
Yes, I think you're right, because these justices who realize that they sit in the seat that the giants of American history have sat in, who have lifetime tenure, it's hard to say this, but I believe it. They are not looking at this as resolving an election contest in Florida in December in the year 2000. They're looking at this from the point of history. And they know that historians, scholars, justices who will replace them, lawyers and law students will study every word, not that they say in the courtroom today, but that they write in their opinion. And it's from the long view of history that they will make their judgment.
Well, gentlemen, at this point, we have a short view across the street of the Supreme Court, and within about 10 to 15 minutes, we're actually going to be hearing these arguments, and we'll try to make more sense of them then. We're going to take another break. We'll be back with Judge Andrew Napolitano, Brian Wilson, and our cast of reporters in just a couple of minutes.
South Bend, Indiana, animated symbol of Notre Dame, flashing true mid-season form today at the expense of Illinois. There's Stevenson, fighting Irish wingback on a sweeping end run of 13 yards to a first down. Zontini, on another gallop around the flank of the line, penetrates further into Illini territory. These Irish are really on the wing today. Undefeated and untied, they point to national recognition. Notre Dame's ball again to Stevenson, who fades. Let's go, a looping pass to Brown, standing on the goal line, and that, my fellow quarterbacks, is how touchdowns are made. Notre Dame leads at the end of the first quarter, 7-0. Tonelli, Notre Dame fullback, provides a third-quarter thrill when he snakes his way through the Illinois secondaries, walled in, laterals to Sheridan, who mops up everything in his path, including the water bucket. Defensively, it seems, these Irish are equally as strong, as Wardley of Illinois proves in a frantic attempt to penetrate the Notre Dame line. But the payoff play of the day finds Illinois kicking to Sheridan, the Irish left halfback, who takes the ball on his own 30-yard line. And folks, we give you a lad whose 70-yard broken field dash is just another reason why football fans go slightly nuts.
It's the National Open Golf Tournament at Marion in Ardmore, Pennsylvania. The huge gallery watches Lloyd Mangrum tee off. Kerry Middlecoff. Sammy Snead. Eye-filling golf as Ben Hogan drives. Kerry Middlecoff tries everything on this short putt to no avail. Hogan applies his skill to a long try. And, brother, that's tantalizing. But the terrific Texan plays steady golf and sinks him when he has to tie for the lead and qualify for the playoff round. Mangrum tees off in the playoff. George Fazio. Ben Hogan. Bantam Ben on the comeback trail from a brush with death plays a cool and calculating game. On the verge of his second Open title. Par 69 to win the fourth three-way tie in the tournament's 50-year history. $4,000 goes with this trophy, enough for Ben and his wife to celebrate in championship style. Nice going, Ben.
Let's set the scene here outside the United States Supreme Court. I'm Tony Snow, joined by Brian Wilson. We're also joined by Judge Andrew Napolitano in New York. Now, it has occurred to a number of people around here that there might be some television cameras about. So we have protesters, in fact, the fellow over our shoulder, arguing for a recount, screaming, "Play it again, Sam." You know, and these are the kinds of
America.
Only in America.
You know.
So we've had strolling minstrels, we've had marchers, and we have people also responding to the muse inside their heads or their feelings or whatever else. So,
that's the great thing about this country is that, we have a free and open discussion. And if you've been in Washington any time, as I know you have, and I've been here about 15 or 20 years now, you see these kind of protests and you come to appreciate how wonderful it is that in this country you can have that, when in many other countries it is just simply not allowed. It's pageantry, it's interesting, and it's colorful, and it's democracy in action.
And the other thing we have, I'm going to cut you off for a second, Andrew, because Rita Cosby has yet another courtroom observer to give us an update. Rita?
Well, Tony, I have Congressman Brad Sherman. He's a third-term Democratic congressman from Sherman Oaks, California. You were one of the lucky ones who actually didn't have to wait in line, but you actually had a designated seat inside. You were inside for, what, about an hour and 15 minutes?
Yes, I was, and I came out to speak to you and hopefully my constituents as well.
Give us a sense of what's going on inside. What is the mood and what did you see?
It's a very serious mood, very tough questions, particularly of all the justices asked tough questions of the lawyer representing the Bush campaign. And the thinking was that maybe there is no federal issue here, or at least no federal issue to be decided by this court at this time.
Did you get a sense based on that where it's leaning? Or sometimes, obviously, a lot of times the questions that you hear from the justices don't indicate where they're going at all. They're just questions that they want to have resolved or ones that they want to show the other justices answers on.
Well, the biggest decision was one made last week by this court when it decided not to look at the equal protection claims being made by the Bush campaign. In effect, the court said, you can have a recount. That's legitimate, and even if you're only recounting certain counties, that's legitimate. What the court is going to do with the questions that it has decided to review today is hard to determine, but I would say things are leaning in Al Gore's direction from what I saw.
Did they bring up anything about the Florida legislature? Obviously, that was mentioned in the briefs. The Gore camp is certainly opposed to the Florida legislature getting involved in this issue. Was that discussed in the chamber?
It's clear that the Florida legislature could have passed laws before November 7th, and all the justices recognize that could have vested power to select those electors in the legislature, or heck, even in the Supreme Court of Florida. It is by no means clear that the Florida legislature could do anything today to disenfranchise the people of Florida. The people of Florida have voted, and now it's just a matter of counting those votes.
And what did you hear, though, that the justices said regarding that issue?
They made it plain that the Florida legislature had the right prior to November 7th to decide how this election would be conducted and how a contest would be handled.
All right, Congressman Brad Sherman, thank you very much. One of the lucky ones who did not have to stand in line. And of course, we will hear from some more folks who did stand in line in a few moments. Tony, back to you.
Thank you, Rita. Also, the court is expected to conclude hearing arguments within about 5 minutes. We expect Theodore Olson, who is the counsel of record for the Bush team, to come out and speak to the press. We may also hear from Lawrence Tribe. We will carry all of those remarks. Also, late breaking news, the Bush legal team has a new filing down in Florida between Circuit Court Judge Sanders Sauls. They have said they have a dozen reasons why Judge Sauls should toss out Al Gore's challenge to Florida's presidential vote. Obviously, that issue will be taken up tomorrow when Judge Sauls holds a huge evidentiary hearing. He says that he'll go all day and all night if necessary until the last lawyer drops. Meanwhile, of course, the Gore team is before the Florida Supreme Court asking them to order officials to start recounting ballots right away. As we have said, arguments are wrapping up at this very moment before the United States Supreme Court. People who are involved will be trickling out. We'll be hearing it also within 10 or 15 minutes. We'll have an audio recording of the arguments today. Now, one of the things we're going to do is we're going to provide closed captioning, so don't be surprised to see words scrolling across the bottom of the screen. We don't know how good the audio quality is going to be. So if you can't really make out the words listening, you can certainly read along. In addition, we'll have photos or we'll have pictures, renderings, and other things to give you a sense of what's taking place. And of course, we'll have expert testimony from Brian Wilson and Judge Andrew Napolitano. Now, Judge Napolitano, let me just read you what we're hearing from everybody is that there was a lot of grilling from justices all across the ideological spectrum of Ted Olson about why this should be an issue in the first place. Your reaction?
Well, you know, it takes 4 votes of the 9 to accept the case. So there must be at least 4 of the 9 who wanted to hear it. And one of the mysterious things about the Supreme Court is they never have to state reasons as to why they're taking a case, nor do they have to identify the justices, the 4 who compel all 9 of them to hear it. But the 2 bases on which they could rule that this is not properly before them is that the whole issue is moot because George Bush has won Florida, or that this is entirely a construction and interpretation of state law. And the long-standing Supreme Court jurisprudence is the Supreme Court of a state has the final say on what a state's laws mean. So those are one of the 2 ways that they could be going if they are really tipping their hand and saying to Ted Olson, what are you doing here?
Okay, now we've got a little bit of bedlam around us. Just over our shoulder, we have some occasionally friendly disputations between Bush and Gore supporters, but it gets a little bit heated as well.
Interestingly enough, because passions do rise on this issue, and people feel very passionate on each side of the argument, it is interesting that it's been a rather peaceful crowd. There have been some pretty hot debates here on the sidewalk behind us in front of the U.S. Senate, between the Senate and the Supreme Court, but basically a peaceful demonstration throughout the morning.
All right, Brian. Well, we're going to take another break. The Supreme Court should be wrapping up its deliberations any moment now, and we're just waiting to get the audio tape so we can hear what went on inside. Stay right here.
From New York for her marriage to the Prince of Monaco, the beautiful Philadelphia motion picture star Grace Kelly is interviewed aboard the liner Constitution, producing a mob scene that must remind her of the movies.
Well, Jinx, as I said before, just getting married is a very big step for any girl, and of course, I have a great many feelings about that, and it's a very exciting thing, and I'm very, very happy. Of course, I'm a little sad to be leaving home, but I hope to be back quite often.
Almost all the Kellys are going except one, Lizanne. She can't make it.
My sister's expecting a baby the first part of May, and she's just heartbroken that she won't be able to be with me.
Miss Kelly, would you repeat for us the status of your citizenship now that you're going to Monaco?
Oh, when I'm married, I will have a dual citizenship. On marrying His Highness, I will become monegasque, but I will also retain my American citizenship.
Does that go for your children, too?
I don't know about that as yet.
Miss Kelly, how's your French?
Comme ci, comme ça.
Loveliest of the lovely, as seen here in the role of a non-competitor, she leads an Atlantic City beauty pageant. Marilyn Monroe is mourned by the world, particularly by a host of veterans of the Korean War. One of her many generous givings of her presence to beguile with her charms and divert with her humor fellow citizens, many of whom had a rendezvous with death. A symbol of all the girls back home, Marilyn's talent did not go unrecognized.
The Supreme Court hearing in the case of George W. Bush versus the Palm Beach County Board of Canvassers has completed. So the justices have heard the arguments. They're going to be retreating shortly to chambers and dividing up to figure out who's going to write opinions. If it's a divided court, you'll have a majority and minority opinion. If it's a unanimous decision, the Chief Justice, William Rehnquist, will assign the duty of writing the opinion to one of the justices. Rita Cosby, who has been grabbing people as they come out of the chamber, is standing by with somebody else who can give us a live update. Rita?
That's right. I'm here with Richard Leshner. He's a public policy student at George Washington University. First time in the Supreme Court?
Yes.
What was it like inside?
It was very humbling. I've never really seen proceedings like that with so many people so attentive and quiet and interested in with so intently. It's just, it's breathtaking and very difficult to describe the feeling.
Give us a sense of what type of issues some of the justices seem to be focused on. Was there sort of a question that may hinge this whole case on?
It seemed primarily to me that they were asking questions regarding the constitutionality of the Florida State Supreme Court's actions, specifically with respect to, I believe, Article 2 of the Constitution, and sections 5 and 15 of that article, and also whether or not the entire issue now is moot as a result of the certification of the election in Florida. Those seem to be the primary issues that they were asking.
Now, Richard Leshner, also, you're a public policy student at George Washington University.
Yes.
Why did you think it was important to be inside and see this moment in history?
Primarily because of the fact that I don't think there's ever been anything quite like this with respect to the elections in the history of our nation. I don't know when there'll ever be anything like this again. And it's also an important case with respect to separation of powers within states and federalism between states and the federal government, and all of that combined, notwithstanding the election results, is just too much to ignore.
Did you get a sense of which way the justices may be leaning? Obviously, that's hard to discern, but you were in there for grilling, I understand, on both sides.
That's correct. It was very difficult for me to tell. They were hard on both attorneys, and I could not really tell if they were leaning in favor of one or the other. I'm not a law expert, and so I couldn't tell if their questions were skewed, if they were anticipating particular answers and didn't get them, but they were very tough on both attorneys, all attorneys.
All right, Richard Leshner, thank you very much. Congratulations for getting that seat in history, a coveted spot. He waited in line from 3 p.m. Eastern time yesterday, but he said it was worth it. Back to you, Tony.
All right, thanks, Rita. Well, people are beginning to file out of the Supreme Court, and we are expecting, as we said, to hear from Theodore Olson, who is the attorney of record on the Bush camp, maybe also from Lawrence Tribe representing Al Gore. In addition, as we have said, we're going to be replaying the audio tapes. We've now been told that there are 5 audio tapes. Why do I say that? Because that means that Ted Olson, the attorney for the Bush camp, did in fact reserve a little bit of time at the end for a rebuttal period, so he wanted to get in the final word. Evidently he did. So we're going to bring all of those to you as soon as we get them. In addition, I just want to warn everybody who's watching, we're going to have these things closed captioned because we cannot vouch, certainly not at this moment, for the audio quality. So we're just going to make absolutely sure that if you can't hear it clearly, you'll be able to read it clearly, and we'll be able to give you a rendering on that basis. Now, I'm going to start again with Judge Andrew Napolitano in New York. Andrew, now we've heard a little bit about the sort of the human element. Rita was talking to a clergyman who said it was kind of, you miss the human element. You don't always get that reported. Antonin Scalia leaning back, so all you see is his eyes over the bench. Tell us a little bit from your experience sitting in on Supreme Court hearings about the kind of the pageantry inside the courtroom and that human element.
Well, the pageantry, it can be described in one word, in my view, and that is elegance. There is elegance and reverence for what the court does, but some of the justices have some quirky things that they do. We talked about Justice Scalia leaning way back to the point where you can't see him. Justice William O. Douglas, at times, used to turn his chair around, and the back of his chair would be facing the audience portion of the court. And he was a small man. You never even knew if he was physically still sitting there. That was his way of expressing an opinion without saying it of what argument was being made at the time. It was also his way of expressing an opinion of questions being asked by his colleagues. The young man that Rita just brought up really has a memory that will live with him for the rest of his life, because that human element can never be conveyed, in part, unless you're there. In part because of something Brian said earlier, which is mystery. Charles de Gaulle once said, probably referring to himself, there's no power without mystery. But the Supreme Court has been mysterious by hiding its most essential operations from the view of the public. So the little that you can see stays with you.
It is at least interesting that we're going to have this audio tape. We had asked, the members of the broadcast media had asked for cameras in the courtroom. Well, we practically knew there was zero chance of that happening.
Right.
But to get the audio tape is a break from tradition. Now, there are always audio tapes made of these sessions before the Supreme Court. And traditionally, they are held in an archive and reserved and held back until after the rulings are released, if there are some. Sometimes that's as much as a year before those tapes are released. Now, at that time, our interest is probably passed on the story. We know the ruling. We know what's going on.
Okay, we've just received word that Lawrence Tribe is about to speak to the press, so let's see if we can get a shot of that and go to the microphones.
Kind of federal intervention in this kind of proceeding. Several of the justices were, I think, really quite surprised by the thought that anyone could find a federal question buried inside the Florida Supreme Court's opinion. but they decided to hear the case, and so they wanted to explore it fully. And it was a very full discussion of all of the issues. The fundamental issue was whether anything in the United States Constitution prevents the state, through its highest court, when a very major election ends in a photo finish, from taking a closer look at the films of that photo finish by counting and recounting if necessary, in order to get it right. And I do think that that fundamental idea came across, but I think no one can ever try to second guess what the Supreme Court will do.
Your side were made before the justices?
Well, I think when you combine the briefs with what it was possible to say in a fairly limited time, we certainly said what we had to say.
Did you leave feeling more optimistic or less optimistic than when you walked in?
I felt more optimistic just because it's always nice to have one of these ordeals over. But I have learned from 29 other arguments that you can't always guess anything about where the justices will come out from exactly what they ask. I certainly didn't think there were any curveballs, and there was nothing that disturbed the court that we were unaware of. And in that sense, it's always a relief to know that the case doesn't have any time bombs in it.
Okay, now our Steve Centani sat in a room adjacent to the Supreme Court chambers. He heard the proceedings. He joins us now to give us his sense of what went on in there. Steve?
Well, Tony, there was a lot of lively discussion on both sides. As you heard Lawrence Tribe say just a second ago, a lot of the...
For a state institution which is involved in the process of picking presidential electors, to rely on the state's own constitution rather than relying on the statutes of the state legislature, which are promulgated under the authority of Article 2 of the Constitution. That is, usually the Constitution of the state trumps the legislation. In this area, ironically, it's a little upside down. In this area, because the Constitution says each state shall choose electors in a manner that its legislature designates, it follows from that if a state court isn't concerned with the manner that the legislature chose, but only with the state constitution, then that's a problem. And I think that the response in this case was that's not what the Florida Supreme Court did. And Justice Ginsburg, near the very end of the argument, asked a question that was pretty telling. Actually, she made a statement to the representative of Governor Bush in his rebuttal. She said the very concluding paragraph of the opinion relies not on the state's constitution, but on the very legislation that it's supposed to rely on. And so a lot of time was taken up on how many angels danced on the head of that particular pin.
Some of the justices seemed uncertain that there was a question for the federal Supreme Court here at all, that the law of Congress may have been there to govern Congress. What is your take?
Well, I think that certainly will be their conclusion about the so-called safe harbor law that was passed in 1887, the law that says that if a state provides certain methods of resolving electoral disputes, and if those methods reach a final conclusion by December 12, then that is binding on Congress. I'm quite sure that the court will say that it's Congress to whom that is addressed, and that there is no federal question in this case arising out of that. Now, that's different from Article 2 of the Constitution.
We want to break in right now because we are told that the audio tapes of the Supreme Court proceeding, the court being called to order, are being queued up. The audio technicians are about to press that play button, and for the first time in history, you will be hearing the workings of the Supreme Court in almost real time. The court jealously guarding against the peering microphones and lenses of cameras and media coverage. You'll hear the court be called to order. You will hear first the voice presenting of Theodore Olson on behalf of George W. Bush. Here now is the audio from the U.S. Supreme Court.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. all persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention for the and this honorable court.
We'll hear argument this morning in number 00836, George W. Bush versus the Palm Beach County Canvassing Board. Mr. Olson.
And may it please the court. 2 weeks after the November 7 presidential election, the Florida Supreme Court overturned and materially rewrote portions of the carefully formulated set of laws enacted by Florida's legislature to govern the conduct of that election and the determination of controversies with respect to who prevailed on November 7th. These laws had been formulated by the Florida legislature pursuant to an express delegation of authority to it by the United States Constitution. The election code that the Florida legislature developed conformed to Title III, Section 5 of the United States Code. That provision invites states to devise rules in advance of an election to govern the counting of votes and the settling of election controversies.
Well, Mr. Olson, isn't Section 5 sort of a safe harbor provision for states? And do you think that it gives some independent right of a candidate to overturn a Florida decision based on that section?
We do, Justice O'Connor. It is a safe harbor, but it's more than that. Section 5 of Title III needs to be construed in connection with the history.
Section designed in the case of some election contest ends up before the Congress, a factor that the Congress can look at in resolving such a dispute. I just don't quite understand how it would be independently enforceable.
That's why I mentioned the context in which that section was adopted. In light of the extreme controversy that was faced by this country as a result of the 1876 election. And as this court knows, that election was very close. It led to controversy, contests, discord. Congress was very much concerned about the possibility of that happening again. And
what they did was, and it's typical of grant and aid programs, they said, if you run a clean shop down there, we'll give you a bonus. And if you don't, well, you take your chances with everybody else.
Justice Kennedy, I submit that it is much like a compact that Congress is offering in the form of Section 5. Yes, if you do these things, certain things will happen. But among these things, what Congress wanted to accomplish with Section 5 is not only to provide the benefit to the states, but to provide the benefit to the United States of the states accepting that implicit proposal.
What is there in the opinion of the Supreme Court of Florida that indicates that it relied on this federal statute in the reasoning for its decision and in its judgment?
Well, I think the fact is that it did not. What it did was it disregarded the compact when the state adopted a code of ethics or code of election procedures to govern the election and the determination of disputes pursuant to the election. It brought itself into that safe harbor and guaranteed to the voters and the candidates in that state that the controversy and turmoil that infected this country after the 1876...
Well, but we're looking for a federal issue, and I thought that you might have argued that the Secretary of State was instructed by the Supreme Court not to jeopardize the state's chances, and it cited 3 U.S.C. sections 1 through 10. And so if the state Supreme Court relied on a federal issue or a federal background principle and got it wrong, then you can be here.
Well, I certainly agree that it mentioned those provisions. I was simply saying that it blew past the important provisions of Section 5 and the benefits that Section 5 gives to the states, to the voters in that state, and to the people running for office in that state. That is to say that if the rules are complied with, if disputes are resolved according to the rules that are set forth, then not only will the electors chosen by the voters in that state be given conclusive effect at the time they are counted by Congress, but we will not have the controversy, dispute, and chaos that's been taking place in Florida since then.
Suppose a less controversial federal benefit scheme. Let's say the scheme that says states can get highway funds if they hold their highway speeds to a certain level. All right. And suppose you have a state Supreme Court that, in your view, unreasonably interprets a state statute as not holding the highway speed to the level required in order to get the benefit of that safe harbor. Would you think that that raises a federal question and that you could appeal the state court decision here because it deprived the state of the benefit of the highway funds?
No, I don't think so. I think
Why is this any different?
This is a great deal different because this is, first of all, Article 2 of the Constitution, which vests authority to establish the rules exclusively in the legislatures of a state, tie in with Section 5. Secondly, as this court has stated...
Let's just talk about Section 5. I mean, the constitutional question is another one. Why is Section 5 in that regard any different from the highway funding?
I think it can't be divorced from Article 2 of the Constitution because it's a part of a plan for the vesting in the legislatures of a state, and Section 5 implements Article 2 in the sense that it provides a benefit not just to the state but to the voters.
But just talk about the statutory issue. I assume that if we worked long enough with Justice Scalia's hypothetical, we could find a case where a court adjudicated with reference to the federal principle and got the federal principle wrong. Did the Indiana versus Brand, that kind of thing. Did that happen here?
Well, I think that the state Supreme Court did not pay much attention to the federal statute. It was obviously aware of it. It did get the federal
principle.
Well, then
there's no federal constitutional issue here.
Well, there is a federal...
Pardon me, statutory.
Well, we believe that there is, Justice Kennedy, because although the state recognized it, it blew right past it. The state legislature adopted the code that the Section 5 of Article 3 of Title 3 invited it to do. The state Supreme Court, which had no right under the Constitution, but I can't divorce the constitutional provision from Section 5, then overturned the plan that the state enacted through its legislature to make sure that what happened down in Florida was not going to happen. And so what the state Supreme Court did, knowing full well that these provisions existed, overturned the carefully enacted plan by Florida.
Mr. Olson, do you think that Congress, when it passed 3 U.S., intended that there would be any judicial involvement with it? I mean, it seems to me it can just as easily be read as a direction to Congress saying what we're going to do when these electoral votes are presented to us for counting.
I think that it wasn't directed to Congress, but it seems to me that in the context in which it was adopted and the promise that it afforded, that the conclusive effect would be given to the state selection of electors, that it is a somewhat empty remedy, and it doesn't accomplish Congress's objectives if it cannot be enforced when an agency of the state government steps in, as the Florida Supreme Court did here, and overturn the plan by which the Florida legislature carefully set forth a program so that disputes could be resolved, and we wouldn't have the controversy, conflict, and chaos that we submitted exists today in Florida.
Your submission is based on the premise that the Florida court overturned something that the statute had done. Is it not arguable, at least, that all they did was fill gaps that had not been addressed before?
Justice Stevens, I don't think that in this case that's even remotely arguable. What the state Supreme Court did is take a set of timetables, a set of provisions that...
Yes, and the first one was the mandatory. Is it your view still that the shall date controls in all respect?
No, not necessarily. The 102, there's the two provisions are section 102.111 111 and 102-112.
Right.
111 contains the shell date, 102 contains the may date.
Correct.
Both of those statutes, both of those provisions say that the returns must be or shall be filed by a certain deadline. The shall and the may provisions simply can relate to the possible remedy. We submit that under either interpretation, the Secretary of State of Florida either must or shall ignore those returns or may set those aside in her discretion.
Does that mean if there were an act of God that prevented the returns from being filed, that she would have discretion either to accept or reject the returns?
Yes, I believe
she would have discretion. Would she be compelled in that event to accept the returns?
I don't think so. She took the position.
She has the total discretion either to accept or reject. Is there any circumstance in which he would be compelled to accept a late return?
I don't know of any, and I haven't thought of any, Justice Stevens.
Well, you're arguing in effect that it's a mandatory deadline. I wonder if you really mean it's mandatory.
Well, the problem is that what we're saying is that either it's mandatory, in which case she could not accept them.
But you don't know whether it's mandatory or not.
Well, the Florida Supreme Court and what the Circuit Court did in that case is said that it wasn't, and we'll accept this for purposes of this argument, that it wasn't altogether.
Yeah, but one of the things that's of interest to me is the extent to which you say there was a change in the law. It seems to me that in order to answer that question, you have to know what your view of the law was before this all happened.
I think that we can answer that this way, is that whether it was shall ignore or may ignore, it was not must accept.
Under any circumstance, it was not must.
Under no circumstances was it must accept. Now, the second...
Even an act of God or fraud?
I don't believe so, Justice Stevens.
Is it the law in Florida, like as in most states and in the federal government, that when official has discretion, may accept or may not accept, that has to be exercised within the limits of reason?
Yes. There was an abuse.
Well, then isn't it possible that when the court says she must accept under certain circumstances, what they mean is outside those circumstances, given the circumstances here, it would be unreasonable to refuse?
Well, what the court did was so constrain those circumstances virtually to make them non-existent.
All right, so then what you're arguing about is a determination by the State Court of Florida as to what the circumstances are under state law where the action of a state official would or would not be reasonable.
I think that yes, but I think it has to be looked at in the context in which that was done. When the state Supreme Court so constrained and says in its opinion, shall accept these late returns until 5 p.m. on November 26th, and in the context there was no discretion left for the Secretary of State at all.
Mr. Olson, may I ask you, because you've been skipping over what I thought was a key piece of the Florida legislation. The Florida Supreme Court said there's the deadline, and that conflicts with another provision of this law, the provision that says there shall be, under certain circumstances, recounts. And then there's a rather detailed description of the process that's necessary. The timeline for when you can ask a recount is on the 6th day.
Up to.
Yeah, up to. And it would be impossible in a populous county to, in one day, do what the statute instructs must be done when there's a recount. The Florida Supreme Court said, it said right in its opinion, there's two conflicts. And the first one they mentioned, straight out on page 21A of your appendix, is that there has to be a reconciliation between this, yes, there can be recounts, and yes, there's a deadline. So they are trying to reconcile two provisions.
The first part of the recount provision to which you're referring, Justice Ginsburg, says may conduct a recount under certain circumstances after the sampling part of that process is taken. If it's taken in the county canvassing board's discretion, then under certain circumstances it is supposed to go forward with a more fulsome process. But the legislature being fully aware of the recount provisions and the importance of this ties in with the protest period for the election, which overlaps the recount provisions and the contest provision for the election, and the fact that all of this has to be done in the context of a presidential election. Under any other kind of election, these things wouldn't be nearly as important, but we have very important timetables, and as this court has said, a presidential election is so important to the rest of the nation, and there's such a high federal interest in accomplishing these things in the right way. What the Florida legislature did is balance the protest period, the recount period, with the contest period, and state that there shall be certain deadlines before which certain things need to be done and after which. So what those two statutes say is that there may be a recount, but that there shall be compliance with the time deadline. It also says that...
But that's something that one could certainly argue. My problem is one could also argue what the Florida Supreme Court said, and I do not know of any case where we have impugned a state Supreme Court the way you are doing in this case. I mean, in case after case we have said we owe the highest respect to what the state says, state Supreme Court says, is the state's law. And
this is a very unusual situation, Justice Ginsburg, because it is in the context of a presidential election, and it is in the context of federal rights. This court has, in the areas in which we've described in our brief, undertaken to review the meaning and effect of a state Supreme Court or a state court decision under certain circumstances. We submit this is one. What the Florida Supreme
Court has said, and even in the very cases that you cite, as I checked them, that we owe the highest respect to the state court when it says what the state law is.
Yes, but then the court has also said, then we go on to see the extent to which what the state court did, as we cited in the Lindsay case, for example, in the ex post facto context, we go on to see what the import of that is in connection with the federal right. I would emphasize that what the Florida Supreme Court did is basically essentially say, we're rewriting the statute, we're changing it.
Did the Secretary have any flexibility to accommodate the statute to the exigencies of the presidential election?
Well, the Secretary of State. The Secretary of State did. She doesn't much anymore, because what has happened, and I would like to finish that one point, that the Florida Supreme Court said we are not going to be bound by technical statutory requirements, or what the Supreme Court called hyper-technical statutory requirements. Instead, we are going to resort to the will of the people, the will of the electorate, the will of the voters, so to speak, and we are going to, because we can't rewrite the statute, but we are going to partially rewrite the statute, we're going to resort to our equitable powers. And among the things that the court did, and there are a range of them, as I have indicated, they took away the discretion of the Secretary and instructed her to accept these manual recount returns.
Mr. Olson, on the equitable powers, they were doing that in setting a new deadline. And I don't think you would argue the case would have been more acceptable if there had been no deadline.
No, it wouldn't have been. But
on the fight between may and shall, they relied on 4 traditional canons of statutory construction and not equity at all.
They recited 4 canons of statutory construction, Justice Stevens, but when they said they used those canons of statutory construction to say that the words may and shall mean shall not. That is not a reasonable exercise of statutory construction. I think it's relatively obvious that what the Supreme Court did is exactly what Section 5 of Article 3 intends not to happen. Change the rules.
I don't read their opinion that way, Mr. Olson. It seems to me that the portion of their opinion dealing with statutory construction ends with the conclusion that the Secretary has discretion. The portion of the opinion employing the canons of construction does not place any limits upon the Secretary's discretion.
Well, yes, but I agree with that up to a point. But then it says that she must accept these returns that are after the deadline.
That was not on the basis of any canons of statutory construction. That was on the basis of the state's constitution.
Well, that's right. So there was both going on, and what the court was bound and determined to do was to get to a consequence that the court determined was consistent with the will of the people, irrespective of what the statute was.
Mr. Olson, would you agree that when we read a state court decision, we should read it in the light most favorable to the integrity of the state Supreme Court? That if there are two possible readings, one that would impute to that court injudicial behavior, lack of integrity, indeed dishonesty, and the other that would read the opinion to say, we think this court is attempting to construe the state law. It may have been wrong. We might have interpreted it differently, but we are not the arbiters, they are.
I would like to answer that in two ways. In the first place, I don't mean to suggest, and I hope my words didn't, that there was a lack of integrity or any dishonesty by the Florida Supreme Court. What we're saying that it was acting far outside the scope of its authority in connection with a exercise of power that is vested by the Constitution of the United States.
If it tells us we see these two provisions in conflict, but they need to be reconciled.
Under almost any other circumstances, yes, Justice Ginsburg, but in this context, we're talking about a federal right, a federal constitutional right, and the rights of individual citizens under the Constitution, and so therefore the court, this court has a greater responsibility to look.
I'd like to get focused a little more on this same area. If it were purely a matter of state law, I suppose we normally would leave it alone where the state Supreme Court found it, and so you probably have to persuade us there's some issue of federal law here. Otherwise, why are we acting?
Yes.
And are you relying in that regard on Title II? I mean, would you like to characterize, Article 2, would you like to characterize the federal issue that you think governs
we are very definitely relying on Article 2 of the Constitution. The framers of the Constitution debated long and hard. It was one of the longest debates that took place during the formation of the Constitution. Where should this power be lodged? In the federal legislature, in the state legislature, and at the ballot booth, or what? The one thing that was discussed and rejected by virtually everyone is that the power to select the manner in which electors would be appointed would be in the state judiciary. And we quote, in the state judiciary. That was rejected. The notion that it would be vested in the state judiciary was something that was rejected, and what the framers decided to do is to vest it in the state legislature, and vested that authority under Article 2, not just in the state, but in the
legislature could vest it in the judiciary if it wanted, as I read the McPherson case. And here they've done something less. The state judiciary said, we're going to invoke the ordinary election procedures, which, warts and all, it involves some interpretation by the courts and contest proceedings, etc.
Well, it is, yes, it said that, Justice Kennedy. But what it did was supplant a set of rules enacted before the election to govern the election for a set of rules to made up after the election.
All right, Mr. Olson, let's assume that it did that for the sake of argument. I want to go back to the issue that the Chief Justice raised a little while ago. And I'd like you to comment on this line of reasoning. You got Section 5. Congress in the statute seems to have gone to great lengths to provide what to do in the situation that you are describing, accepting your view of the case. Section 5, it says, if you do certain things within certain times, the conclusion that you draw is going to be conclusive upon the Congress. In Section 15, it sets out, in fact, an elaborate set of contingencies about what the Congress is supposed to do and can do if there is a dispute as to whether a given set of procedures in the state have conformed to Section 5. Section 15 refers to regularity, it refers to legality and illegality, and it looks to me as though, at least at this stage of the proceedings, Congress has said if there is a question about whether this if-then provision in Section 5 construing Article 2 has been satisfied, then this is the decisional tree for the Congress to follow in deciding what to do about it and in resolving challenges. And it looks to me as though at this stage of the game, the statute has committed the determination of the issues that you raise and the consequences to follow from them to the Congress. Why should the court, why should the federal judiciary be interfering in what seems to be a very carefully thought out scheme for determining what happens if you are right?
Because I submit that that writes Section 5 essentially out of existence if an agency of state government, if a state legislature...
No, it doesn't write it out of existence. It provides in Section 15 what happens if the state agency does what you says it did.
If the state agency, if the state legislature, empowered by the Article 2 of the Constitution, does what it is invited to do by Section 5, and then another agency of state government, in this case the state Supreme Court, comes along and upsets that scheme, yes, you have ultimate resort to the resolution of the dispute under Sections 15 of Title 3, but that's precisely...
Well, you say you have ultimate resort, but that begs the question. That seems to be precisely the resort that Congress has provided.
Well, I'm not making myself clear, I think, is that the importance of Section 5, it was to invite the state to do things that would avoid the chaos and the conflict and the controversy and the unsettled situation that this country faced in 1876.
Mr. Olson, did Section 15 exist when McPherson was decided?
I don't know, Justice Scalia. I don't know the answer to that, when it was adopted. I can't recall whether it was a part of the 1887 electoral count statute or not. I can probably answer that.
That would make a difference, wouldn't it?
Well, it seems to me it wouldn't make a difference because of this. It might, yes, it certainly might make a difference one way, but it still wouldn't make a difference because our concept here, and I think it's quite a rational and actually the only explanation for how you can put these provisions together, Article 2 and Section 5, and Congress's desire to avoid the very controversy, chaos, conflict, which even the...
Well, but Section 15 assumes that there is controversy and chaos.
Yes.
And Section 15 isn't providing for challenges except in situations perhaps exactly like this one.
But that's what the country, what essentially Section 15, although it modifies it and structures it somewhat, it was still the situation that Congress was facing in 1876 when it was dealing with the Hayes-Tilden election.
Right.
And by the time it got there were dueling slates of electors, there were buying, there were exchanges and a lot of things that everyone felt was very destructive to the country.
But Congress had to face the constitutional fact that under Article 2, it could not, or its understanding was certainly, that it could not mandate certain state procedures. Article 2 did say the legislature shall decide what they are.
Correct.
So the most that Congress could do in providing for a more orderly resolution of what happened in Hayes-Tilden was to do what it did in Section 5, and that is to say, if you do certain things, you can depend upon the results, recognizing that the state might not do those things. And it then provided, or at least at the present time it is provided in Section 15, that if you don't do those things, there is a sequence of issues that can be raised to be decided by the Congress. If Congress wanted this court to get into the issue at this stage, it seems passing strange to me that despite all the elaborateness of Section 15, there wouldn't have been some mention of federal litigation preceding the Section 15 proceeding.
I think it's a very important point, and let me make it, that Congress did say if you do these things, certain consequences will flow from it. Florida did these things. And we submit that the courts are here to protect the benefit of the bargain that Florida made when it responded to that invitation.
Well,
and because
we have to separate your statutory argument from your constitutional argument. To the extent that you're relying just on the Constitution, do you think that Congress could, by Section 15, exclude the courts from adjudicating the constitutionality of what the state has done?
No, I don't think so.
But it certainly could express its preference for a scheme whereby the initial litigation, if you will, at this level would take place in the Congress. To acknowledge that is not to say that the issue is justiciable or that this court has somehow been necessarily excluded from the process for all time. It is simply to say that the first line of litigation at the federal level seems, under the statute, to be Congress and not the court. Isn't that a fair reading of 15?
That's not a fair reading of Section 5. And let me answer this question, and I'd like it with the court's permission to reserve the time.
I don't think Section 5 goes to the issue. Well, the question is whether it's a fair reading of Section 15.
I don't think that they can be read in isolation. I think that Section 5 was designed to avoid the problem created by the controversy and the having to resolve this in Congress, which is exactly what did happen in 1876 and was a very unsatisfactory situation.
And in 1876, Congress did not have the rules.
1877.
Congress did not have the rules with respect to conclusiveness that it now has under Section 5.
And that's right, and it put those rules with respect to conclusiveness into Section 5. The Florida legislature bought into that scheme, and now the Florida Supreme Court, which doesn't have any constitutional authority pursuant to Section 2 to do so, upset that scheme, deprived Florida of the benefit of doing exactly what Congress wanted to have happen under Section 5. I would, if the court's with the court permission, reserve the balance.
Very well, Mr. Olson. Mr. Clark, we'll hear from you.
Mr. Chief Justice, and may it please the court, our argument is simply addressed to issues having to do with Florida law, and the point being raised by the Secretary is this, that the law in the state of Florida on November 7 was changed by the Supreme Court of Florida's decision on November 21. The Secretary is not contesting the right of the Florida Supreme Court to change the law of Florida, she is simply pointing out that the law did change.
Does the Secretary maintain that in some instances she has a discretion that a court does not? Or can a court do whatever she might do under Florida law?
Under Florida law, she has certain discretion that I think a court probably does not have in the protest period, Justice Kennedy, and that would be that she had the discretion to decide whether or not returns could be permitted after that seventh day. And indeed, that's based on two things that we have in the record. One is an opinion that was issued by the Division of Elections that talks about the circumstances in which the Secretary would exercise discretion. And the second is the letter that the Secretary sent to the 3 or 4 canvassing boards that requested an extension of time after the 14th deadline had passed. She sent a letter out. She said, please indicate to me whether or not you intend to file returns after the deadline, and if you do, what the reasons are. She collected a set of criteria, she applied the criteria, and then sent a letter back. And what she did, Justice Kennedy, in the case of the division's letter, the opinion, which of course is binding under Florida law on elections officials who receive them, the division had said that there were certain circumstances such as acts of God, hurricanes, and that kind of thing where the discretion would be exercised. When she came up with her additional reasons for considering whether or not she would exercise her discretion, she indicated a number of them, which are also contained within the record. It's at the Joint Appendix at 21. She indicated where there was a result of voter fraud, where there's a substantial...
She said she would exercise her discretion. Did she say she would have to exercise her discretion in those conditions?
I think she would have to exercise her discretion,
The court
sir.
could compel her to.
Yes, sir.
Do you think that was clear before the opinion of the Supreme Court in this case?
Yes, sir.
Let me just ask one general question for your comment on whether it's a change in the law. To what extent, in your view, did the Supreme Court of Florida consider itself bound by either prior precedent or the Constitution of the state which pre-existed?
In terms of handing down this decision?
In terms of the particular result it reached in this case.
I believe the Supreme Court of Florida was looking at its law in terms of articulating the law that it wanted to have then and on a going forward basis. I mean, what it did, and obviously, since it's the chief court of the state, it has the right to do whatever it wishes to do with respect to Florida law, only bound by whatever separation of powers.
Do you think they thought their decision was dictated either by prior precedent or by the Constitution of the state?
I don't know. Your Honor, I don't know whether they thought that or not, but that's not what the opinion says. As a matter of fact, the opinion is pretty clear. They start out by talking about statutory construction, and they hinge everything on the use of the word interpret, and then they sort of turn the word interpret to a use that it's not intended to be. But then when they get to the point of designing the rule of law they're going to go forward on, they don't talk about interpreting the statute. They then go and base it on principles of equity and the Florida Constitution. And indeed, what they end up with, Your Honor, is this statement with respect to the discretion that the Secretary is left with, and that is this, and it's on 35 of the Joint Appendix. We conclude that consistent with Florida's election scheme, the Secretary may reject a board's, that's the canvassing board's, amended returns only if the returns are submitted so late that their inclusion will preclude a candidate from contesting certification or preclude Florida voters from participating fully in the federal electoral process. Now, Your Honor, there's no way...
Your position is that was entirely new.
Yes, sir.
And I'm just wondering, therefore, your submission is that it was not dictated by the Constitution or by prior precedent.
No, Your Honor.
Well, I thought you said a moment ago that the Florida court did rely on their Florida Constitution. There's a section of their opinion that's devoted to that.
Your Honor, in devising their remedy, they referred to the Florida Constitution, but the issue that we're here on, as I understand it, sir, is whether or not the law changed. There's no question that they have a right to do what they did. The only difference is whether...
I think perhaps another statement of the issue is to what extent did the Florida Supreme Court, in construing the statute, rely on more general provisions of the Florida Constitution, which they cited in their opinion?
I think they did rely in creating the remedy on the Florida Constitution. I believe they created a right that had not previously been seen there, which they have a right to do. But, Mr. Chief Justice, the issue again is whether or not the law that they articulated on November 21 is different than the law that existed on November 7, and how the Secretary of State, in exercising her discretion, was to divine the standard that would be established on November 21.
Your position is, so long as it's different, it violates Section 5, and therefore we have a right to step in.
Well, Justice Scalia, we have not addressed the federal issues because, I mean, we're in a situation where you have...
Well, this is a federal court. What are you here for if you're not addressing the federal?
I apologize. But we have the Secretary of State here, we have the Attorney General here, and the legislature has filed by amicus, and of course the state has not appeared. So it's a little unusual. We haven't addressed those issues, but to answer your question, yes, sir.
Can you tell me, when this petition was filed here, the Secretary had not certified anybody the winner. Now the Secretary has certified a winner. And therefore, I guess whether we win, whether your side, the side you're supporting, wins or loses, it doesn't change that. And I guess that's moot. Well, but my question is there any respect in which this really makes a difference, this case? How I'm thinking if it does make a difference in numbers of vote, is that kind of thing right for us to decide now? How could it make a difference? What's the consequence of our going one way or the other now in this case?
Your Honor, it makes an enormous difference because the relief that has been requested would be for the court to determine that the law in effect at the time of the election was that manual recounting of ballots would not be permitted to address voter error, which I think has been extensively.
But we don't have, well, suppose they won and the relief was, suppose your side won, and the relief was fine, it should have been certified on November 14th or 18th instead of November 26th. Now, what's the consequence of that? Well, just that. Forgetting what the reasoning is there a consequence that flows from that is real, adverse, significant, concrete, that we could predict now as opposed to speculating?
The only immediate result would be that you would have a margin that was, instead of being 536 votes, would be 900 and some odd votes, and it would only be added to as a result of whatever was added by the overseas ballots.
Fine. Then this case is said, we've said, a claim is not ripe if it rests upon contingent future events that may not occur as anticipated, or indeed may not occur at all. And so what I wonder is this in this realm of speculation as to whether or not it will or will not make a difference to the outcome of the election?
It will make a difference to the outcome of the election because there is an ongoing contest which is interrelated and is involved in the Supreme Court's opinion. And of course, because the Supreme Court of Florida, in coming up with the remedy that they came up with, completely changed the period of time from a relatively short period of time, 7 days for a protest, and a much longer period for a contest, we now have a situation where there's 19 days for the protest and 16 days for the contest.
Well, it's too late to lengthen the time for the contest. I mean, to the extent that they've shortened the contest time, that's water over the dam by now, isn't it?
Yes, Justice Scalia, but the issue here, I'm sorry.
Is it not the case that if the votes are as they have been shown to be under the Florida Supreme Court's opinion, the race is much closer, and therefore some counties under Florida law would conduct recounts that otherwise would not conduct recounts? Doesn't whether a recount is conducted depend upon how likely it is that the recount is going to change the outcome?
Your Honor, if the law is returned to the point it was on November 7, there is no right to a manual recount to correct voter error, and that will end the litigation that currently exists in the state of Florida, which were the opinions of the Secretary of State's Division of Elections that were issued, and also the state of the law as it existed at that point in time. The record shows very clearly that there is no dispute that there were any problems with voting machines or any of the tabulation problems with voting machines. It was simply when they went through the process of what is, Justice Ginsburg, a discretionary right to a manual recount, not a mandatory one. When they went into that and did the test, each of those canvassing boards did not find any problem with a mechanical problem. It was simply a problem in terms of voter error.
The Secretary took the... Never mind.
Thank you.
Thank you, Mr. Clark. Mr. Hancock, we'll hear from you.
Mr. Chief Justice, and may it please the Court. In accordance with Article 2 of the United States Constitution, the Florida Legislature has directed the manner of selecting presidential electors in Florida. That manner is pursuant to a popular vote that's implemented pursuant to the general election laws of the state of Florida.
I guess Article 2 permits the legislature in general to make a choice. It could itself select the electors.
Yes, Justice O'Connor, we agree with that. In implementing the election law, each branch of the Florida government plays a role. For example, the judiciary, or the executive branch of our government, has not found itself bound by the hyper-technical requirements of the election law. An example of that is that the executive branch has implemented a rule, not a law, but a rule that allows absentee ballots from overseas military voters to be received up to 10 days after the close of the polls. Under the law of the state of Florida, all absentee ballots have to be received by the time the polls close on election day.
In your brief, you say you conclude that the Florida Supreme Court, like I think it's at page 12, like any state court, exercise its inherent equitable powers to remedy a threat to fundamental constitutional rights. And it rewrote the certification deadlines according to that power, did it not?
Yes, Justice Kennedy, the only equitable power exercised by the court was setting the deadline.
But isn't that such an amorphous, general, abstract standard that it can't possibly be said to be a law that was enacted and in place at the time of the election?
No, the laws were enacted well before the election. What happened was that in the court
Of course, the Constitution is there before the election, the due process clause is before the election, but what we're talking about is having laws of sufficient specificity and stability that people can rely on them in advance and not have them changed after the fact. And your briefs makes it very clear that they exercise their equitable powers to remedy a threat to fundamental constitutional rights and change the deadline accordingly. It seems to me that's no standard. It's an enviable standard, something we probably all agree with in the end. But so far as the requisite specificity to satisfy this 3 U.S.C. Section 5, I just don't see that it's there.
The court had to do something, Justice Kennedy. It was faced with conflicts in Florida law. They had conflicting opinions from the Florida Attorney General as to the meaning of the law and the Secretary of State as to the meaning of the law. As a result of those...
Maybe it had to do something, but did it comply with 3 U.S.C. Section 5?
I submit, Justice Kennedy, that 3 U.S.C. Section 5 doesn't require the state to do anything. It merely says...
Did it comply with that part of 3 U.S.C. Section 5 that requires that laws be enacted and in place prior to the election in order to get the safe harbor?
Yes, it did. The laws were in place before the election, and those laws granted to the judiciary...
But certainly the date changed. That is a dramatic change, the date for certification,
yes,
right? And it was done by the court.
Yes, it was done.
And the legislature had very clearly said, 7 days after, that's the date. And it just does look like a very dramatic change made by the Florida court. And I'm wondering if that is consistent, in fact, with the notion expressed at least in Section 5, so that the result would be, if it did go to Congress, it would be a change.
I agree that the date was implemented pursuant to the court's equitable powers. Other than that, it was a routine exercise in statutory construction. The court was faced with a situation, first of all, where because of conflicting advice, the counties had started and then stopped conducting manual recounts because of advice from the Secretary of the State, which the Supreme Court ultimately concluded to be erroneous.
Yes, and that advice was, and this was really the beginning of all of the problem, her advice was that the provision providing for recounts, manual recounts, not requiring them but giving them as one of the options, only came into play when there was some defect in the machinery, and it was not available for voter error. That is, for voters who didn't punch the cards the way they were supposed to. And the attorney, your office came out with the opposite conclusion. The Secretary's brief contends that that had always been the rule in Florida. Is that the case? Do you know of any other elections in Florida in which recounts were conducted, manual recounts, because of an allegation that some voters did not punch the cards the way they should have through their fault? No problem with the machinery, it's working fine, but there were pregnant chads, hanging chads, and so forth.
No.
Did it ever happen before?
I'm not aware of it ever happening before, but I can say that the Supreme Court of Florida for 100 years has put a duty on election officials to discern the intent of the voter. And while the Secretary of the State refers to it as voter error, when the ballot is punched, that's under the laws of the state of Florida, as interpreted by the Supreme Court, that voter has cast the ballot, even if the Chad did not completely fall.
Is it your position that any interpretation the Supreme Court of Florida makes to implement the will of the people is never a new law?
That the Supreme, yes, I can't say ever, but I say that on the case before the court, All that was before the court was ordinary statutory construction, which must be, the result of it, whether this court would agree with it or disagree with it, must be respected by this court. That's the very foundation of federalism.
Are you relying on the Florida Supreme Court statement at least twice in its opinion? Now I looked at the page to which Mr. Clark referred, page 37A. It says for the second time that the section governing manual recounts appears to conflict with the sections that set a deadline, and it's reconciling that conflict.
Yes,
whether it was wrong or right, that's what it said its mission was, and that's what it did.
Yes, both in words and in operation, the statutes could not work together because of the time for requesting manual recounts, the extent of the job of manual recounting.
What is the section that requires manual recounts?
It's 102.166 authorizes manual recounts.
That's different from requiring.
Yes, but once it starts, Justice Scalia, once it's authorized, if the initial sample recount shows an error that might affect the outcome of the election, then the board is then required to, among other things, conduct a full manual recount.
No, it's required to do one of three things.
Right.
One of which could be a manual recount.
Yes.
But it could decide to do one of the other two instead.
Yes, the problem faced by the county.
So there is, I mean, the court says that there's a requirement of a manual recount, but I don't see anything in the text of the statute that requires a manual recount.
The statute requires that the election officials attempt to discern the cause of the error. Here, the cause of the error was that, in these counties, was that the machines were not able to read ballots. 10,000 ballots in Palm Beach County, the machine did not read as including a vote for president. That was the issue. So the solution to that was not the machines, even when they're operating properly, would not read these ballots. So what was left to the county canvassing boards then was to do the full manual recount. In the language of that statute, again, says they shall do a full manual recount in those circumstances.
Well, it says that the board may authorize the manual recount. It doesn't require it. But if it does authorize it, then it tells it how to do it and says they shall appoint as many counting teams as necessary, presumably as necessary to do it within the time limit.
Yes, Justice O'Connor, but again, these under the law, these requests can be made up to the time of canvassing. That means up to 6 or 7 days. And also, even in the number of ballots at issue here are between 650,000 in Palm Beach County and also 900,000, up to 900,000 in Broward County.
Well, if that is a statutory problem, the court's resolution didn't really solve it, did it? Because even with her extended time period, the same statutory problem exists. There still isn't enough time under the extended deadlines for some of these counties that have an enormous number of votes to conduct a manual recount. Isn't that right?
Well, let me...
I mean, to resolve a supposed conflict in the statute in a manner that leaves in place the same problem that existed before, it seems to me not a real resolution of the statutory problem.
Well, the Supreme Court tried to blend it all together to make it work, Justice Scalia, and again, it came up with a solution. The Secretary of State's argument here is based on the Secretary of State herself recognized that she had the discretion under Florida law to accept returns filed outside of that 7-day deadline. A breakdown of the machines, in her view, would justify late returns. A failure of the machines to read ballots would not justify late filed returns. The Supreme Court said that the legal standard she was using was wrong. That we submit that decision of the Supreme Court is the law in the state of Florida.
I'm going to extend your time 2 minutes, Mr. Hancock, because you haven't had a chance to say a lot yet.
Well, I will. I don't need the extension of time, Your Honor. If there's no other questions, I will stop. Thank you.
Thank you. Mr. Tribe, we'll hear from you.
Mr. Chief Justice, and may it please the Court, I think I would want to note at the outset that the alleged due process violation, which keeps popping up and then disappearing and has, as far as I can tell, not appeared in the state Supreme Court, did make one appearance in the reply brief here, is really not before the Court, and for understandable reasons, because although it is part of the popular culture to talk about how unfair it is to change the rules of the game. I think that misses the point when the game is over, and when it's over in a kind of photo finish that leaves people unsure who won. And then the question is, how do you develop greater certainty? And a rather common technique is a recount, sometimes a manual recount, sometimes taking more time. It would be rather like looking more closely at the film of a photo finish. It's nothing extraordinary. It's not like suddenly moving Heartbreak Hill or adding a mile or subtracting a mile from
You're saying no important policy in 3 U.S.C. Section 5?
No.
In fact, we can change the rules after the game's not important.
No,
popular
certainly
culture.
Not, Justice Kennedy. But I read U.S.C. Section 5, that is 3 U.S.C. Section 5, not as a requirement that, for example, one never add resources to checking how a particular ballot was cast. If you look at the language, I think it's really much too casual to say of it that all of the laws must stay fixed in order to have the safe harbor apply, though as I'll try to argue in a few minutes, that's really not a question for this court, but rather for Congress. But the language of Section 5 is that, and I'll just read what I think are the key words. If a state...
Can you tell us where you're reading from?
Actually, I'm just reading from a copy of the U.S. Code, 3 U.S.C. Section 5, not from the page I can identify.
It's in the appendix to the petitioner's brief, I'm sure, isn't it?
Yes, although I'm afraid I don't have it in front of me.
Page 3A of the blue brief.
Thank you, Justice Souter. Page 3A of the blue brief, I am reliably informed. So if any state...
That won't get you an extra 2 minutes.
Well, I tried. If any state shall have provided, and then it says by laws enacted prior to the day fixed for the appointment of the electors, a fancy way of saying election day, for the final determination of any controversy or contest about the appointment of electors, and here's the key phrase, I think, by judicial or other methods or procedures, at least 6 days before the time fixed for the meeting of the electors, that means in our situation December 12, then the final determination shall be conclusive and govern the counting in Congress. Now the question for Congress, I suppose, would be, though I don't see how this court could get into that question at this stage, but the question would be, is a particular change extending a deadline for exigent circumstances because a recount has been authorized, a change in the judicial or methods of procedures for resolving the contest?
Let me ask you just a moment. Mr. You say you don't think this statute permits this court to get into the matter at this time. Are you suggesting there could be any judicial review of a decision by the Congress to count one set of electoral votes?
No, I don't think so, Mr. Chief Justice. It's just that I don't trust my own imagination to have exhausted all possibilities. For example, in the case in, I think it was 1890, in Fitzgerald v. Green, when this court held that only states can punish fraudulent voting for presidential electors, it got into the act sort of obliquely and at an angle, and that had a bearing on the question of how the presidential electoral slate might be composed, but it certainly didn't get into this.
No, it certainly was quite different from this hypothetical.
No, that's certainly right.
You suggest in your reply brief that it is not, I think you said it's not self-evident that the Florida legislature at this time has the right to appoint any slate of delegates because the Congress has set the date and the date is the general election day. If that is so, doesn't this mean that when we think about justiciability, we must be very careful to preserve the role of the court? You have said that or suggested here on the page in your reply brief that the Florida legislature now has no role. You are now suggesting that this court has no role. That means the Supreme Court of Florida is it so far as judicial interpretation of the consequences of 3 U.S.C. Section 5.
Well, Justice Kennedy, first of all, I do want to be clear that in our view, the question of whether and when and how
the Florida legislature can enter the picture is in no way presented here. That paragraph was intended to suggest that it's not obvious that the views of some that there's no problem is right. Secondly, if it were the case that the Florida legislature could not simply decide, well, we're tired of all this counting, we're moving in, and that this court cannot decide whether the conditions of 3 U.S.C. Section 5 are met, it would then remain only for Congress to make a determination, and adding the Florida legislature would not, after all, have added an adjudication.
And my point is that puts hydraulic pressure on your non-justiciability argument and makes it a very, very important argument and a critical argument in this case.
Well, perhaps, Justice Kennedy, but I frankly can't see how it would affect the decision in this case. That is, after all, you have before you a judgment of the highest court of a state. As Justice Ginsburg and others have suggested, it would ordinarily be the case, surely, that one would not go out of one's way to read the judgment as a breach of faith with the duties of trying to reconcile provisions that are in fiction.
I guess in the area, though, of presidential electors, it could be that that court, as all courts would be, have to be informed, at least, by the provisions of Section 5 in reviewing the laws enacted by the legislature of the state. I mean, it had to register somehow with the Florida courts that that statute was there and that it might be in the state's best interest not to go around changing the law after the election.
Well, Justice O'Connor, I certainly agree that if the Florida Supreme Court adverted to 3 U.S.C. Section 5 and, as Justice Kennedy asked earlier, got it wrong, then there would be a federal issue for this court. Would it be, I wonder, a federal issue?
Is there a federal issue if the court doesn't?
No. The answer is no.
Advert to it.
It would be nice, but remember, it is
because of Article 2, which, after all, does give the legislature plenary power, and must have wanted, it must have wanted to have the laws in place so that it wasn't, so that Florida wouldn't risk losing its electoral votes. I mean, the legislature had to want that by enacting laws, and perhaps the Florida court has to be aware of the consequences to the state of changing the rules.
But Justice O'Connor, under Article 2, Section 1, Clause 2, the authority to regulate the manner of the choice of electors is vested in the state legislature. If the state legislature decides from the beginning to exercise that authority by instructing the various institutions, certainly not just the courts, the Attorney General, the Secretary of State, in very particular ways to exercise their roles in the process with a specific view of...
by enacting that date. Here is the certification date. How could it have been clearer?
Well, I suppose it could be a violation of Florida law if the enactment of that date is construed as a direction to a particular authority, like the Secretary of State or the state's highest court, to take certain actions in order to get the benefit of this bonus. But only a violation of federal law. I don't see how you get a
Florida law with that.
Of state law, I'm sorry.
Are you talking about the Florida Constitution?
Well, it might have been a violation.
But then you run into the Blacker case.
But it seems to me that the federal question, which is really what brings us here, yes, can only arise if 3 U.S.C. Section 5 is something other than what Mr. Olson called an invitation to the state.
It can also arise under the section of the Constitution that was construed in Blacker. That's quite independent of 3 U.S. 5.
Well, that's right. If one concluded that Florida had violated its duty to empower the legislature to take these regulatory steps.
If one concluded that the Florida legislature had relied on the state constitution in a way that the Blacker case says it may not in construing the statute.
I think that's possible, Mr. Chief Justice, but the judgment before you doesn't provide even an inkling, I think, of proof about those matters. All we have...
That's what we've been arguing here.
Well,
it does or whether it doesn't.
Well, I think we've been arguing several interrelated things. One of the things we've been arguing is whether one could, in good faith, reach the conclusion, novel as it was in some respects, as Justice O'Connor points out, that the Florida Supreme Court reached. Now, if the answer to that question was no, perhaps if there were a due process issue in this case, and if someone had a protectable interest that was injured, that would be relevant. But the federal question that makes that relevant here would arise only if one forgot that 3 U.S.C. Section 5 is all carrot and no stick.
No, a federal question arises if the Florida Supreme Court, in its opinion, rather clearly says that we're using the Florida Constitution to reach the result we reach in construing the statute. And I think Blacker is a strong argument they can't do that.
Well, that they can never advert to their own Constitution? I don't think so.
Certainly it stands for the proposition you couldn't do it then. In those circumstances.
Well, what would it be, I wonder, about the circumstances here that would say that in reconciling these provisions, which at first we were told were mandatory, then we were told they're not mandatory, they give discretion, and now we're told that the real issue is simply, did the court, in putting a boundary on that discretion, do something federally impermissible? What would it be about that sequence that would implicate?
You know, if the Supreme Court of Florida simply said, in its opinion, look, these sections of the statute conflict, we've got to, under our traditional principles, resolve it one way or the other. But it doesn't say that. It goes on to say, look, in the light of the Florida Constitution and the general rights conferred there, we're construing it this way.
It seems to me that as a tiebreaker, as a way of shedding light on the provisions that are in conflict, so long as it's not done in a way that conflicts with a federal mandate, they're not violating any.
Mr. Trump, I don't agree with that. I don't think that the Florida Supreme Court used the Florida Constitution as a tool of interpretation of the statute. If you look at its opinion, it's separated into various sections. The issues, legal opinion of the Division of Elections, 5, the applicable law, Romans 6, statutory ambiguity, and 7, legislative intent. That's the section where they construe the statute in view of these ambiguities and so forth. That section concludes, under this statutory scheme, the county canvassing boards are required to submit their returns to the department by 5 p.m. of the 7th day following the election. The statutes make no provision for exceptions following a manual recount. If a board fails to meet the deadline, the secretary is not required to ignore the county's returns, but rather is permitted to ignore the returns within the parameters of this statutory scheme. So what the statutory interpretation gives you is a firm termination date of December 7th and discretion in the secretary. The opinion continues. Roman 8, the right to vote. The text of our Florida Constitution begins with a Declaration of Rights, and it goes on to say that to the extent the legislature may enact laws regulating the electoral process, those laws are valid only if they impose no, quote, unreasonable or unnecessary, close quote, restraints on the right of suffrage contained in the Constitution. In other words, I read the Florida court's opinion as quite clearly saying, having determined what the legislative intent was, we find that our state constitution trumps that legislative intent. I don't think there's any other way to read it. And that is a real problem, it seems to me, under Article 2, because in fact, there is no right of suffrage under Article 2. There's a right of suffrage in voting for the legislature, but Article 2 makes it very clear that the legislature can itself appoint the electors.
But it seems to me that it's already been conceded that the legislature can delegate that function to the judiciary. And when Justice Kennedy asked if it can delegate the function to the judiciary, and that is what McPherson seems to suggest, then can it not delegate something less? That is, can it not give the judiciary a role of the sort that it's exercising here? After all, the legislature, and this is important, it's not true in every state, the legislature itself re-promulgates the Constitution every several years, and then it's ratified by the people.
Isn't there another? No, please.
That's all right.
Isn't there another way of looking at what the Florida court did, and that was, in effect, to apply the statute, the interpretive criterion, that where there is any discretion for interpretation, an unconstitutional result should be avoided. And because you have here a statute, as I understand it, that regulates both federal and state recounts, that much is, I think, is clear. The only way to avoid an unconstitutional meaning of the statute so far as Florida law was concerned was to get into this constitutional concern about preserving the franchise. And that because the legislature intended one standard to cover both federal and state recounts, it therefore is valid to consider the state constitution in order to derive a general meaning that will apply to a federal as well as a state election. Can you look at it that way?
I fully accept that view, Justice Souter. I would supplement it with one important point. We're not dealing here with a decision in which, within the gray area where a court could reasonably go either way, this court simply said, we don't care about these federal considerations. It, in particular, exercised its equitable powers in favor of the petitioner in order to facilitate meeting the December 12 deadline while still being able to have electoral contests. That December 12 deadline comes purely from federal law.
Can you just go back to your characterization of the opinion? I think we'd all agree that given that the legislature has to select the manner, a state can't say, our Constitution selects the electors. I suppose
I think that's right.
All right, but thinking of this opinion, suppose the court had said, look, we reach our result based on the canons we found in Blackstone. Now, nobody's going to say they've said Blackstone selecting the electors, right?
I think that makes sense.
Now, I suppose they said we reached this decision based on the values found in the Constitution. That would be like Blackstone.
I think
but suppose they say, well, the legislature wants us to do X, but our Constitution requires us to do not X. That might be different.
It might be
different. What is it that they've done here?
Well, I certainly don't think they've done the third. They did not say. I think when they underscored the presence of language that Justice Scalia read about what's mandatory, they were simply being candid about the fact that they were acting in conflict with one part of the statute, but the
adjacent... in a separate section of the opinion, Professor Tribe, that is entitled the right to vote. It is after the legislative intent section, and it says categorically, to the extent the legislature may enact laws, they're invalid. And I suggest perhaps the reason that the court did it is that however expansive the doctrine of constitutional doubt is, there is no way that it can make December 7 mean anything except December 7. I mean, they were almost constrained to use the Constitution to override the firm deadline that was explicitly set forth in the Constitution.
Justice Scalia, both you and I think at one point Justice O'Connor, in pointing to the particular dates that came out differently under the approach that this court used from what would have emerged if they had looked only at 102.111, are making a mistake, with all respect. It's not as though this court promulgated a rule for the future about December 7. In commemoration of Pearl Harbor, we say December 7 is the day. No, what they did was say we have to find a date which will accommodate these conflicting statutory provisions and policies in light of what our Constitution tells us. And we surely, it would amaze, I would think amaze this court to see anyone saying that because an opinion was organized under Roman numeral headings,
Professor Tribe,
in such a way that
isn't it also true, Professor Tribe, that Part 8 of the opinion relies on 4 things: the Florida Constitution, earlier Florida decisions construing statutes, an Illinois case, and a federal case.
Absolutely.
Not just the Illinois Constitution.
And surely, is it also true that the inability to use Section 7 depended in the Florida Supreme Court's reasoning not on the existence of the Constitution as a sole reason, but on the inability to make the December 7 date final and provide for the recounts within the times in which recounts can be called for. So that's what I'm saying is, didn't they say that the date of the 7th cannot stand, not because of the Constitution alone, but because there are other provisions in the statute that cannot be accommodated with sections with the 7th date?
Exactly.
Yeah.
And I guess
they said that twice, and I think that's critical. If you add to that we read a decision of a state court in the light most favorable to that court and not in the light least favorable, I suppose there would be a possibility for this court to remand for clarification. But if there's 2 readings, one that's questionable, one that isn't, all of our decisions suggest that we read the one.
Especially, I think, Justice Ginsburg, when the odds that these conceivable federal problems are indispensable to this result are overwhelmingly negative. That is, it's not as though one cannot explain the result this court reached in the most conventional, standard ways. And the fact that
Professor Tribe, I would feel much better about that resolution if you could give me one sentence in the opinion that supports the second of these supposed alternative readings, that supports the proposition that the Florida Supreme Court was using the constitutional right to vote provisions as an interpretive tool to determine what the statute meant. I can't find a single sentence.
I think, Justice Scalia, I can do a little better than find a sentence. The entire structure of that part of the opinion, as Justice Stevens points out, would be incoherent if the Constitution was decisive. That is the highest law in Florida. Why bother with all the rest if that is anything more than an interpretive guide?
You would bother with it because, having decided very clearly what the statute requires and finding no way to get around the firm date set, you say the reason it's bad is because of the state constitution. That's how it's written. Now, but they might have tried it another way, but it seems to me they didn't.
They also say that the provision that reaches the result that conflicts with the authorized recounts was written in 1951, that in 1989 they wrote a provision that unmistakably created discretion, and we haven't yet discussed this provision also created the provision that when the returns are filed late, it doesn't say throw them away, it doesn't say give them back, it says fine every member of the canvassing board $200 a day. That would be a totally crazy provision. As this opinion understands, if you were not to reach a reconciliation of this sort, this result was overdetermined under Florida law. It might be true that they said the Constitution also points this way, but there isn't a sentence in the opinion that suggests that without that constitutional argument, the result would have to be different.
What is the November 26th date? Is that the 7-day date moved? Or is that some kind of a date that tries to reconcile the ultimate point after which the Secretary, in exercising her discretion, no longer has to accept the late returns? Did it move the date from the statute? Is it created a new date about this discretion? What is it?
Well, it looks to me like an exercise of the Chancellor's foot, as it were, in this particular case. When I saw the date, November 26th, I couldn't come up with an algorithm or a formula that would generate it. But the court was confronted with the task of drawing, as this court has recognized, what are sometimes inevitably arbitrary lines. That is, it said it was not consistent with the overall scheme of the statute to require these recounts, which had just begun, to terminate. That truly would be a promise to the ear to be broken to the hope, like a munificent bequest, Justice Jackson said. And if the paupers will, why tell people to count if you won't count it? And
if the legislature had jumped into the breach and said this same thing, would that be a new statute or new enactment under 5 U.S.C.?
You see, I honestly, Justice Kennedy, I'm not sure, because the language that I quoted from 3 U.S.C. Section 5 focuses on the institutional dispute resolution arrangement that is in place. And if you look at the legislative history in the decade of hearings in the period after the Hayes-Tilden debacle, that history focused on the importance of having a fixed tribunal which you could look to, rather than one cooked up at the last moment. And indeed, what they seemed to be most afraid of was the political entry of legislators and executives at the 11th hour. There was no focus at all.
But are you saying you can't tell us whether they, in the hypothetical, suppose that that would be a new enactment?
Well, there certainly are no cases on the subject. The language gives me very little guidance. Since the section is addressed to Congress, neither my opinion about it nor the court's opinion is necessarily...
You don't think you could tell us what you might advise the Congress if you were the counsel for the Judiciary Committee?
I think I would advise the Congress that it is not a new enactment, that it is an entirely reasonable construction of an existing enactment, as to which the only alternative construction is to make it self-destruct and to make it internally contradictory. And I honestly don't think, if I were advising Congress, that I would say it's a new construction. I do think also that some people reasonably could argue the contrary. And I guess I think that this language should be interpreted, whether by a court or by Congress, in a way that gives some deference to the state government and its organs. And I think any degree of deference here is inconsistent with saying that there's been a federal violation, especially when I want to remind us all about the context. Are we going to say that this paragraph in this opinion says that Florida is in breach of Article 2 of the Constitution in general? Hard to say. I don't
There
think so.
should perhaps be some deference, though, to the concept expressed in Article 2 that it is the authority of the legislature, and some special concern about what the legislature may have said.
Yes, but if the legislature is entirely happy not to completely delegate this power to the courts, which Article 2 would permit, but rather to allow the courts to exercise a somewhat more flexible role than the one that the critic of this opinion would be embracing, that's within the power of the legislature of Florida.
But who would have thought that the legislature was leaving open the date for change by the court? Who would have thought that?
You just read the statute in 1989 and it says may. It says she may reject the late
That doesn't change that's not the date.
No, the date is the one from which the may is measured. That is, you're supposed to get it in by 7 days later. What if you don't? Well, if you don't, she may or she may not reject them. Now, anybody reading that would realize that's a deadline only in a kind of Pickwickian sense. It's not a real deadline. She's got discretion. Certainly, if there's an act of God of the sort Justice Stevens asked about,
well, then the secretary came in and argued and said, yes, her discretion was if it were an act of God or a machine breakdown, she would exercise her discretion.
And it's an entirely normal exercise of judicial interpretation to say that this statute is not limited to God and machines.
Professor Trump, can I ask you why you think the Florida legislature delegated to the Florida Supreme Court the authority to interpose the Florida Constitution? I mean, maybe your experience with the legislative branch is different from mine, but in my experience, they are resigned to the intervention of the courts, but have certainly never invited it.
Well, I have to say my experience...
What makes you think the Florida legislature affirmatively invited the Florida Supreme Court?
The odd thing is that the system in Florida involves their own repromulgation of the Constitution, and their scheme with respect to the resolution of disputes over elections draws a sharp distinction between elections to their own House and Senate, which they won't trust the courts with as far as they can throw them. Those are to be resolved exclusively in the House and Senate, and all others are to be resolved in the courts under a standard that they understandably
they are resigned to, but they need not be resigned to the Florida Supreme Court interposing itself with respect to federal elections. They need not be, because the Florida Constitution cannot affect it. And I just find it implausible that they really invited the Florida Supreme Court to interpose the Florida Constitution between what they enacted by statute and the ultimate result of the election.
Well, I suppose if they were at all farsighted, if they looked at their own work and saw how self-contradictory it was, they might say we would want someone with the authority to reconcile these provisions to do so in the light not only of the literal language, but of the fact that they're dealing with something very important, the franchise. The disenfranchising people, which is what this is all about, disenfranchising people isn't very nice.
But wouldn't
Justice violate the federal as well as the state constitution?
But wouldn't Justice Scalia's suggestion be a stronger suggestion if they had dealt by this statute only with federal elections, or only with the presidential election, as opposed to dealing with both state and federal in the same statute?
Well, it's not uncommon, given the convenience of having similar regulations apply on election day, not to bifurcate. Oregon v. Mitchell, after all, confronted the nation with a problem.
Right, but when they don't bifurcate, it's reasonable to suppose that they expect their statute to be construed, number one, as one statute, not as having different dates for state and federal, and number two, to be construed, so far as the state concern arises, in accordance with the state constitution. And if that is so, then the result is they would expect a state constitutional concern to inform their interpretation of a statute which ultimately governs federal as well as state.
And they would recognize that when the federal election involves the presidency of the United States, with the special problems of the electoral college deadline, they might emerge with rather different deadlines and, to some extent, a different approach for the two elections.
But there are already different deadlines for federal elections, aren't there, because of the federal statute concerning overseas ballots?
Yes, that's entirely true.
That's going to be different anyway.
And there's
but that's different as a result of federal law, isn't it?
Well, there is a consent decree arising out of federal law. But it
wasn't the legislature's choice, it was Congress's choice that required that.
In 1986, there was a congressional statute that already created that difference.
Mr. Tribe, before you finish, I would like to know whether you are conceding, because some of the things you said sound like maybe you are, that the Florida legislature, under Article 2, Section 1, could say, we don't want any judicial review of anything about the manner in which we say electors should be appointed. Does the Florida legislature have the authority to cut out judicial review?
No, I certainly don't think so. They cut out judicial review, and even this may not be entirely consistent with the Florida Constitution. They cut out judicial review for the election of their own members in the House and Senate. I certainly don't think they would have the authority to expel the federal judiciary from the election of
the state judiciary, when it says each state shall appoint electors in such manner as the legislature thereof may direct. May the legislature direct as to the Florida Supreme Court. And Florida Supreme Court, we don't want you to review whatever we do.
I'm not actually clear about that, Justice Ginsburg. I've thought about it a lot. It seems to me that under Smiley v. Home, in similar cases, the general principle is that the Constitution takes the state government and its arrangement as it finds it, and that when the legislature is identified, that really does not mean the legislature in some specialized capacity, as with Article 5. Now, if that's the case, and if it's therefore assumed that the legislature is surrounded with both executive and judicial authority, then a decision by the legislature to completely exclude the judiciary from any possible role, the state judiciary, might be inconsistent with the underlying meaning of Article 2 itself.
Well, could the state legislature at least now say, in light of all this confusion, we enact a law today saying this is the way electors will be selected?
Well,
is that open to the legislature now?
I'm not sure. That's very much like my inability to answer, because I honestly have not reached a conclusion, and it's not presented by this case. I don't know whether the legislature could do the further thing of naming electors, and if it doesn't do that...
Thank you, Mr. Tribe.
Thank you, Mr. Chief Justice.
Mr. Olson, you have 4 minutes remaining.
Thank you, Mr. Chief Justice. May it please the Court. It seems to me that it's very difficult to read the Florida Supreme Court decision as saying anything else other than the Florida Constitution, in their view, in that court's view, is trumping everything else. The second paragraph of the conclusion says, because the right to vote is the preeminent right in the Declaration of Rights of the Florida Constitution, and so forth. This opinion is full of language.
Wouldn't they, I suppose they'd refer to the Declaration of the Rights of Man, to the 1789, the French Revolution. I mean, the right to vote is a value in the Constitution. Are they actually saying, I didn't see it? Or they say the statute means one thing, but the statute's unconstitutional because the Constitution of Florida says the opposite? I didn't see that.
I think that the only reasonable, fair reading of the decision is that the Florida Supreme Court felt that, and it says it over and over again, that we are going to attempt to discern the will of the people, the will of the electorate, and discern and enhance in whatever way we possibly can the right to vote. And because of that, these provisions of the statute, which are very much quintessentially legislative, the timetables that are involved in this statute, particularly the November 14th deadline, is a part of a composite package. There's 1 week for a protest and certain recounts to the extent that they can be done, and there are 4 weeks for contests. When the Florida Supreme Court truncated, when the Florida Supreme Court expanded the protest period from 7 days to 19 days, it necessarily limited the contest period to a shorter period of time. It changed the discretion. It allowed certain things to occur that couldn't have occurred, and it justifies all of those things on the grounds that the Florida Supreme Court, the Florida Constitution, trumps those legislative concerns. And that's why it said we are not going to be dissuaded by hyper-technical statutory considerations. So the court was doing what this court said in the McPherson versus Blocker case that it cannot do, is allow itself to insert itself, or the Florida Constitution, above what is required by Article 2, Section 1 of the Constitution. It also seems to me quite evident in response to what Justice Kennedy was asking earlier, that there was concern about the federal statutory provision. The language to which I think Justice Kennedy was referring is on page 32A of the appendix to the petition from the court's decision, and there's a footnote there that does refer to reference to 3 U.S.C. 1 through 10, which of course includes Section 5. And it says so in conjunction with the statement that the exercise of the discretion by the Secretary of State could not be done in such a way that would preclude Florida voters from participating fully in the federal electoral process. The court was assuming, it seems to me, that it was not conflicted. The decision that it was rendering was not going to cause a conflict with the federal statutory scheme, and it was, we submit, in error in that regard. So to sum up with respect to this, the Florida Supreme Court radically changed the legislative scheme because it thought it could do so under the Florida Constitution. By doing so, it acted inconsistently with Article 2 of the Constitution and inconsistently with Section 5 of Title 3, and it has brought about precisely the circumstances that Section 5 of Section 3, Title 3, was designed to avoid.
If I look at in the conclusion, the paragraph on page 37A, where they summarize what they said, there's nothing there about the Florida Constitution. It's only about the Florida Election Code. They say they must construe the Florida Election Code as a whole, and they point out the provisions in conflict. There's not one word in that paragraph that says anything about the Florida Constitution.
The very second paragraph refers to the Florida Constitution and the rights to vote. Page 36A of the appendix to the petition.
Thank you, Mr. Olson. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
All right, and there you have it, the recording of historic arguments in the case of George W. Bush versus the Palm Beach County Board of Canvassers. Now, you'll notice that at the very end, the marshal there said that the court's going to reconvene Monday. Don't read anything special into that, because the court was going to reconvene Monday anyway. We don't know when we're going to get a decision, what kind of decision, but we've got some folks here who can help us sort it out. Joining me right across the street here at our location across the street from the Supreme Court, constitutional scholars Bruce Fein and Paul Rothstein. Also joining us from the Supreme Court itself, closer to the steps, Steve Centani, and in New York, Judge Andrew Napolitano. Let me begin first with two gentlemen who haven't had a chance to speak yet. Bruce Fein, you were saying before the arguments began that you thought the court was going to kick this back down and not make a decision. You still think so?
Yes, I do. I think that the Chief Justice and Justice Souter seemed very adamant on the idea that Congress itself has enacted a rather comprehensive scheme in Section 15 of the Electoral Count Act for determining disputes as to whether or not a state judiciary has rewritten state legislative laws that were there prior to the election or not, and that it ill behooves the U.S. Supreme Court or any federal court to get involved. Moreover, that kind of theory would be totally in sync with all the Supreme Court federalism decisions that they've issued, much to the chagrin of liberals like Al Gore, for the last 4 or 5 years. There was some sharp questioning by Justice Scalia as to whether the state legislative enactment was really interpreted by the Florida Supreme Court as opposed to the Florida Constitution. I think ultimately, however, the pressure for unanimity would push the suppression of any kind of dissent on the theory that this really wasn't an interpretation of a statute, but an artificial limitation on what state legislatures could do that was imposed by the Florida Supreme Court. I would expect a decision perhaps Tuesday or Wednesday of next week, and I think the Chief Justice will write it, and we'll be back to the Florida state courts where we are right now.
Paul Rothstein, let me ask you, it seemed that we had sharply different lines of questioning, and it basically breaks along the ideological lines that people may expect. Ruth Bader Ginsburg spent a lot of time asking questions about proper deference to the Florida Supreme Court. Do we read anything into that?
I think you're right. There was some breaking along traditional ideological lines, but what went across all lines was the fact that most of the justices did seem to be reluctant to buy the Bush argument whole hog, that somehow the Florida court was legislating. They didn't want to condemn it on that ground. So almost none of them did, because that would involve condemning something that the United States Supreme Court frequently does. Techniques that they use are the same as the Florida court. There was substantial agreement across ideological lines to take what seemed really a good way out of this, to just say that this statute that they're trying to interpret wasn't meant to apply now. It's meant to apply if and when there is some kind of contest in the United States Congress over competing slates of electors, and therefore it's premature now to even consider this, and then they just get out of the case and wait. Also, I think some of the conservative justices had a little different idea, another easy way, but this time condemning the Florida court, but on a much narrower ground than we had talked about, and that was to say that the Florida court injected the Florida Constitution into its decision, whereas the federal law requires that the legislature, legislative dictates, not constitutional dictates, shall govern. So there was some sentiment for that. Justice Breyer said, however we decide this controversy, whether the deadline was on November 14th or November 26th, Bush has won, and there is a contest going on. It doesn't make any difference. So let's get out on that ground.
Okay, Judge Napolitano, let me ask you, based on what Paul Rothstein just said, is it conceivable to you that the court could kick this back out for now, but then entertain it again at some later date?
Yes, I think it is conceivable, and I sort of agree with both Paul and Bruce that there does seem to have been in the questioning that consensus that this is not the right time to come to us. But I also see some language saying the legislature trumps the court when, in the state systems when it comes to setting down the regulations for electing the president, and the Congress decides what electors are going to come to Washington, D.C., but you can still come back to us when all of this is over. At the present time, it's moot.
Well, I could less dissent from that just modestly, because that idea was raised before Chief Justice Rehnquist that after Congress opined, could the Supreme Court get involved then? And Rehnquist raised his eyebrows about 5 feet and said, no way, we're not going to try to change a president who's sitting in the White House.
Well, after Congress opines, of course, that's pretty much it.
Yes.
Yeah, I would say, yeah. Okay, Steve Centani, right after the arguments, you seem to think that the Gore camp had sort of gotten the better of it. On second hearing, do you still have that opinion?
That the Gore camp, I'm sorry, Tony, that the...
sort of got the better of it?
Gore camp got the better of it? I believe they did, because a lot of the justices really questioned whether or not this law applies at this stage of the game. They were struggling to see whether or not there was a federal question and whether or not this law really regulated what the states do at all, but rather advised them of how to make sure that their slate, once they submit it to Congress, is conclusive and acceptable. And so from that perspective, of course, I think they had serious questions with the Bush camp's claim that there was a clear violation of Title III, Section 5. But by the same token, as you heard your two experts talk about, there is a question of whether or not the Florida Supreme Court acted properly and whether or not it could have violated Article 2 of the Constitution, which grants the legislatures the sole power to determine what slate of electors is going to be presented, and whether or not by relying on their state constitution they may have violated Article 2. So it does go both ways, and it's an interesting point to speculate on, that they may find that the case is moot at this point and revisit it later on, in which case we'd all be back out here again, including all the protesters, and we'd have this mass scene out here once again. Now, of course, the waiting begins to see what they say about what they heard today, and that we expect some kind of decision to come down fairly soon, possibly by the middle of next week. Tony?
Okay, Paul?
I did want to add, Tony, along the lines of your notion that there was an ideological divide, that on the personal level, Rehnquist and Scalia seem to take some personal delight in raking Mr. Tribe over the coals. They're sort of old enemies. And Ginsburg and Souter and Stevens felt that they had to come to Mr. Tribe's defense.
Yeah, they asked a series of pretty leading questions.
Yes, right.
Isn't it true that, and fill in the blank? Right. Let me ask you a question, though, Bruce Fine. It seemed at the very end, Ruth Bader Ginsburg was trying to address the possibility that the Florida legislature could come in and elect, basically appoint a slate of electors, and she seemed to be asking whether the Florida State Supreme Court could assert review over that.
Yeah, and suggesting the answer was no. That is, the state legislature could decide to remove the state judiciary, the state, not the federal judiciary, the state judiciary entirely from the electoral process within the state. And I think the answer is yes. And indeed, the state judiciaries were excluded for the first 50 or 60 years of our existence, where there were no popular elections, there were no contests, there were simply direct elections by the state legislatures. And I think that is at least a hint to the Florida state legislatures. If you want to go ahead and elect the Bush electors before this dispute is finally resolved in the state courts, if you do it, it's not going to be questioned by us.
Andrew Napolitano?
Tony, I agree entirely. With Bruce. In fact, I made some notes during the oral argument that Assistant Attorney General Hancock at one point conceded to the court, I don't remember which justice asked him the question, that the legislature can name its own electors. I agree with Bruce. That's not reviewable by the Florida State Supreme Court.
So go ahead, Paul.
I was going to say one thing that might have mystified the listeners to the Supreme Court argument is the fact that it was not in argument as to whether or not hand recounts, selective and without standards or not, whether those kind of hand recounts are somehow constitutionally unfair or violate voters' rights or due process or equal protection laws. None of that was in play in this decision, in this argument, and that may mystify the listeners, but it is not part of this case. case, and it is for that reason that many of us feel that this case doesn't have a lot of practical significance.
Okay, Paul, and as a matter of fact, that case, a case talking about the legitimacy of various hand recounts, is now before the 11th U.S. Circuit Court of Appeals in Atlanta, Georgia, and it may yet end up before the Supreme Court, but that's for another day. We're going to take a break. We'll be back with more. Stay with us.
Govern the settlement of any dispute or contest regarding the electors. A lot of back and forth on that. Greta, Roger, translate a little bit for us.
Well, here's the problem, Frank, is that according to the Bush campaign, is you can't change the rules midstream after the fact. They say that Election Day was a drop-dead date and that the rules were changed. The rules that Congress has given the state legislature sort of a safe harbor in terms of when they have to resolve their dispute. What the Gore side has said, wait a second, the rules weren't changed. All the Florida Supreme Court did was interpret the existing law in the state of Florida. In fact, it was Justice Stevens who commented during the argument is that when he asked a question, he made the statement that wasn't the Florida Supreme Court simply interpreting, using these sort of standard statutory construction rules, weren't they just interpreting conflicting state laws, or were they creating new law, something that Justice O'Connor might perhaps sink because she made the statement that there was a dramatic change when the Florida Supreme Court changed the time from when the certification would have to occur. Now, what the Supreme Court will do, you got me.
Roger?
Well, the other side of it is, and I think the other part of the argument was, look, let's assume that there was something wrong under the dictates of Article 3, Section 2, then R5, then the next question is, what do we do about it? What is the proper remedy? Is the remedy here before the Supreme Court? And let's suppose that the Florida State Supreme Court did act out of line. And what they were suggesting is that the remedy may very well be with Congress and not with the Supreme Court, and that they shouldn't be here with the Supreme Court, that perhaps down the line, if Congress does something that the Supreme Court doesn't agree with, then maybe come back then. But as for now, they were suggesting that Section 15 of that statute that you cited would seem to indicate that they should go to Congress for a resolution rather than the Supreme Court.
And here's the interesting thing, Frank. What Charles was talking about is that they may never even reach the issues that Roger and I were just talking about. I mean, the first thing they confronted the lawyers with is, why are you here? Do you have a right to be here? Is this a federal issue or is this a state issue? And it's completely plausible that the court would suddenly decide, look, this isn't a matter we should get into. This is a matter that should be left to the states. On the other hand, they may think that there's a sufficient constitutional argument, and for that reason, it does belong in the United States Supreme Court. And then they move to the second question, is whether or not the Florida Supreme Court violated the federal law or violated the Constitution. And if so, we go to sort of the third question, which the Supreme Court may never answer. It's really a matter for the parties, is if they do find a violation, now what? What's the practical effect? And at this point, with this very, very shifting landscape on this case, both in state court in Florida and here in the Supreme Court, is that no one's really sure what would be the practical effect.
Greta Van Susteren and Roger Cossack, very much many thanks. And if there's ever a special day for burden of proof, this is it. You got an awful lot to get your arms around. We wish you luck on that. To Charles Bierbauer, Ken Gross, and all the others who've been with us this day, we're going to have a lot more ahead. We'll leave you with a quote, as I said, from Ruth Bader Ginsburg, who teed up this question as to whether this is a federal issue at all. She said, "We owe the highest respect to state courts' interpretation of state law." Will that be what carries the day or not? I'll be back with a little bit more of this right after this very quick break.
You had a little exchange between Justice Sandra Day O'Connor and Ted Olson, who is the chief attorney for George W. Bush. Justice O'Connor asked basically the equivalent of Admiral Stockdale's famous question. She asked, who are you and why are you here and why should we be deciding this case? And that was Ted Olson's response. A little bit after the arguments concluded, our Rita Cosby had a chance to speak with Ted Olson, and here's a part of their conversation.
Court?
Well, they certainly understood the reasons why we brought it to the court. That doesn't mean that they will ultimately agree with us, but they did agree to take the case, and they understood why we thought it was important. And so we're very gratified by that. Now, where they will take it, I don't know, because once they take a case, they still have to decide whether we're going to actually decide it or whether we will decide we shouldn't have taken it. That is always possible.
What did you find the toughest questions that you were facing by a number of the justices?
Well, you tend to forget, but they all seem tough. The questions that related to whether this case should be decided by the Supreme Court, whether the court should let the process go in Florida, those are very tough questions, questions that we expected, questions that we thought we gave very good answers to, but they're all very hard questions. It is, on both sides of the case, there's hard questions to be asked.
Okay, now welcome back. We're here in sort of a bit of bedlam outside the Supreme Court. Even though arguments ended a little more than an hour and a half ago, the protesters are still lingering and screaming out their lungs, and you can hear a few of them. But let's go back to Steve Centani, who's closer to the Supreme Court, and get his reaction again to some of the key issues. Now, Steve, Steve's got a guest, and we're going to turn to him. Steve?
Yeah, Tony, I have Senator John Ashcroft here, who was able to go inside the Supreme Court chambers and hear today's arguments. And we want to get his reaction right now. Thanks for joining us, Senator.
Delighted to be here. It was a great thing to be.
What were your impressions?
Well, first of all, there are a lot more people there to listen to this argument than there have been when I've had the opportunity to argue before this court. So it was a great day, orderly, obviously, aggressive participation by all of the court, focusing on really a central issue. And that issue is, were the rules changed inappropriately after the election? You know, the Constitution of the United States provides that the legislature shall make rules regarding the selection of electors. And the question is, one, did the Florida Supreme Court usurp that when it changed the dates, when it changed the discretion of the Secretary of State? And number two, there was a 1870s statute which followed the Hayes-Tilden debacle, where we had tremendous confusion about the election of the president. And it said you shouldn't have different rules after the election than you have before the election. The question whether the Florida Supreme Court improperly changed the rules in that respect. So the focus is on whether or not the Florida Supreme Court improperly changed the rules, either against the Constitution by usurping the legislature or against the statute passed in the 1870s.
On the question of the statute, there seem to be a lot of justices who question whether or not that statute should apply at this stage of the game. They seem to think, including Justice Rehnquist and Justice O'Connor, that it might apply when this goes to Congress and there's a disputed slate of electors before Congress.
Yeah, there is a question about whether the statute is supposed to guide the legislature in Florida, or whether it's supposed to be a way of inhibiting someone like the court, or whether it simply sets up a set of rules about the way the votes would be counted once they come back to Congress. In any event, I think the clear focus of the case today is, did the Supreme Court improperly change the rules, either by usurping the power of the legislature given to them by Article 2 of the Constitution, or else this statute?
And there didn't seem to be agreement on that either. They seem to be struggling with it toward the end there.
I think it's pretty clear this could be a divided court. Of course, America is accustomed to the fact that the Supreme Court on very important issues is not always unanimous. And of course, there is some comfort to many, because no matter how the court rules, it would not set aside the certification of George W. Bush as the winner in Florida. That was clearly stated both by judges interrogating the attorneys and by the attorneys, that the outcome of this case today does not disrupt or set aside the certification of George W. Bush as the Florida winner.
How do you think they're going to rule? There's some suggestion that they might find it to be a moot point at this point and revisit it later.
Well, I'm not sure. I noticed Justice Scalia talking about the constitutional issues, and you know, the constitutional point from Article 2 wasn't discussed very thoroughly, but I think it's one that underlies the rest of the argument, and I don't think that some of the justices will want to say offending the Constitution is inconsequential. So for them, I think they're likely to want to rule in this case.
Okay, we're really going to have to wait and see. It could go either way, couldn't it?
I think the court will be divided. If I were pressed, I would hope that they would see that changing the dates and changing the authority of the Secretary of State is really a rule change and improper to do after the election.
Well, thanks for joining us. We appreciate your opinions on this. Senator John Ashcroft joining us live outside the U.S. Supreme Court chambers. Tony Snow will have more on all this right after this break.
Spectators at Indian Creek, Miami, see Guy Lombardo and his 12-cylinder Tempo 6 tune up for a crack at the records as the popular maestro roars over a measured mile. He's out to top Gore Wood's 124-mile figure with Gore himself looking on. A crescendo of 12 cylinders as Tempo 6 hits the choppy waters at over 112 miles an hour. Now over 113 miles, and while Gold Cup records shatter, Gore's time still stands.
Before we go back to Tony Snow and the team in Washington, as we speak, of course, the U.S. Supreme Court is considering a historic decision. The justices questioned both sides today during George W. Bush's suit to overturn Florida's recounts ordered by the Florida Supreme Court. But there are legal proceedings in state circuit court, too, and another ballot caravan is heading to Tallahassee. As for the candidates, they've been watching and waiting and planning for possible administrations. All sides have had their say before the U.S. Supreme Court and fielded some tough questions from the 9 justices. Some justices asked why the highest court in the land should interfere in contested election results in Florida. Governor Bush's lawyers are trying to convince the U.S. Supreme Court to overturn a ruling by the Florida Supreme Court. They argue the ruling that extended the deadline for vote recounting rewrote Florida election law. That brought a sharp response from Justice Ruth Bader Ginsburg. She said she did not know any case that impugned a state Supreme Court the way the Bush argument did. Gore's lawyer argued that Bush wanted the justices to turn back the clock on election laws. Harvard law professor Lawrence Tribe likened the vote recounts to a photo finish in a race. He said the issue is whether a state can magnify the photo to see who really won. Tribe said he expects the High Court to rule on the issue by early next week. Back in Florida itself, the ballot battlefields are expanding. New lawsuits been filed in Florida State Court contesting the election, filed on behalf of unidentified voters. It asks that all absentee ballots in Martin County be thrown out. That could cost Governor Bush 2,800 votes. The lawsuit accuses the GOP of tampering with hundreds of absentee ballot request forms. That lawsuit is actually similar to one in Seminole County. In that case, a Democratic activist charges illegal handling of absentee ballot request forms. Meantime, Bush lawyers asked a circuit court judge, M.N. Sanders Sauls, to send for another 1.25 million ballots from 3 counties. The judge has yet to consider the request. Al Gore lawyers asked the Florida Supreme Court to order hand recounts started immediately. Bush's legal team counters with a motion to throw out Gore's contest of the election. They argue the real election dispute is between separate groups of state electors, not Bush and Gore, and there are reports the Bush team plans to call 95 witnesses if the case actually goes to trial as scheduled December 6th. Meantime, about 600,000 ballots from Miami-Dade County are being trucked to Judge Saul's court in Tallahassee. More than 500,000 from Palm Beach County are already there. The judge has scheduled hearings today and tomorrow on Gore's challenge to the certification of Florida election results. A Supreme Court ruling may not actually end Al Gore's Florida election challenge. In an interview with the Associated Press, running mate Joe Lieberman said the Gore camp believes the final decision will come from, not the U.S. Supremes, but the Florida Supreme Court. But the Connecticut senator acknowledged the U.S. Supreme Court could eventually
have the last word. Meantime, the Democrats have been working on transition plans. Sources say the group wants to create a grassroots panel of community leaders to advise Gore on building his administration if he gets one. Meanwhile, claiming victory, George W. Bush says one of these days, that's a quote, one of these days he'll prevail. In the meantime, the governor is continuing planning for a new Bush administration. The governor and his wife, Laura, are planning to return to Austin today for a Christmas party. They'll be back at their ranch in Crawford, Texas tomorrow. That's where Bush plans to meet with House Speaker Dennis Hastert and Senate Majority Leader Trent Lott. The governor spent most of last week on the ranch. Yesterday, he held meetings with retired General Colin Powell, who you see in the picture, along with running mate Dick Cheney. Powell is expected to be offered the position of Secretary of State. We'll have more updates throughout the day. Now, more on the arguments before the United States Supreme Court with Tony Snell.
Thanks, John. Well, we've moved to a quieter climb right next to the U.S. Supreme Court. And as John just mentioned, there's a lot of activity going on today in Florida. For an update, we go to Tallahassee, where our Rick Leventhal is standing by. Rick?
Tony, yeah, John touched on a couple of the matters. We've got a couple of hearings scheduled for this afternoon. One of them scheduled to start in just a few minutes in Judge Nikki Clark's courtroom. She's holding a hearing on that Seminole County case where a Florida Republican staffer is accused of spending between 15 and 30 days in the election supervisor's office, filling out more than 2,000 ballot applications that weren't completed by voters. Apparently, they were missing voter ID numbers. The apparent purpose was to ensure that the votes were counted. Now, Democrats have protested that, asking that all absentee ballots in that county be thrown out, which could cost George W. Bush thousands of votes, although most observers believe it's unlikely. Now, they're supposed to be deposing witnesses in this case today. The trial isn't scheduled to start until next Wednesday, and a similar case has been filed in Martin County, also by Democratic voters, also over absentee ballots that were allegedly filled out improperly by Republicans. Now, meanwhile, the contest continues, sort of, in Judge Sanders Saul's courtroom today. He's holding another hearing at 3 o'clock this afternoon, but it's apparently just a planning hearing to work out logistical questions and issues that have been raised regarding Saturday's hearing, which is scheduled to start at 9 a.m. Of course, tomorrow, a big day in the contest battle as attorneys for Al Gore fight to get some 14,000 so-called questionable ballots counted, and Bush attorneys fighting that, saying if you're going to count those ballots, then count them all, possibly more than 2 million of them. As you heard John mention, those ballots from Miami on their way here should arrive, we're told, within a couple of hours, Tony, so we will be standing by to bring you that as it happens. Tony?
All right, Rick, thanks so much. We've also got a new batch of Fox News Opinion Dynamics polls bearing on the question. We're taking a look at the politics of the issue. Question number one, who do you think actually won the election? There you see all voters, Bush 56%, only 25% say Al Gore. Also, if you had to vote again, who would you vote for? That is the next question that we asked in the tally. And if we can pull it up here, there we go. If the election were held again, you see that Bush would get 49% of the vote. Al Gore would get 36% of the vote. How about the favorables of the two men? Once again, let's take a look for favorables. George W. Bush's favorable today is 60%, as opposed to 56% just before the election. Al Gore's favorable, 46%, as opposed to 54%. And finally, we asked, why do you think Al Gore keeps fighting on? The vice president has said he's sure he has more votes. Most people, 66% of those responding said he's fighting for himself. 19% said fighting for democracy. And 12 said a combination of the above. So there you have a quick snapshot of public opinion. We're going to take a quick break. When we return, we're going to talk to Fred Graham of Court TV about today's proceedings before the United States Supreme Court.
A century-old lace veil over a filed taffeta and lace dress, Grace Kelly is escorted by her father to the altar of Monaco's St. Nicholas Cathedral. The moment for the ultimate church wedding that will complete a romance between the 26-year-old American and the 32-year-old ruler of the little principality. And Prince Rainier III has a smile for the vision he will make his princess. bride's parents are intense spectators as the ceremony begins. Performed by the Most Reverend Gilles Barth, Bishop of Monaco, and consecrated according to the rites of the Roman Catholic Church with double marriage rings. At the low mass that follows, the happy pair make a solemn but handsome appearance. Partaking in a papal blessing with reverence and humility. At long last, all the arduous ceremonies are over, having gone through with their civil wedding a day earlier. Only a ride through the cheering Monegasques remains. Then they're off on Prince Rainier III's yacht for Pollença in the Balearic Islands.
South Bend, Indiana, animated symbol of Notre Dame, flashing true mid-season form today at the expense of Illinois. There's Stevenson, fighting Irish wingback on a sweeping end run of 13 yards to a first down. Zontini, on another gallop around the flank of the line, penetrates further into Illini territory. These Irish are really on the wing today, undefeated and untied. They point to national recognition. Notre Dame's ball again to Stevenson, who fades. Let's go, a looping pass to Brown, standing on the goal line, and that, my fellow quarterbacks, is how touchdowns are made. Notre Dame leads at the end of the first quarter, 7-0. Tonelli, Notre Dame fullback, provides a third-quarter thrill when he snakes his way through the Illinois secondaries, walled in, laterals to Sheridan, who mops up everything in his path, including the water bucket. Defensively,
boundaries in a different direction for Florida court.
What about the argument that I have heard is it was made a reference to it in the written pleadings, which said if you push the certification back to November 14th from November 24th, that what happens is that the contest filing that was filed on Monday is untimely, right or wrong?
Well, I think that that's subject to interpretation. There's no question that a Florida court might deal with it in a way different than we understand it. But the bottom line is that you'd be restored back to a set of principles that were articulated by Florida law and that would allow for you to make certain that Florida voters aren't disenfranchised before December 12th arrives, which I think is a very serious question.
Governor, one of the issues that seemed to be brought up was a suggestion that perhaps this case wasn't quite ready to be before the Supreme Court. That in fact, even if there is a problem, the remedy laid with Congress rather than the United States Supreme Court, that it was Congress under Section 15 of the statute in question that really has to solve this problem. Your response to that?
Well, I know you know as well that typically there are probing questions that are in search of defining the outer boundaries of an argument. I do think, however, that the focus of their argument as it evolved focused exclusively on the things that we think are important here, and those are issues of fairness. I think that they thought it was ripe. I'm expecting that they'll look in that direction when they render a ruling.
Governor Roscoe, thank you very much for joining us on this very balmy and exciting day in Washington. We're going to take a break, and up next, Democratic Representative Edward Markey. When we come back, stay with us.
You guys.
This week on the Art Club, we've come to Budapest, the capital city of Hungary, to check out this year's Autumn Festival.
We try to gather any genre of art, new artistic forms, contemporary artists from Hungary, from abroad, mainly from Europe, but 60–70% of the participants are Hungarian artists.
We also look at an exhibition of 10 contemporary artists from the Carpathian Basin who are showing at the Varna.
There was a shift, and you could tell that the liberals, the four traditional liberals, it's Souter, John Paul Stevens, Ruth Bader Ginsburg, and Steve Breyer, seemed to be gentle with Tribe. And at that point, you could see a cleavage in the court. You could see that this could wind up to be 5-4.
Which is an interesting thing. A lot of people expected that if the court were to come out with any kind of opinion, it would be 9-0. The Chief Justice would like to see some sense of everyone getting along. That didn't really seem likely given what we saw in the courtroom.
Well, it certainly didn't seem likely. The people who were wondering why the Supreme Court ever took this case. It's an unlikely case because it relies so much on state law. And so I think a lot of people felt, well, the Supreme Court has decided that it is going to lend the prestige of the court in order to give more legitimacy to the eventual winner. And so it took a case with some risks in order to issue a broad decision that would settle everything and send the new president off with some legitimacy loaned by the Supreme Court. I don't think that's going to happen now.
Is it conceivable to you that the court could decide, rather than making a firm decision on this, just to buck it back to the Florida legislature?
Yes. Yeah, there was some talk about ripeness. That's a word that lawyers use when they don't want to decide this case today. You know, it's not surprising. You look around here today, and, you know, I've been coming to these things for 35 years. I've never seen quite this much partisan rancor over a Supreme Court case. The country is divided very closely and narrowly. You can see it here. It stands to reason that the court might be very narrowly divided, and it may be that their best intentions were to issue a soothing, unifying opinion. They're not going to be able to agree on that, and they may decide some way to punt.
Now, Fred, you were inside the courtroom. As you said, you haven't seen this kind of partisan rancor, but we also haven't seen a case like this ever in American history, really, where the Supreme Court is asked to step in and possibly decide a presidential election. Give us a sense of the dynamics inside. This was sort of an A-list event in Washington.
Well, it was really a lot of fun in there because they brought us all in early, and you could tell that a lot of people were, you know, anyone in the legal and political world was supposed to be there, but it's a very small, there are only 400 places there. You can imagine all the tantrums that were thrown around Washington by people who feel they're important enough to be there but couldn't get in. And, you know, you see a lot of pressing of the flesh and posturing around. And I pressed the flesh and postured a little bit myself. I went up and talked to some of the senators and august people who were there. So it was an interesting scene, and I think you know, not as glum and ominous as, for instance, in the Pentagon Papers case was argued here, or the Nixon tapes case. I think there was a sense here that maybe this is all going to be decided someplace else.
Now, one of the things we did see were a couple of attorneys from Florida in arguing. Did they seem at all counter-intimidated by standing before the nation's highest court?
No, not at all. In fact, I thought some of the more coherent arguments were made by those two lawyers from Florida. They had much clearer points to make. One represented the Secretary of State, Catherine Harris, and you know, he was going full bore for her, and the other represented the Democratic counterpart of hers, the Attorney General, Mr. Butterworth. And I thought they were easier to understand. You know, it's going to be interesting. The audio tapes are now being played on the networks, and it's just gibberish, you know, because most of the lawyers and the justices, they'll say about 5 words in English, and then they'll lapse into legalese, and it's very hard to follow. And so I have a theory, Tony, and it's this. You know, for years, those of us who cover the Supreme Court from television have been trying to get the justices to let us bring our cameras in, and they've always resisted that. Okay. I think what they have accomplished by letting the people hear only the audio tape, it is such gibberish that people are going to say, please don't let cameras into the Supreme Court because it's so incomprehensible and boring. So the justice may have outsmarted those of us from the media today.
Very quickly, Fred, will you expect an opinion within the next 3-4 days?
Well, the fastest I've ever seen an opinion was 4 days, and that was in the Pentagon Papers case. They would like to do it by then. You may have mentioned, I mean, it's possible that by the end of the day, something could come down saying we're not going to go to the merits and decide this case. If they don't do that, I would guess Wednesday.
All right, Fred Graham of Court TV, thank you for joining us. That's going to wrap up our coverage, at least from here, of today's historic arguments. Again, the case of George W. Bush versus the Palm Beach County Board of Canvassers. The United States Supreme Court has read the briefs, heard the arguments, and now they're trying to figure out what to do with it. We'll carry you all the latest developments on that story and more right here on Fox News Channel. Stay tuned.
The United Nations General Assembly, now sitting at New York, Premier Khrushchev mounts the rostrum to indulge in another outburst of vilification. And delegations from all over the world, many of them headed by their chief executives, hear an irresponsible tirade of abuse that for gutter language has never been surpassed in the history of parliaments. A ranting, raving attack on about everyone who disagrees with communist imperialism, including a threat of atomic war. An exhibition so intemperate, it brings an interruption from Frederick Boland of Ireland, President of the Assembly, who warns the Kremlinite he is out of order.
Take the microphone from me. On a former occasion, I indicated the view of the chair that offensive remarks of a personal character directed to the heads of states or heads of governments were not in order. I'm afraid that a description which was applied to the head of the state by the speaker at the rostrum was unparliamentary and out of order, and being out of order, it should not appear in the official record.
Is Hitler reincarnate in this pudgy propagandist? Loveliest of the lovely, as seen here in the role of a non-competitor, she leads an Atlantic City beauty pageant. Marilyn Monroe is mourned by the world, particularly by a host of veterans of the Korean War. One of her many generous givings of her presence to beguile with her charms and divert with her humor fellow citizens, many of whom had a rendezvous with death. A symbol of all the girls back home, Marilyn's talent did not go unrecognized.
The U.S. Supreme Court is deliberating the future of the presidency at this hour. We'll have the latest. Texas Governor George W. Bush is confident when all is said and done, he will be president. We'll tell you who's on what list for a job in a possible Bush administration. Vice President Al Gore convinced he won the presidency. He's also preparing for his new administration. From Fox News World Headquarters in New York, hello, everybody. I'm Bridget Quinn. It's 2 p.m. Eastern Time. Glad you're here with us today. Today is December 1st, 24 days since we went to the polls. And while the U.S. Supreme Court is weighing this morning's arguments, the Court of Public Opinion is also weighing in. For the results of the latest Fox News Opinion Dynamics poll, we turn now to John Gibson. Hello, John.
Hello, Bridget. You know, these politicians and lawyers are always saying the American people think and the American people want. Well, we actually know what they want because we have conducted a Fox News Opinion Dynamics poll as of today. And let's take a look at some of the highlights of the results. The number one question, should Gore concede? Yes, concede 56%. No, contest the election 39%. As you can see, it splits up a little different among Democrats and Republicans, but overall, yes, concede is the overwhelming opinion. The next one, a very important question, if the election, the vote for president, this is November 3rd versus December 1st. If the election were held all over again tomorrow, who would you vote for? As you can see, if it were December 1st, George Bush would get 49% and Al Gore would get 36%. This compares with the day, a couple days before the election on November 3rd. This very same poll showed a dead even split at 43%. So as of this point, a 6% has gone over to the Bush side from the Gore side. The next question, who actually won the election? We know it's a contested election. Americans think George Bush won, 56% to 25%. Up next, favorable opinion. What do you think of these two guys? As of today, Bush is viewed favorably by 60% of Americans versus 46% of Americans viewing Gore favorably. It was quite a bit closer on November 3rd. Next, Gore's reason for the recounts. We're essentially asking people, why do you think Al Gore is insisting on this recount? That he's fighting for himself, 66%. Fighting for democracy, 19%. A combo of the two, 12%. You add up the second two, that's 31%. 2-to-1, people think Gore is in this for himself and not for other reasons. Feelings about the election decision, sick and tired, 59%. I guess almost anybody would have predicted that. You can ask your friends and neighbors and get that opinion. And then the next one, very important one, proud of your vote for president. The Bush voters, 94%, they were proud of their vote. Only 3% were not. The Gore voters, 84%, 10% were not. So as you can see, what we're learning from this poll, let's look at the next one. What we're learning for the poll is that people are tired of Al Gore. This is probably the most important one. What are the chances there will be a Chad Everett in the future or a Chad anybody in the future? More Chads, very small number. Much fewer Chads, a very high number. The same number of Chads, an inconsequential number. We are not going to name our children Chad after this. So, Bridget, the result of this polling clearly is that whatever is going on in the courts and whatever is going on in the recount, most Americans think that George W. Bush won the election, that George W. Bush will be the president, and they are thinking less of Al Gore in the election aftermath.
And it remains to be seen if there will be a person named Chad in the administration, if it is a Bush administration. I can't believe we asked that Chad question. That's the best.
Well, who should be named the ambassador to Chad? That'll be the next one.
All right, John Gibson, see you in a little bit. Thanks a lot. All right, back to the U.S. Supreme Court now. And Al Gore and George W. Bush took their cases to the highest court in the land today. Let's get you caught up from Washington now. And our correspondent, Brian Wilson, is joining us live. Brian?
Hello, Bridget. Basically, we were hearing arguments over 3 points of law. Article 2 of the U.S. Constitution, 3 U.S.C., U.S. Code Section 5, and the Florida Election Code. There were some very, very detailed and finely pointed questions about those 3 laws and what they say. That was basically what happened for 90 minutes in the U.S. Supreme Court today. At stake here is perhaps a ruling which conceivably could help to resolve this disputed election. Now, for the Bush camp, D.C. constitutional lawyer Ted Olson. Take a listen to some of the arguments from earlier today.
When the Florida Supreme Court expanded the protest period from 7 days to 19 days, it necessarily limited the contest period to a shorter period of time. It changed the discretion. It allowed certain things to occur that couldn't have occurred, and it justifies all of those things on the grounds that the Florida Supreme Court, the Florida Constitution, trumps those legislative concerns.
The Bush camp has basically said from the very beginning their concern is that the Florida Supreme Court overstepped its boundaries here in violation of 3 U.S. Code Section 5, which says that when you count an election, you have to count by the rules that were in effect before the election or the day of the election. So they say they changed the rules, they rewrote Florida Election Code. Now, for the Gore camp, one of the preeminent constitutional scholars in this country, Lawrence Tribe of Harvard University. Take a listen to what he said to the court.
It said it was not consistent with the overall scheme of the statute to require these recounts, which has just begun, to terminate. That truly would be a promise to the ear to be broken to the hope, like a munificent bequest, Justice Jackson said. And if the paupers will, why tell people to count if you won't count it?
So basically what the Gore camp is saying is that, look, the Florida Supreme Court was right to do what it did, to extend the counting deadline in the state of Florida. Basically, there was a conflict in the Florida Election Code. And when there is conflict in the law, it is the Florida Supreme Court which has the right and responsibility to step in and resolve that conflict. Therein lies the basic arguments before the High Court today. There were some very pointed questions by the justices on both sides, as both sides presented their case, and that thing that we don't know, Bridget, is exactly when we'll get a ruling from the High Court on this. If the justices take a snap poll behind closed doors and everybody is against even considering this case any further, we might conceivably get some sign of that very soon. Otherwise, it will usually take at least 4 days, 5 days for the Supreme Court to come to terms and write their opinions. Understand, they are writing history here. It's not something they are likely to rush, even though there are huge time concerns in this election. Bridget?
Brian Wilson live in Washington. Brian, thank you very much. And don't forget, for complete coverage on the internet of Florida's decision and all your news, just check out our website, foxnews.com 24/7. And straight ahead here on Fox News Live, the big delay in the election results has led to a big delay in the new president. Whoever he is, he has to put that transition team together. A lot of work to be done before Inauguration Day. We'll update you. Meantime, the Bush and Gore team still fighting the battle of the ballots. We'll have live updates from both camps next on Fox.
Canadian distance swimming star Marilyn Bell and coach Gus Ryder on the way to challenge the English Channel starting from Cap Grinet, France. The 17-year-old Toronto lass made headlines in September 1954 when she swam the 32 miles of Lake Ontario from Youngstown, New York to Toronto. Here she is battling the English Channel with alternating pacemakers. Marilyn's parents ride along to root their daughter on, and the teenage titan needs it when the channel suddenly gets mighty rough. But the plucky girl fights it out and becomes the youngest girl ever to beat the English Channel. The cliffs of Dover are a welcome sight, and to Marilyn Bell, our heartiest congratulations.
20 million Americans collect stamps as a hobby. And in the wake of the new rates, there will be 2 more for their albums to go with, if they're lucky, a block like this one from the $3 million Kaspari collection. Which reminds us that while Washington races to send rockets to the moon, it still handles mail as it did a century ago, when it cost as much as a pound of coffee to send a letter from Philadelphia to Boston. When the West was wild, stagecoaches charged 2 bits to take a letter to California. By Pony Express, it was $5. Now, Postmaster General Summerfield promises added revenue will enable him to install transformers in all our big post offices. They're 5 times faster and more accurate than clerks. At last, the post office catches up with today, artistically too, as this most dramatic new air mailer proves. But in our history, there are hallowed memories, and with this new Lincoln, we salute one of these.
Many people braved the cold this morning and gathered outside the U.S. Supreme Court to be part of the historic hearing. Rita Cosby now was in the crowd, and she joins us on this historic day. Rita?
Hi, Bridget. Well, as you can see right now, it's a little calmer outside the U.S. Supreme Court, but earlier today, just a swarm of protesters were out here. We still have a few of them outside. Inside in the chamber, there literally were 400 seats, 400 very coveted seats. And for members of the public who wanted to get inside, many of them lined up as early as yesterday morning just to get a chance to go in for a few minutes and view history. Now, in addition to this, of course, all the lawyers were inside fighting their cases. I spoke with Bush lawyer Ted Olson immediately after the hearing, and he told me that he felt it went well. He felt that the justices understood their position, that this case should have an intervention by the Supreme Court, and that the Supreme Court decision would certainly have a big impact, in his opinion, on the situation in Florida. I also spoke with Secretary of State, former Secretary of State Warren Christopher, who's working with the Gore team. Here's what he had to say about some of the possible outcomes. Where do we go from here? Say the court rules favorably for Vice President Al Gore. What happens next?
Well,
what impact could it have?
We continue with our contest in Florida. I think it'll be a big psychological lift if they come out for Vice President Gore. On the other hand, it's not over if they come out the other way.
They ask very hard questions, and they always do, but particularly today. And that's the invigorating, exciting thing about it. That's what we expect when we go into the United States Supreme Court. You better be prepared to answer hard questions, because they have a very difficult job to do, and they're making a decision that's exceedingly important to the country. And our citizens would want them to ask hard questions, and we better be prepared to respond to them.
And that was Bush attorney Ted Olson answering a number of questions, talking to us, of course, about his situation in the court. He said there were a lot of tough questions, but he felt that he had good answers for them. Now, in addition to all that, you're looking right now at sort of an overview, an aerial scene of what happened outside the U.S. Supreme Court. Just a slew of protesters. At one point, it looked like we had at least more than 1,000 protesters outside. Some of them with issues not even involved in this case. Some of them were death penalty opponents. Some of them were were right-to-lifers, anti-abortion advocates. But then in addition to that, obviously, we had a lot of them who were Bush supporters, a lot of them who were Gore supporters, and at one point the two sides were just trying to drown each other out, seemed to be having a shouting match. We had the Gore voters saying every vote must count, and then we had the Bush supporters saying Bush won, Gore go home. So some very strong opinions on both sides. Talking to a lot of court observers who were inside, everyone seemed to say it was a privilege to be a part of this, to watch history in the making, and all of them seemed to say that both attorneys, really on both sides, were getting equally grilled, that the justices seemed very interested in this case and seemed to ask a lot of very pointed questions to both sides. Back to you, Bridget.
Rita Cosby, thank you for the update. So more than 3 weeks now of election limbo, and it has been taking its toll on the transition teams of both sides. A third of the preparation time is now, poof, gone. Whoever becomes president will have a lot of catching up to do. Rick Folbaum now with more on that story.
Even under normal circumstances, transitions are frenzied. 73 days to get a brand new administration up and running. This election, though, is anything but normal. And with each new lawsuit and legal brief, time's a-wasting. We're now only about 50 shopping days till inauguration.
I think that Governor Bush and I, in the interest of the nation, should both proceed with transition planning and activities.
Governor Bush is putting together the infrastructure even without the $5 million in transition funds the government gives to the election winner.
We now have an office with a lot of space. We've got people signing up, volunteers coming on, telephones being put in, and computers.
Historian Alan Lichtman says transitions are important, both symbolically and substantively.
They are a time when the new president develops his agenda, forms relationships with Congress, plans his new administration.
Attorney General Janet Reno says required background checks for prospective appointees and employees can start now, even without a clear winner, but it's still going to take time.
But you can only shorten up that process so much. It's going to be a big bottleneck for the new president.
No matter who wins, there are bound to be jobs left unfilled, agendas left underdeveloped. But scholars say that's okay. All of that will eventually fall into place. What might be more difficult is the symbolic transition of the new leader from partisan candidate to president-elect. All those good feelings Americans generally have between election and inauguration day could be lost. The new president could have a tough time winning hearts, even though he will have just won in the courts.
He's got to be inspirational, and he's got to be a powerful leader. Otherwise, that president will be consigned to the dustbin of historical mediocrity.
A transition both men would like to avoid. In New York, Rick Folbaum, Fox News.
And more on the transition straight ahead. Two sides getting ready, but of course only one gets to go to the White House. Up next, we'll have the latest from both Camp Bush and Camp Gore.
Time to do some Foxcasting for this evening. Friday night, America's date night. Oh, it's going to be chilly in the northern plains. Look at that, 15 in the Twin Cities, 18 in Chicago. We'll have 20 in Denver as a lot of cold Arctic air goes right down through the middle part of the country. Meanwhile, 20s return to the northeast. We'll have some 30s all the way from Dixie back through Dallas and the desert as well. Out west, temperatures tonight drop into the 40s and the 50s. All right, that's your Foxcast for tonight. I'm Steve Ducey, the weather guy.
In our voice describing this Hollywood ceremony incidental to these Academy Awards, we humbly hope you'll understand. Your newsreel's parent company, 20th Century Fox, being responsible for Panic in the Streets, which gets Edna and Edward Anhalt the Best Film Story Oscar from Ruth Chatterton. With Leo McCarey officiating, 20th Century Fox continues triumphing as Joe Mankiewicz's direction of All About Eve is declared tops, after which Mercedes McCambridge honors George Saunders as Best Supporting Actor for his role in All About Eve. A thrilling climax for All About Eve is reached when the distinguished UN statesman Dr. Ralph Bunche announces,
I am happy to announce that the winner is All About Eve.
Bringing Mr. Zanuck, who produced the multi-prize winning picture once again to the stage to accept still another well-merited award. Can you blame us for our elation? For the Messrs. Mankiewicz, Zanuck, and Saunders have garnered 9 of Filmdom's most prized awards for 20th Century Fox Film Corporation, and one of them belongs to your Movietone News. Wearing a century-old lace veil over a file taffeta and lace dress, Grace Kelly is escorted by her father to the altar of Monaco's St. Nicholas Cathedral. The moment for the ultimate church wedding that will complete a romance between the 26-year-old American and the 32-year-old ruler of the little principality. And Prince Rainier III has a smile for the vision he will make his princess. Bride's parents are intense spectators as the ceremony begins, performed by the Most Reverend Gilles Barth, Bishop of Monaco, and consecrated according to the rites of the Roman Catholic Church with double marriage rings. At the low mass that follows, the happy pair make a solemn but handsome appearance. Partaking in a papal blessing with reverence and humility. At long last, all the arduous ceremonies are over, having gone through with their civil wedding a day earlier. Only a ride through the cheering Monegasques remains. Then they're off on Prince Rainier III's yacht for Pollença in the Balearic Islands.
The court battles continue, but the Bush campaign is still pushing ahead with its White House transition plans. Carol McKinley joining us live now with the very latest from Austin, Texas. Hi, Carol.
Good afternoon, Bridget. You know, there's been no reaction from the Bush camp to these U.S. Supreme Court hearings, but you can bet they're keeping their ear to the ground on them. You know, they probably won't say much until there's some kind of decision from the court, and really no one knows when that will happen. Perhaps this weekend, maybe as early as next week. Meanwhile, back at the ranch, there were some VIPs in Crawford, Texas. Much publicized visit with the man who could be the next Secretary of State, Colin Powell. That happened on Thursday, and more VIPs are on the guest list, we find out. House Speaker Dennis Hastert and Trent Lott, Senate Majority Leader, will get a taste of Texas. They're meeting with Bush and Dick Cheney on the ranch tomorrow. They'll probably be talking about the upcoming legislative session in January, and they'll discuss transition. You know, Bush does consider himself the president-elect, and we're hearing he's getting more and more impatient with Al Gore and his refusal to concede. But he's walking a precarious line here because he is still the governor of Texas and has his gubernatorial duties. In fact, for instance, he's coming down to Austin, driving that 2 hours south from Crawford this afternoon because he has a Christmas party to host. That will be at the governor's mansion. Bridget?
Carol, George W. Bush has been taking some hits lately for having Dick Cheney do quite a bit of the work involving the transition. Has he had any sort of response to that?
Well, it's interesting you asked that, Bridget, because when he talked to the press yesterday, it's really the first time he'd spoken with reporters himself in a while. And when he was asked about that, he just laughed. Most of his aides tell us that he's been involved in all of the decision-making. He's been doing it from behind closed doors because he doesn't want to seem too arrogant. He doesn't want to look like he's the president before it's time.
Carol, any more appointments imminent, or are they just going to lay low for a little while after that meeting with Colin Powell yesterday?
I think they're going to lay low, and I think it's very telling that Hastern and Trent Lott are coming in tomorrow. This is the first time they've talked to the governor since the election, and now they're coming in as if he is the president to talk to him about the legislative sessions. So at this point, I mean, I think that's what's on the agenda for tomorrow, that and the fact that Bush really wants to get this presidential bid in there. He wants to get into the White House as soon as he can.
Carol McKinley joining us live from Austin, Texas. Carol, thank you very much. And as for the other side, the Democrats are tossing around their own name should Al Gore win the White House. Our David Schuster keeping tabs on Camp Gore, joining us live from Washington with an update. David?
Well, Bridget, as far as the transition is concerned, the Gore campaign is suggesting that they would include Republicans in a Gore cabinet. But the focus, of course, for the Gore campaign is the Supreme Court. Several key Gore advisors were there, including Warren Christopher. And just minutes after the Supreme Court arguments, in which there certainly appeared to be at least 5 Supreme Court justices who thought that the Florida Supreme Court overreached, Christopher came to the reporters and tried to put the best face on the arguments. He suggested we shouldn't read too much into the tone of the arguments.
It's always very hard to judge from the questions because people ask questions in order to get the responses from the counsel. I'm an optimist, and so I'm an optimist about the outcome. But it was a splendid professional argument.
Warren Christopher made a point of saying that if Al Gore loses at the Supreme Court, that does not mean an end to Gore's contest of the election in Florida. And that seems to suggest that, of course, regardless of what the Supreme Court might do, that the vice president might have his own mind, that he might continue fighting. That, of course, is a problem for congressional Democrats who have openly suggested that Gore needs a victory in the Florida Supreme Court if he's going to maintain support from Democrats in Capitol Hill to keep going with this litigation in Florida. The Gore campaign was well represented at the Supreme Court today. In addition to Warren Christopher, Bill Daley, the campaign chairman, was there. The vice president's son, Al Gore III, and the vice president's daughter, Corinna, both sat in the first couple of rows of the Great Hall of the Supreme Court. Furthermore, there were a string of Democratic lawyers who helped prepare the briefs that attended the Supreme Court hearings. The vice president apparently watched the audio replay from the Naval Observatory in Northwest Washington, the site of the vice president's official residence. There are no events in his schedule, but he was expected to get a briefing from his lawyers, but also watch some of the arguments on audio replay for himself. The Democrats in Capitol Hill clearly believe that the Supreme Court was obviously divided on the question of whether the Florida Supreme Court overreached, but some Democratic lawyers are holding out hope that even if a majority of the justices believe that the Florida Supreme Court overreached, that there may not be a majority of the justices who believe that there's a federal issue that needs to be decided. There are also some Democrats who are suggesting that perhaps the court will decide that the issue is not ripe for a ruling. But in any case, there is some concern among Democrats who clearly believe that at least half the justices, 5, maybe 6 justices, were openly hostile to some of the actions of that Florida Supreme Court. Bridget?
And David, I guess the timing of any Supreme Court decision is key here to, well, really to either camp.
Well, Bridget, that's right. And for the Gore campaign, perhaps more so, because the Gore campaign believes that suppose the Supreme Court doesn't rule for a week, that they may be able to get some momentum, perhaps, in the Florida Circuit Court or the Florida Supreme Court as far as getting these recounts started. And that might bolster Al Gore's claim if at some point he decides, well, forget what the Supreme Court says. I've got a contest that's taking shape in Florida. I'm going to keep going. If he can get the events in Florida ahead of the United States Supreme Court, perhaps he can build some momentum. If, on the other hand, the Supreme Court were to come back, say, this weekend or Monday morning, which is unlikely, but if they come back with a loss for the vice president right off the bat, Democrats on Capitol Hill are going to say, well, forget about your chances in Florida. You've lost at the Supreme Court. That's the end. So clearly the Gore campaign is hoping to buy some time that maybe the Supreme Court won't rule for a couple days. And then in the meantime, maybe they can get some momentum somehow in Florida.
And David, it sounds like Gore himself personally is just really hanging tough. I was reading in one paper this morning that friends say he has no exit strategy because he just hasn't thought of exiting.
Well, Brett, it depends, I guess, on what papers you believe. There's some suggestions that clearly he's not going to give up any other circumstances. There are others that suggest, well, maybe he was a little wishy-washy over the weekend and that it was his family who said, look, don't give up any other circumstances. But in any case, at this point, by all the signals that you get from Warren Christopher, from Bill Daley, from their posture at these news conferences, they believe that right now all eyes should be focused on Florida, that if they can somehow get some momentum down there, get the recounts going, that perhaps it's not going to matter what the Supreme Court does. Congressional Democrats, of course, though, disagree, and the Congressional Democrats are the ones who will ultimately probably force Al Gore to either concede if that's going to happen or to keep fighting if it seems that Al Gore can just do that.
David Schuster, thanks for the update live in Washington. And still ahead here on Fox News Live on a busy Friday. The ballots keep on trucking. Today, rental vans are taking loads of ballots from Miami-Dade to the state capitol, where they will join their Palm Beach counterparts. A little reunion, possibly be recounted again. We'll have a live update.
Couple, because millions are golden, also because silence is golden. They're seen but not heard. Count and Countess von Haugwitz-Reventlow. Married at Reno, they're on their honeymoon, speechless. But let's try to get them to say a few words, 5 words or maybe 10. Count, what do you think of married life? Not a word, but maybe the Countess will let slip a secret or two. How's the weather, Countess? Nothing for publication. The words she would not speak were countless, but she is not countless. Away she goes to greet some of her friends, and so ends the interview that was only a view.
This presentation of the awards of the Academy of Motion Picture Arts and Sciences is always a distinguished occasion in Hollywood. Producer Darryl Zanuck and Mrs. Zanuck and Wendell Wilkie discuss movie affairs. Linda Darnell and Cesar Romero are among the film stars in attendance, as are Betty Grable and George Raft. Donald Crisp and Mary Astor are acclaimed for the year's best performances as supporting players. For the best acting by stars, Joan Fontaine and Gary Cooper get what Hollywood calls the Oscars. Top honors for producer go to Darryl Zanuck, award presented by Walter Wanger.
Colonel Zanuck, it's indeed a pleasure to be able to present you with this award for the most distinguished picture of the year, How Green Is My Valley, a picture which has brought great credit to the industry and to Commander Ford, who made it, and you, who produced it.
Thank you very much, Mr. Wanger. It's a great pleasure to accept this award for the entire 20th Century Fox studio.
Bottom of the hour now. With all the twists and turns of the election deadlock every day, it's kind of tough to make sense of it all. But John Gibson is here to help us clear things up, sort them out. Hello, John.
Thanks a lot, Bridget. Hi, everybody. As we have been reporting, the U.S. Supreme Court is right now considering a historic decision. The justices questioned both sides today during George W. Bush's suit to overturn Florida's recounts ordered by the Florida Supreme Court. But there are legal proceedings still going on in the Sunshine State, too. And another ballot caravan is heading to Tallahassee. As for the candidates, they've been watching, waiting, and planning for possible administrations. All sides have had their say now before the U.S. Supreme Court and fielded some tough questions from the 9 justices. Some justices asked why the highest court in the land should interfere in contested election results in Florida. Governor Bush's lawyers are trying to convince the U.S. Supreme Court to overturn a ruling by Florida's top court. They argue the ruling that extended a deadline for vote recounting rewrote Florida election law. That brought a sharp response from Justice Ruth Bader Ginsburg. She said she did not know any case that impugned a state Supreme Court the way the Bush argument did. Gore's lawyer compared the vote recounts to a photo finish in a race. Harvard Law professor Lawrence Tribe said the issue is whether a state can magnify the photo to see who really won. Tribe said he expects the High Court to rule on the issue by early next week. Back in Florida itself, the ballot battlefields are now expanding. A new lawsuit's been filed in a Florida state court contesting the election. Filed on behalf of unidentified voters, it asks that all absentee ballots in Martin County be thrown out. If the judge approves and the state accepts the new total, Governor Bush's lead in Florida could disappear. The lawsuit accuses the GOP of tampering with hundreds of absentee ballot request forms. It's similar to a suit in Seminole County. In that case, a Democratic activist charges illegal handling of absentee ballot request forms. Meantime, Bush lawyers asked Circuit Court Judge N. Sanders Sauls to send for another 1.25 million ballots from 3 counties. The judge has yet to consider the request. Al Gore's lawyers asked the Florida Supreme Court to order hand recounts start immediately. Bush's legal team counters with a motion to throw out Gore's contest of the election. They argue that the real election dispute is between separate groups of state electors, not Bush and Gore. And there are reports the Bush team plans to call 95 witnesses. That's a lot. If the case goes to trial, the judge has scheduled hearings this afternoon and tomorrow morning on Gore's challenge to the certification of Florida election results. Meantime, about 600,000 ballots from Miami-Dade County are being trucked to Judge Saul's court in Tallahassee. More than 500,000 from Palm Beach County arrived yesterday. There's the truck doing the trucking. Whichever way it goes, the Supreme Court ruling may not end Al Gore's Florida election challenge. In an interview with the Associated Press, running mate Joe Lieberman said the Gore camp believes the final decision will come from the Florida Supreme Court, but the Connecticut senator acknowledged the U.S. Supreme Court could have the last word somehow. Meantime, the Gores and the Liebermans have been working on transition plans. Sources say the group wants to create a grassroots panel of community leaders to advise Gore on building his administration. Claiming victory, George W. Bush says, quote, one of these days, close quote, he will prevail. In the meantime, the governor continues planning for a new Bush administration. The governor and his wife Laura returned to Austin today for a Christmas party. They'll be back at their ranch in Crawford tomorrow. That's where Bush plans to meet with House Speaker Dennis Hastert and Senate Majority Leader Trent Lott. The governor has spent most of the last week on the ranch. Yesterday, he held meetings with retired General Colin Powell and running mate Dick Cheney. Powell, of course, is expected to be offered the position of Secretary of State. We'll have updates throughout the day. Now, for more coverage on Florida's decision, Bridget Quinn and Shepard Smith.
Welcome, Shep.
Thank you.
Had to pay extremely close attention to every word of the hearings to try to understand it legally. It was tough.
It was I don't have that mental capacity.
I don't
it's
either.
It's the truth.
All right. Yeah. Maybe this is a little bit of a simpler issue. Another court battle in Florida set to take place tomorrow.
Yeah, boxes of ballots pouring into Tallahassee where they could be counted again. Fox News correspondent Rick Leventhal has moved to Tallahassee, and he joins us there live with the latest. Hello, Rick.
Hey, Shepard, Bridget. Yeah, the armed convoy on its way here should be arriving, we believe, in an hour or so here in Tallahassee, along with the police escort and the media observers and the partisan political observers as well. A lot of other things happening here that we also want to talk to you about, including the state legislature here, where it looks more and more likely that, in fact, the state legislature will call a special session to consider appointing the electors to the Electoral College themselves, concerned about the delays in the legal arena. Vice President candidate Joe Lieberman says that if that happens, he believes it could trigger a constitutional crisis, but the legislators say they don't think so. Their concern is that Florida might not be represented at all since the court battles are dragging on and the electors are supposed to be named on December 12th, which is only a week from next Tuesday. Yesterday, a committee of the Florida legislature recommended a special session be held as early as next week.
Obviously, the Florida Supreme Court changed the rules of the election after the election had taken place. Again, putting the 6 million votes cast by the people of this state at risk. Another reason why we have a problem is because the lawyers have taken over this process.
The state Supreme Court also considering several appeals related to this election deadlock, one of them from Vice President Al Gore himself, asking for the immediate recounting of some 14,000 disputed ballots considered undervotes because the machines didn't read them one way or the other. The Gore camp believes those undervotes could swing this election his way, but the Republicans say, look, if you're going to count those 14,000, you need to count them all, all the ballots from Miami-Dade and Palm Beach County, and now 3 other counties as well, where they believe Gore may have gotten some illegal votes himself. So they're talking about perhaps counting more than 2 million votes. That decision, we believe, will be made by Judge Sanders Saul possibly as early as Saturday. Tomorrow morning, 9 a.m., they begin their hearing there on a variety of issues, but most importantly, whether or not to recount any or all of those ballots. And one other thing I just wanted to mention, reported in the Miami Herald today, it's possible that at least 445 of the votes that are on their way here cast in Miami-Dade County were actually cast illegally by felons. The paper there reporting that perhaps as many as 5,000 felons across the state voted on November 7th, which is against the law, and the paper says that 75% of them are registered Democrats. Bridget, Shepard, back to you.
All righty, Rick Leventhal, we thank you. All right, well, more on the legal issues now as the U.S. Supreme Court steps into the ballot battle. And joining us with more on the historic hearing this morning is Maxine Waters, Democratic Congresswoman from California. Congresswoman, thank you for being here.
Well, you're certainly welcome.
You attended the hearings. Did you get any sense that there's a possibility that the court might not take this case, might not make a decision?
I don't know. I've heard that opinion given by people who were here today, saying they may not take the case up for a decision. They certainly seem divided to me. Based on the questions they asked and the conclusions they seem to come to individually, it seems to me that if they do make a decision, it would be a divided decision. It would be a 5-4 decision, I would think.
You think it would be divided along ideological lines? Most experts say that they think if the court rules here, it's going to be unanimous.
I don't think so. I mean, of course, I'm only second guessing, but based on my observations there this morning, it sounded as if we had justices coming from different places.
What struck you greatest, Congresswoman? Did you have a sense as well that there were at least 2 or 3 of the justices who seemed to be questioning whether, in fact, the Florida Supreme Court did some legislating from the bench?
Sure. We had, I think, justices who came down on both sides of that issue. There were some who seemed to think that you should follow the law, the literal letter of the law, and that the legislation itself that determined how the elections are to be held and how they're to be run gave a time specific by which those votes must be turned in to be certified. And there were others who did not see it quite that way. They thought that there was a certain kind of situation in the law that allowed for interpretation, and that certainly the Secretary of State has discretion with certain kinds of conditions. For example, if you have a hurricane, if there's an act of nature, and that gives you the flexibility to have discretion when you have a problem or a crisis. There are others who said when you have a certain kind of crises that cannot be settled by the Secretary of State, that should only fall in the lap of the House of Representatives. That's what the Constitution has to say. So I think there is a difference of opinion.
Congresswoman, when all is said and done, and if Al Gore were to be handed a defeat at the hands of the U.S. Supreme Court, would you recommend to him to throw in the towel at that point?
No, absolutely not.
Where would he go then? Well, what's left?
I think there's still issues to be resolved. I'm very interested to know what is happening with the absentee ballots, where the Republicans were allowed to come into the elections office and literally put the identification numbers on the ballots after they were sent out. And that's, according to state law, very illegal. There are uncounted ballots. There are too many allegations of irregularities. It should be played all the way out.
What would it take then for you to make the suggestion to Al Gore to throw in the towel? At what point?
I have no suggestion to Al Gore to throw in the towel. My advice to Al Gore is you keep fighting until you are absolutely satisfied that questions have been answered, that the people's votes have been counted, and that Mr. Bush has won this election fair and square.
Congresswoman Maxine Waters, Democrat from California. Congresswoman, thank you very much.
You're welcome.
Thank you. And straight ahead, an historic moment. The U.S. Supreme Court hears arguments from both Bush and Gore lawyers.
So, did their arguments sink or swim, or something in the middle? We'll hear what Fox News Channel's legal analyst, Peter Johnson, thinks in just a moment.
It's the National Open Golf Tournament at Marion in Ardmore, Pennsylvania. The huge gallery watches Lloyd Mangrum tee off. Kerry Middlecoff. Sammy Snead. Eye-filling golf as Ben Hogan drives. Kerry Middlecoff tries everything on this short putt to no avail. Hogan applies his skill to a long try. And brother, that's tantalizing. But the terrific Texan plays steady golf and sinks him when he has to tie for the lead and qualify for the playoff round. Mangrum tees off in the playoff. George Fazio. Ben Hogan. Bantam Ben on the comeback trail from a brush with death plays a cool and calculating game. On the verge of his second Open title. Par 69 to win the fourth three-way tie in the tournament's 50-year history. $4,000 goes with this trophy, enough for Ben and his wife to celebrate in championship style. Nice going, Ben. '" In the Santa Monica Civic Auditorium, the highlights of the presentation of Academy Awards. For their roles in the Best Picture West Side Story, George Chakiris gets an award from Shirley Jones as Best Supporting Actor. And as Best Supporting Actress, we have Rita Moreno receiving one from Rock Hudson. Exciting Rita, no end. While acting for Sophia Loren, Greer Garson accepts the Best Actress Award from Burt Lancaster. And there's joy in Italy, as the star whose performance in Two Women was a winner. And with director De Sica shares her triumph with Mother and Husband.
Fifteen minutes before the hour now on Fox News Live, there's another truck headed north in the Sunshine State, all loaded up with chatted ballots. And the question now is, will they ever be counted again? That partially rests with the Supreme Court. So with the Supreme Court hearing and the how can now and how did the two sides fare in getting their points across, our legal analyst Peter Johnson joins us now here in Studio B. Hi, Peter.
How are you, Shep?
Good talking about this in the green room back there. It felt like there was a split. It felt like a few of them were suggesting maybe they did legislate from the bench.
Well, you can never anticipate what the ruling is, but I agree with you that there are some questions there about legislation from the bench, and that was evinced in at least a few of the Supreme Court justices' questions. I think what we have to do is await their decision, whether it's in 3 days or 4 days or even sooner than that. What's important, though, is I think the American people have to understand that we're not in a constitutional crisis.
Maxine Waters used the word crisis a minute ago. Joe Lieberman has used that phrase.
Well, I think that phrase is disturbing, and it's misleading, and it's not useful. We have an issue before the United States Supreme Court as to whether the Florida Supreme Court acted within its bounds in making legislation, as some say, or interpreting a statute. Even if the United States Supreme Court decides that the Florida Supreme Court was within its bounds in interpreting the statute, the result of the election as certified doesn't change. I know a lot of people have indicated, well, it's a public relations issue, but this is not a public relations issue. This is not a matter of rhetoric and intemperance where we say, well, if this happens, this will be a constitutional crisis. It's not a constitutional crisis if the Florida Supreme Court and or the United States Supreme Court does not decide this issue in a final conclusory way by December 11th at midnight. Then the Florida legislature, in some form, has an obligation under the law, under the Constitution, to step in and name electors. That's not a matter of constitutional crisis. That's the orderly progression of the law. And it's the orderly progression of the law based on the Gore challenges. If there were not the Gore challenges, then we wouldn't be down involving every branch of government. We have the federal judiciary involved. We have the state judiciary involved. We may have the Florida state legislature involved. And in the end, it may be the province of the United States Congress. So there's a possibility, though this was a historic moment, this may not be the only time that we see this case in the United States Supreme Court. It may, in fact, if there is an adverse ruling, mean a bad ruling for Governor Bush, there may again be some constitutional basis to bring it back to the United States Supreme Court again, because in fact we're dealing with a federal election, a presidential election, the most important election in our lexicon of elections. This is the underpinning of our society, this election. So to say that it's not going to go back to the United States Supreme Court again may be jumping the gun. We still need to hear from the Florida Supreme Court. We will. But if that decision is fraught with judicial activism, if it violates a federal statute, if it violates the United States Constitution in some way, then look for either the Bush lawyers or the Gore lawyers to again go to the United States Supreme Court. So it's not over till it's over. Yeah. And it's a long time from being over.
Is there really a possibility, Peter, as so many people have bantered about, that there might be two sets of electors? That we could come to a point where the legislature says you're the electors and the vote says you're the electors as the ballots are arriving once again in Tallahassee. Not a Ryder truck today, not an eight-hour-long Ryder commercial today. Moments from now, we'll know who the commercial is for today. But at any rate, they could both be, we'll be watching this, but they could both end up there. And then the House of Representatives would choose?
Hypothetically.
But we feel closer to there than we were a couple weeks ago.
Because we've moved another step down the track in terms of these challenges and contests. And the more that we move into the process, the more that different levels of our state and federal governments have to get involved. But let's let the process play out. Let's have confidence in our U.S. Supreme Court.
Yeah, Peter.
That's why they're there.
Thank you, Peter Johnson. Appreciate it. Well, the ballots are there. The ballots have come. The ballots have come. And we'll take you live to Tallahassee, and we'll talk about the ballots and the rest on this historic day. Stay with us.
A century-old lace veil over a file taffeta and lace dress, Grace Kelly is escorted by her father to the altar of Monaco's St. Nicholas Cathedral. The moment for the ultimate church wedding that will complete a romance between the 26-year-old American and the 32-year-old ruler of the little principality. And Prince Rainier III has a smile for the vision he will make his princess. Bride's parents are intense spectators as the ceremony begins, performed by the Most Reverend Gilles Barth, Bishop of Monaco, and consecrated according to the rites of the Roman Catholic Church with double marriage rings. At the low mass that follows, the happy pair make a solemn but handsome appearance. Partaking in a papal blessing with reverence and humility. At long last, all the arduous ceremonies are over, having gone through with their civil wedding a day earlier. Only a ride through the cheering Monegasques remains. Then they're off on Prince Rainier III's yacht for Pollença in the Balearic Islands.
was 19. She marries Vaughn Paul. He was assistant director in the making of her first motion picture when she was a child singer. Now he's an associate producer. Deanna Durbin's wedding is quiet and traditional. The traditional wedding cake and the bride cutting a slice. How is it? Nothing like finding out. You try it first. Weddings are wonderful. The cake is so good. The wedding of a Vanderbilt heiress is a social occasion, and she's Gloria Vanderbilt. The old Santa Barbara mission in California and a bridal veil on a windy day would seem to make it a breezy romance. The groom is Pat DiCicco, an actor's agent. The best man is movie star Bruce Cabot, bridesmaid Shirley Cohen. He's 32, she 17.
You are looking live, Tallahassee, Florida. The truck has arrived, the ballots are there. What, Bridget, 650,000 or something like that?
I think even more.
Even more, all right. Well, lots of ballots, chatted ballots from Miami-Dade County have now arrived, and I still haven't been able to figure out who the commercial's for today, but we'll get to that.
That's right. Ryder got enough attention yesterday.
Yeah.
The focus of the nation today on the U.S. Supreme Court, the highest court in the land, weighing in on the fight for the White House.
And joining us from our Washington newsroom now is Britt Hume, managing editor of All Things Washington. Hello, Britt.
Hi there, Shep. Hello, Linda.
I was talking to Peter Johnson just a minute ago about this possibility of dueling electors. Is that possible?
It is. I'm sorry I said Linda. I meant Bridget. Hello, Bridget.
Quite all right. Hello, Britt.
Yeah, it is possible, Shep, and it's an intriguing scenario. For one thing, you got the Florida legislature down there making noises as if it might hold a special session for the purpose of appointing electors in case none is chosen. Well, they're not going to need to do that in all likelihood because the electors, a slate of Bush electors has already, in fact, been chosen, certified, and the so-called certificate of ascertainment signed by the Secretary of State and the governor has been sent to Washington and resides here for presentation to Congress. Now, if the Florida Supreme Court or some other judicial body in Florida were later to declare as a result of this contest procedure that no, Albert Gore was the winner of this election, there would then be a rival certificate of ascertainment developed somehow, signed by somebody, and it too would be sent to Washington, at which point it would be up to the U.S. Congress which of the slates of electors it would authorize. Now, that presumably would happen by December the 12th. That's the reason why the Gore people are rushing against that deadline, because they're trying to get a competing slate of electors named. Now, if the contest was so clear that Mr. Bush were to decide that he really did lose and he would bow out of the race, concede, or whatever, then it wouldn't matter. But if he and the Republicans backing him were to decide that they felt that the election had in effect been stolen from them by the Florida judiciary in some way, then I think that possibility of the matter being resolved by the Congress would in fact be a live possibility, and we could have us a very intriguing game played out between December 12th and December 18th when the electoral votes are in fact cast.
Britt, about the U.S. Supreme Court and their hearing today, is it still likely that they would come out with a unanimous ruling to sort of insulate themselves from any charges of partisanship?
I think they'd like to. Courts like to be unanimous in big cases because it has greater effect, it has greater authority, it does insulate them from criticism, it has a greater sense of finality attached to it. Listening to the justices and their questions today, it did not sound like a united court. It sounded like a court that is divided quite closely on whether A, there is a real federal issue here, and B, whether in fact the Florida Supreme Court did indeed overstep its bounds as a court and get involved in rewriting law impermissibly under federal statute. There did not seem to be agreement among the justices on that. There did seem to be perhaps enough justices, maybe 5, maybe 6, some think as many as 7. It was hard to know who might be willing to do that, but it's hard for me to imagine it being unanimous. But look, you're flying blind when you're listening to these arguments because the argument is the only public glimpse you have into a process that started before the argument and will end after the argument, and that is the interchange among the justices. And their conversation and their reading and interpretation of the briefs and the law is already well advanced when these hearings occur. So what you get is you look in on a phase of it, and they're asking questions not for the point necessarily of illuminating themselves, but for illuminating a point that they want a fellow justice to hear sometimes. The reasons for asking questions are often more complex and more subtle than you realize, and it can be you can easily be misled by listening to them and picking up your sense of where they're going. But the sense I have about it is that the only thing that they could probably agree on unanimously now is to hold the matter in abeyance for a time and say, well, there is a federal question here, and we're skeptical about what the Florida Supreme Court did, but at the moment it doesn't seem to have affected anything, but this courthouse door remains open should the outcome make it necessary for one party or the other to come back here. It seems they might be unanimous on something like that.
Bert Hume, we thank you. See you tonight, 6 o'clock Eastern Time. Shep, what's coming up?
Well, we have a busy hour ahead trying to figure out what in the world's going on in Florida. We'll check back in at the truck where they're unloading the ballots, presumably, or will be shortly at least. We'll check in with some legal experts about how all of this may go forward. And we'll do a lot of other stuff that I'm not entirely sure of yet. We'll know in a little while, and John Gibson will be here with all the latest in Florida, so stay with us.
Hollywood's great night when the experts confirm the public's choice. As, for example, 3 coins in the fountain, which is awarded 2 Oscars by the Academicians to prove the public discerning, having flocked to this 20th Century Fox film by the millions, as they did to Broken Lance, another 20th Century Fox Oscar winner. Best Actress award goes to Grace Kelly, acclaimed by Vox Pop for her role in The Country Girl, a popular honor comparable to that achieved by Marlon Brando, whose role as Napoleon in 20th Century Fox's Desiree is unforgettable. But the Oscar he now gets from Bette Davis is for his waterfront portrayal.
The days when baseball fans can feast their eyes on the dazzling doings of Joe DiMaggio, one of the game's all-time greats, who always went all out in playing his way to the pinnacle of his profession. Flanked by Yankee owners Topping and Webb and manager Stengel, the Yankee Clipper makes an historic announcement.
I said last spring, I thought this would be my last year. I wish I could have had a better year. But even if I had hit 350, this would have been my last year for me anyhow. You all know I've had my share of injuries and setbacks during my career. In recent years, these have been too frequent to laugh off. When baseball is no longer fun, it's no longer a game. And so, I've played my last game of ball.
Sorry to see you go, Joe, but happy to welcome you to our Yankee microphone.
One historic day in the United States, the legal fallout from the presidential election landing before the highest court in the land. Lawyers for both George W. Bush and Al Gore presenting oral arguments to the Supreme Court. 3 o'clock in the East, now noon in the West. I'm Shepard Smith in New York, and this is a special edition of Fox News All Politics. We'll have live reports and in-depth analysis coming your way, but first, top of the hour, time for the top of the news, and for that, Gibson has your update. Hello, John.
Hello, Shep. How are you?
Good.
Hi, everybody. As we've been reporting, the U.S. Supreme Court has heard arguments, and now the justices are trying to decide George W. Bush's suit to overturn Florida's recounts ordered by that state's Supreme Court. But there are legal proceedings going on in the Sunshine State as well, and another ballot caravan is about to arrive in Tallahassee. As for the candidates, they've been watching, waiting, and planning for one of them to go to the White House. All sides have had their say before the U.S. Supreme Court and fielded some tough questions from the 9 justices. Some justices asked why the highest court in the land should interfere in contested election results in Florida. Governor Bush's lawyers are trying to convince the U.S. Supreme Court to overturn a ruling by Florida's top court. They argue that the ruling, which extended the deadline for vote counting, rewrote Florida election law, and that's wrong. That brought a sharp response from Justice Ruth Bader Ginsburg. She said she did not know any case that impugned a state Supreme Court the way the Bush argument did. Gore's lawyer compared the vote recounts to a photo finish in a race. Harvard Law professor Lawrence Tribe said the issue is whether a state can magnify the photo to see who really won. Tribe said he expects the High Court to rule on this issue by early next week. Back in Florida itself, the ballot battlefields are now expanding. A new lawsuit has been filed in Florida State Court contesting the election, filed on behalf of unidentified voters. It asks that all absentee ballots in Martin County be thrown out. If the judge approves and the state accepts the new total, Governor Bush's lead in Florida could disappear. The lawsuit accuses the GOP of tampering with hundreds of absentee ballot request forms. That lawsuit is actually similar to one in Seminole County. In that case, a Democratic activist charges illegal handling of absentee ballot request forms. Meantime, Bush lawyers asked Circuit Court Judge N. Sanders Sauls to send for another 1.25 million ballots from 3 counties. The judge has yet to consider that request. Al Gore's lawyers asked the Florida Supreme Court to order hand recounts start immediately. Bush's legal team counters with a motion to throw out Gore's contesting of the election. They argue the real election dispute is not between Bush and Gore, but between separate groups of state electors. And there are reports the Bush team plans to call 95 witnesses if the case goes to trial December 6th. The judge has scheduled hearings this afternoon and tomorrow morning on Gore's challenge to the certification of Florida election results. Meantime, it's the truck chase again. About 600,000 ballots from Miami-Dade County have arrived at the Circuit Courthouse in Tallahassee. More than 500,000 ballots from Palm Beach County arrived yesterday. Whichever way it goes, a Supreme Court ruling may not end Al Gore's election challenge. In an interview with the Associated Press, running mate Joe Lieberman said the Gore camp believes the final decision will come from the Florida Supreme Court, but Connecticut Senator acknowledged somehow or another the U.S. Supreme Court could have the last word. Meantime, the Gores and the Liebermans have been working on transition plans. Sources say the group wants to create a grassroots panel of community leaders to advise Gore on building his administration. Claiming victory, George W. Bush says, quote, one of these days he will actually prevail. In the meantime, the governor continues planning for a new Bush administration. The governor, his wife Laura, and his running mate Dick Cheney return to Austin this afternoon for a Christmas party. They'll go back to Crawford, Texas tomorrow. Bush plans to meet with House Speaker Dennis Hastert and Senate Majority Leader Trent Lott at his Texas ranch. It is not clear if Cheney will be at that meeting. The governor spent most of the past week on the ranch. Yesterday, meetings with retired General Colin Powell, who is, of course, expected to be offered the position of Secretary of State. Updates throughout the day. Now more coverage of today's U.S. Supreme Court hearing with Shepard Smith.
5 after 3 here in New York, and coming up on this special edition of Fox News, we'll go live to the Supreme Court, where our man Brian Wilson is standing by to give us a complete update on everything that happened. His brain is large, and he'll be dropping knowledge. In the meantime, you are looking live. Tallahassee, Florida, is it? Is that the land of the new? Yes, that is Tallahassee, Florida. The ballots have arrived, you may have heard, and they're unloading them now. 654,000 ballots to be unloaded just in case a recount of the hand count and recounted and counted ballots is necessary. Hang on.
Canadian distance swimming star Marilyn Bell and coach Gus Ryder on the way to challenge the English Channel starting from Cap Grinet, France. The 17-year-old Toronto lass made headlines in September 1954 when she swam the 32 miles of Lake Ontario from Youngstown, New York to Toronto. Here she is battling the English Channel with alternating pacemakers. Marilyn's parents ride along to root their daughter on, and the teenage titan needs it when the channel suddenly gets mighty rough. But the plucky girl fights it out and becomes the youngest girl ever to beat the English Channel. The cliffs of Dover are a welcome sight, and to Marilyn Bell, our heartiest congratulations.
Americans collect stamps as a hobby, and in the wake of the new rates, there will be 2 more for their albums to go with, if they're lucky, a block like this one from the $3 million Kaspari collection. Which reminds us that while Washington races to send rockets to the moon, it still handles mail as it did a century ago, when it cost as much as a pound of coffee to send a letter from Philadelphia to Boston. When the West was wild, stagecoaches charged 2 bits to take a letter to California. By Pony Express, it was $5. Now, Postmaster General Summerfield promises added revenue will enable him to install transformers in all our big post offices. They're 5 times faster and more accurate than clerks. At last, the post office catches up with today, artistically too, as this most dramatic new air mailer proves. But in our history, there are hallowed memories, and with this new Lincoln, we salute one of these.
Well, most of the legal sparring has been in Florida, but today the action moving to the highest court in the land. Fox News correspondent Brian Wilson live at the Supreme Court with the latest. Hello, Brian.
Hello, Shepard. Just a moment ago, I want to pass on a conversation I had with Senator Patrick Leahy, who's the ranking member of the Senate Judiciary Committee, and he was inside the courtroom. He walked over together with Orrin Hatch, who is the chairman of that committee, together to kind of make a point. He said that perhaps, you know, there are some people who believe they can work together in this town and in politics. He said the interesting thing about the hearings from his perspective is that there wasn't a lot of reference to precedent. And, you know, in the law, you always look at the precedent. And he said in this particular case, there was not much reference to precedent because there's never been a case like this. Point well taken. It is George W. Bush versus the Palm Beach County Canvassing Board, a case we'll be talking about and the lawyers will be looking over for years and years.